Yes.
Chief, leave to move a very urgent motion tomorrow. Here what happened was in hospital. On 28th of July, the officers of the Family Welfare Department comes and issues a suspension of service notice. Because there is no concept of suspension of service notice. There can be a suspension of my license, termination of my license. The result was all the patients had to be released within half an hour, including patients in ICU and HDU. There is no concept of any suspension, no inspection done, no inspection to nothing. No so-called no opportunity. But kindly not permitted to come back upon service tomorrow.
Serve the notice tomorrow within 10 minutes.
Mentioning
Urgent matter, give all the urgent matter notice.
The passport hold passport is going to expire, or even within kindly I have mentioned this matter previously. I have filed in July, first week of July. It is relating to a passport which has been kept on hold because my renewal will be cancelled on first. Kindly fix up any.
You are enjoying the holiday. You are enjoying your bar resolution. Court was sitting on Saturday. Court has taken 200 SIR matter. Court has disposed of 150 SIR matter. You on that day you have no urgency. When other matter is on list, you are having urgency. You had the knowledge, the bar had the knowledge, the court will sit on 1st of, that is a Saturday. All the SIR matters mentioned before this court, even on Saturday, what the mention and matter is mentioned, I have taken a supplementary list of 115 matters. All urgent matter has been taken. Now you're telling the urgency. Either you take the benefit of bar resolution or you take the benefit of Saturday, Sunday, then you mention on the regular court. And I am taking every day, every Friday the SIR matters. Why you are mentioning? Give it all the matters are coming on the list.
My lord,
yes, sir.
my lord, keep in hold, my lord. Please.
If you mention the urgency in the urgency mentioning list, all matter will be listed. If this court is satisfied with if this court satisfied with regard to the urgency mentioned in the mentioning list, naturally it will be listed.
Sir, my lord, sir, I am the principal of the college. The college is fixed, sir. This renewal will stop from the government of India. Just today, sir. You have fixed the date on 16th of July, but it is in 107. Sir, college will be deaffiliated, sir, from New Delhi National Commission, sir. Sir, please take it urgent, sir, matter, sir. The college permission will be lost. College, this is the order. It is fixed on 16, but till now.
I mentioned that. Hey, क्यों नहीं है सैटरडे लीव? Tomorrow. You mentioned the non. Let it come.
My lord.
Application tomorrow.
My lord, a writ petition has been filed.
Yes, ma'am. Please maintain seniority. Yes, Mr. Vasu.
Sorry.
एक काम करो उसको ना
मैटर my lord.
6 तारीख yes what can be done.
I have participant for that. I have
আমি দিলাম কিন্তু একজনের হাতে
So what is the urgency in that?
I am now out of town. If you produce the
have you mentioned the urgency? Give.
Non,
Give it. It's in the list today. Which number?
Actually, this is a matter for
339. What is the name? Record an order.
Lordship.
339. Though the matter is listed in the monthly list as serial number 339, but the land council for the petition has mentioned the matter and submit that he has instruction to. What you release? Why?
I want to leave
He submits that. Huh? Why?
another family. So many time, my lord, I have been.
Then no, sorry.
Lordship, that is
And chanting.
Lordship, this is a because I am
Give the mentioning. Give the mentioning list and you will see to that. Yes,
we mentioned this matter on Saturday. The exponent amount which TDC was paying, which was illegal and arbitrary. My lord, I mentioned this matter. My lord asked me to go through the monthly list, but monthly list had no.
give the list.
May I have
The mentioning.
an urgent matter and
Yes, call the list. Call the list.
My lord, may I be permitted to mention, my lord, this is the fourth time. My lord.
May I be permitted to mention a matter?
My lord, this is an SIR matter, my lord.
Who is number one?
My lord, kindly, mentioning my lord, SIR matter, my lord. There is a NEET examination. My lord, counseling will be held next week, my lord.
The petitioner.
My lord,
What?
my lord, NEET counseling will be held in next week, my lord.
My lord, this is a
My lord,
kidney
my-
transplantation matter, my lord. I could not make.
My lord,
Yes.
May I be permitted to mention item number 727 of the monthly list?
Yes. Ah.
The number was for Namta ball. Just give me a minute. But I was late to submit the BG physically. But can I take the timber documents? You must be get at 35.
Yes.
It's 35. Kindly see the that minus the description item is 35. Rate contract of damage, defective distribution transformers, different type and capacity. Is the time limit at the bottom of the page. Publishing date 8 June, document download 8 June, date of pre-bid 15 June, date of submission start date 7th June. Can we come to the next page? July.
Last date of physical MD 9 June.
Can be also submitted. What I have done, I have submitted the scanned copy. The physical copy I couldn't upload. So, I'll just show you let's see the rejection first. Can you take
So when you submitted the physical submission of the EMD,
but
BG?
BG? I'll just show you let's see the BG. Now kindly take. Page.
Yes. Yes.
Kindly see.
Yes. BGPDF, EMD.
So uploaded on 4th July. Because the
Plus 84, you have given
the BGF
online you uploaded on 4th of
July.
4th July.
Fine.
Yes. So you have prepared the BG on 1st
July.
Yes. Hundred and
The starts.
yes.
Results.
112.
See the after
Yes.
ground.
Yes.
That is sit invitation. That please consider my bid. Because 13th day after invitation. Lord, I am already enlisted. I am an enlisted contractor. I am doing the job.
Yes.
Lord.
Yes.
Subject sorry, 98.
Yes.
At the root situation. Contract subject to the compliance of something. This is valid. August.
Yes.
First paragraph.
Yes.
Then this was extended.
Yes.
So existing contract, but these contracts are like this. Factor. Maximum transfer. Job subject to correction by my learned senior friend. So on that we will do our jobs because one person cannot complete. They say according to the bank money. I had the bank. But that woman they should not penalize me. When he sees the rejection, physical copy.
Yes.
Well, I only
What is the meaning of fixing a date for filing this physical copy?
see, bank guarantee. Kindly have a look at for 2 plus 7
Yes.
submission of documents. I can
Page 48.
48.
Submission of original copy of the document, earnest money deposit. The original copy of BG earnest money.
The
Correct. But that is correct, Mr. Chakravarti.
and
But when the bid was going to be accepted, but your
the document July, they will kindly take it once.
find the shortage of the.
Kindly take 6 once.
Yes, you're sick.
There is the doctor. Kindly appreciate one thing. Why would the stop and submit this request for your kind consideration regarding the submission. Allow
Yes.
No, I'm sorry.
Continue.
No. Original copy.
What is your stand?
Mullet, the point which my learned friend has shown, my lord, kindly comes to my lord, once again, my lord, page 48.
Page 48.
Clause 7.4, my lord, 2, Roman 2, my lord,
Time
time
of
of submission, my lord.
Yes.
That is why, my lord, time has been framed, my lord.
But I made it.
Copies of PG towards CMD shall be submitted in a sealed envelope in the office as stated above within the date and time as
Yes,
specified
39.
in the NIC. If the bidder fails to submit the original copies within due date and time, his tender will not be opened and his bid will stand rejected now. Malad, he could have, Malad, submit the, Malad, the original copies of the same, Malad, even through his authorized representative, Malad. But what prevented him from submitting the same when a specific date has been framed, Malad, for submission of the original bank guarantees, Malad.
Where is the bank guarantee?
The bank guarantee is at page 81. It was made on 1st of July. And the bank had addressed to the chief engineer. That I could to Mr. Basu has said if I did not have the bank guarantee. It is one day, I mistaken one day, 1st July.
Whether this letter
Yes.
even
Yes.
to the chief engineer that was received by the office of the.
Well, we have uploaded this on the document.
This one.
Yes. Was 13, I'm grateful to my learned friend here. Page 39, clause 11. In the interest, they cannot take any stand, Lord.
Page 39.
Page 39, clause 11. WCCL considers financial interest, the provisions relating to holiday listing shall be governed by visa purchase. So they can take any appropriate decision considering financial interest. But I am working with extended my argument number. So I will be yes. I am realistically telling the contractor. But for this is too much of hardship punishment, not I will suffer only this, not I can understand, I'm not, I can understand, but also not, they cannot also be faulted directly, not, but the thing that I have also
Malad, again, kindly comes to Malad, page 40, Malad.
is that
Clause 20, Malad. Page 40.
Yes.
All tenderers are ensured that all prerequisites as mentioned above are duly fulfilled and submitted by them And if there is any deficiency regarding non-submission of any document, matlab, the non-submission of physical copy, matlab, that is also matlab, within the meaning of this non-submission of any documents. WBSCD shall reserve the right to cancel the tender unilaterally, matlab.
Yes.
And my lord, when did he make the representation, my lord? Kindly comes to, my lord, page 87, my lord. His submission is that, my lord, he went there on 10th.
Yes.
9th was the date. He could not attend because of his sudden illness, my lord. He went on 10th. But on 10th, he did not make any representation, my lord. Again, he went to 13th, my lord, only for making the representation, my lord.
Lord,
My lord, kindly see
Lord,
the
184,
petitioner, my lord.
184 tender should be
Government, which the
one.
government. Anybody?
180 tenderers would be enlisted. Only a person who had made the BG could not go physically.
Page 8, my lord. See the amendments, my lord. Paragraph 9, my lord. Your petitioner further states that when the petitioner failed to physically submit the BG before the concerned respondent due to severe illness, stating such act caused out of unwilling and unavoidable situations, the petitioner on the very next day, that is 10/7/2026, approached the respondent number 3 and made an application inter alia requesting and praying for allowing him for late submission of the original bank guarantee before the concerned authority. But on such date, such application was not accepted by the concerned authority, and the petitioner was further verbally informed, my lord. But on that day, my lord, he did not make any application, my lord. Verbally informed to come to the office, the concerned respondent on 13th,
Yes.
as 11th and 12th July were second Saturday and Sunday.
If the
Subsequently,
government
my lord, yes,
but
allegation, my lord, against the
But it is-
respondent authority.
it is not that
Willing
the
to act with the respondent authority, but in the petition, my lord, if your lordship kindly again comes to
so
my
there is no allegation, it is a
lord,
allegation.
he went there on 9th, he went there on 10th. On that day, he did not make any representation, my lord. Again, he went there on 13th, and thereafter on 27th, my lord. He made series of representation, my lord. My lord, this is for the transparency, my lord. These are the criteria, my lord, which the respondent, my lord, has duly formulated, my lord. If there is, my lord, any relaxation, my lord, that floodgate will open, my lord, and my lord, anyone may come and, my lord, seek for the extension of time, my lord.
Yes.
Lord, I could have understood this if this was a EP contract. I could have understood this financial between.
Correct. But
But it is for only performance was bad.
Come bank guarantee, my lord. See, my lord, it means, my lord, earnest money, come bank.
No. Form of bank guarantee, not come bank guarantee. Page 40 is bank guarantee.
MD is not a there's no MD.
Lord,
My lord, EMD
EMD is there.
instructed, my lord, EMD means, my lord, earnest money, come bank guarantee, my lord.
So there's no further EMD other than the bank guarantee.
No, my lord. There was an EMD, my lord, earnest money that was deposited, my lord, 3.5 lakhs, my lord.
Correct. EMD is 5 lakhs.
No, my lord, EMD. There was a previous meeting, my lord.
Ah.
My lord, there was a previous meeting, my lord.
Ah.
Kindly comes to, my lord. Annexure
EMD comes security deposit amounting
My
to
lord.
rupees 5 lakhs.
Lord,
that's modified, my lord. That
Lord, there are
was
three kinds of.
amended, my lord, in the pre-bid meeting, my lord. Kindly comes to, my lord. Annexure P2, my lord.
Lord,
I'm showing, my lord.
page 7, clause 1, I have 60 kVA. It is 3.5 lakhs. And 5 lakhs for 630 kVA.
78.
Page 78. Only 78, serial 1,
Ah.
up to 160 kVA oil type transformer. I am on oil type transformer for the 3.5 lakhs. 5 lakhs is for 630 kVA oil transformer. Serial number 3 analysis.
My lord. Kindly comes to, my lord, page 78 to 80, my lord. That is the pre-bid meeting, my lord.
Correct.
That is
So-
3.5, my lord.
So 3.5
5 lakhs.
EMD has not deposited.
EMD, my lord, EMD deposited, but the bank guarantee, my lord,
No,
that was
I am
not
telling not, that's why I am telling EMD is deposit.
EMD deposited. my
EMD deposit.
lord.
Yes, Mr. Chakravarti,
We are
what can,
trying to take page 37 once only.
yes,
Page 37,
there are,
bottom,
yes,
37 bottom, submission and guarantee.
correct.
So, here is- I was- I can, I can, hard option, I have
But the problem is that, see, they have prescribed the date, correct?
Right.
And as per the date, you have to submit all the
no, I
documents.
was physically not,
If it is not submitted, the original
but the video was made. It was available.
BG you might be made, you might have, unless and until it is not submitted to the authority, you can revoke at any point
That
of
is why
time.
48,
But-
page
but
48,
my understanding is absolutely valid.
7.
অনেক তো বলেছো। আর কি
So
এটা?
that's why the original, unless and until the authority
Baba.
does not see the original,
Not,
how the authority can
not the
allow
co-
you to,
not the concept I understood, Milord. Concept is that I will make the BG, upload it, probably it would not be there. This one. It's
what can be done?
Not,
It's the condition.
lots of, and
What my Latterford is submitting, my lord, he is not a L1 contractor, my lord. For the first time, he was a new entrant, my lord. And my lord, since that was L1, my lord, those who are the experienced, my lord, and those who have a credential in the tender process, my lord. But he was the new entrant, my lord. His price was matched, my lord, but his claim was that he was L1 entrant. But he was not
who
L1.
is claiming that? Where have I
In the
claimed that?
petition, in the petition itself, my lord.
But I don't so. I I had another certificate.
Can extend if the authority can consider,
But they
consider.
can
how-
consider it. Look, instead of being so vigilant of this
What can allow
unbased,
condition how the
I
court
can understand. Look, it is difficult for the court to extend, but they cannot consider it. But I'm just
Accident, my lord. You can
Petitioner has filed the present date application challenging the order dated 13th of July 2025, wherein the bid of the petitioner was rejected due to non-submission of physical bank guarantee within bracket BG within the time specified in the NIT. The respondent authorities have published a tender notice. Tender notice. What is the date of the tender notice?
I'm sorry.
Tender notice.
Tender notice dated not 8 June 2026.
8 June 2026 for rate contract for repairing of damaged defective distribution transformers of different types and capacities. As per the tender notice, the bidders have to submit their bid on or before 8th of July 2026 at 14:30 hours, and the last date of physical submission of EMD within bracket for BG only is 9th of July 2026 at 1600 hours. The counsel for the petitioner submit that the petitioner has prepared the bank guarantee on 1st of July 2026 for an amount of rupees 3,50,000 with the Bank of India, which is valid up to rupees 12th of July 2031 in the name of the chief engineer within bracket P&C Procurement and Contracts Department, West Bengal State Electricity Distribution Company. Full stop. Full stop. The petitioner has submitted the bid the copy of the bank guarantee through online on 4th of July 2026. But all of a sudden the petitioner fallen ill and could not.
Please consider my case so that if they change their mind only for that, not
Okay.
otherwise I'll be jobless completely for 5 years for that.
4th of July
If they could do that.
2026.
Recording my love may direct them.
Them all of a sudden the petitioner fallen ill and could not submit the physical copy of original bank guarantee in physical form to the respondent authorities on 9th of July 2026. Immediately on 10th of July 2026, the petitioner had been to the office of the respondent authorities with the request for acceptance of the bank physical original copy of the bank guarantee in physical form, but the authorities have not accepted the same. Accordingly, 11th and 12th was the Saturday and Sunday, and 13th of July 2026, the petitioner has made a representation with the request to the authority for acceptance of the physical bit, as the petitioner could not file the physical, submit the original copy of the bank guarantee, physical bank guarantee due to his illness. Though the petitioner has prepared the bank guarantee on 1st of July 2026, and the copy of the bank guarantee was also disclosed in the tender document on 4th of July 2020. Counsel for the petitioner submit that in spite of the request made by the petitioner, the respondent authorities have not considered the case. Accordingly, he filed the present application directing the respondent to consider to accept the bank guarantee and to allow and accept the bank guarantee of the petitioner and to accept the bid of the petitioner. Per contra, an advocate appearing for the respondent authorities submit that in the tender document clause 7.0 within bracket II, it is categorically mentioned that the original copies of the bank guarantee towards CMD shall be submitted in a sealed envelope in the office state of law within the date and time as specified in the NIT. If the bidder fails to submit the original copies within the due date and time, his tender will not be open and bid will be stand rejected. He further submits that. He further he further brought to the notice of this clause to this court with regards to clause subclause 20 of clause 60, wherein of 60 of the NIT document, wherein it is also mentioned that all the tenders are ensured that all prerequisites mentioned above are duly fulfilled and submitted by them, and if there is any deficiency regarding non-submission of any document, WBSCDCL reserves the right to cancel the tender unilaterally. He submitted it in the tender document. It has been the last date of submission of the physical bid was 9th of July 2026 at 1600 hours, but admittedly the petitioner has not submitted the bank guarantee by 7th of July 2026 at 1600 hours. Accordingly, the respondent authorities have rightly rejected the bid of the petitioner. But the land council for the respective parties permit the bid of the petitioner has been rejected only on the ground that non-submission of physical bank guarantee. The petitioner has disclosed the document to show that the petitioner has prepared the bank guarantee on 1st of July 2026, and copy of the same was submitted along with the bid document through online on 4th of July 2026. The petitioner could not file the original copy of the bank guarantee in physical form on 9th of July 2026 on or before 1600 hours as per the bid condition, as the petitioner was suffering from. So he was suffering from fever and he was under medical treatment. This full stop. In the bid document, in clause 7.7.0 within bracket II, the time of submission is mentioned as follows. The original copies of the BG towards EMD shall be submitted in a seal cover in the office at the start as the stated above within the date time as specified the date. If the bidder fail to submit the original copies within the due date and the time, his tender will not be open and his bid will be stand rejected. Clause 2, subclause 20 of the bid documents provides that all the tenders shall ensure that all prerequisites as mentioned above are fully fulfilled and submitted by them, and if there be any deficiency regarding non-submission of any documents, WPSCD shall reserve the right to cancel the tender immediately. The learned counsel for the petitioner has harping upon that it is upon the respondent authority to consider the case of the petitioner because the petitioner has prepared the bank guarantee on 1st of July 2026 and has submitted the copy of the same through on website at the time of submission of the bid through online, but only the physical copy could not be submitted. This court find that it is a specific condition in the bid that the petitioner has to submit the original copy of the bank guarantee in physical form to the authorities by 9th of July 2026 by 1600 hours. Admittedly, the petitioner has not submitted the same by the said date. Considering the above, the court did not find any illegality in the order passed by the respondent by rejecting the tender of the bid of the petitioner. But however, the rejection of the writ petitioner will not prevent the respondent authority for consideration of the request made by the petitioner on 27/7 on 13th on 13th July 2026 with regard to the acceptance of BG which was prepared on 1st of July.
Well, at least something in the first matter of the day.
Disposed.
This is like first matter of the respondent, for the respondent today.
Okay, thank you.
Congratulations.
Yes, and I'm for the statement.
I'm for the response.
And I'm for the petitioner.
Yes.
Filing affidavit reply, my lord.
No.
These are opposition.
The instruction.
Have you received the opposition? File reply?
My lord.
Instruction.
Yes, what is the matter?
Okay, the opposition.
Lordship, the matter is for-
Serve no. Not every opposition copy will not serve to state.
State is not.
All right, man. I'm giving my stand is very much clear. Early occasion, man. I have submitted the written instruction.
Your Lordship, a report was submitted by them on the last occasion stating that the pre-election has anomalies in it, and subsequently, the election was held in Your Lordship. If Your Lordship,
What is your prayer?
Your Lordship, the prayer is for setting aside the election.
Setting aside election. Which election?
Your Lordship may turn to page 60 of the petition. Your Lordship, there was an order by Justice Sinha stating that page 62, Your Lordship, and after paragraph number 9, Your Lordship, stating that if the competent authority comes to a conclusion that the process of election has not been conducted properly, then the necessary remedial measures shall be taken by the authority, including setting aside
Yes.
the entire election.
Yes.
Your Lordship, then subsequent to that, Your Lordship, an order was passed on 25th of August 2025, Your Lordship. That is page number 109. That
Yes.
states
Yes.
that, Your Lordship, the
Yes, Mr. Basu. Yes, you are appearing.
Yes, Your Honor. Milord, first of all, Milord, the Justice Senior Order, Milord, coordinating bench directed, Milord, the authority concerned to take the election and everything. Now, Milord, the authority come to a finding that there are certain, Milord, pre-election, Milord, irregularities. That is, Milord, the election was not constituted. This is subsequently, this reason has been given, Milord. But at the outset, Milord, when the consideration was made, this order has two components. One, Milord, pre-election that the election is not bad. Number one. My learned esteemed friend Milord had submitted earlier occasion that Milord, this election is bad because Milord, the authority said that the election committee was constituted without any resolution or decision being taken. Was not issued in accordance with the law. These are the two grounds. Subsequently, during the course of that section 8 of the bylaws, Milord, it delineates, Milord, how, Milord, but it does not say, Milord, how the notice is to be served. In the instant case, Milord, the petitioner has admitted it was served through electronic mode. It is not. Notice. Question is whether, Milord, section 8 says, Milord, election of the managers of the board, Milord, if your lordship kindly takes pen, Milord, bylaws, Milord, constitution of a board and managers and its functions. Within 15 days of formation of an association under clause 2 of bylaw 3, Milord, I voted in. I'm sorry, Milord.
Huh? You are having?
Yes.
Yes, section.
Section, this is 8. Constitution election of the board. 15 days of formation of an association under clause 2 of bylaw 3. The apartment deciding.
We are referring rule, bylaws.
Yes, bylaws. I'm sorry, Milord. Right. Yes, bylaws 24, clause 8. I'm sorry, Milord. Milord, got it? বইটা দেন বইটা আছে আছে হ্যাঁ এটা দিয়ে দিন এটা বার করে দিন বইটা বার করে দিন
Constitution of
Yes, yes. Number finally comes bylaws 3. The service of notice referred to in clause 1 shall be effected by personal service or through letter mode.
Yes.
I insist on Milord. I seek my kind attention to 8.3. How Milord is to be served. Milord got it? It has to be served. There are 3 modes.
There shall be office bearer, census, looking such authorities and permanent.
My
Constitution of office bearers of the and their functions.
The service of notice in clause 1 shall be effected by personal service through letter sent by registered post or through email or any other electronic mode. But at the my lord got it.
Which you are referring to?
It is just sent within 8.3. 8.3.
2022.
At the left hand side, Milord, 8.3, Roman 3.
2022 नहीं तो पुराना position.
My lord got it.
26. That is old book. Yes, 8.3.
8.3.
Service of the notice
Yes.
referred in clause shall be affected by personal service or through letters sent to the registered post or through email. Yes.
If that is done, then the election is constituted such and such.
Yes.
The requirement of the has not been elucidated and narrated, and the same cannot be supported to affidavit, and why this is required. Now, the question is that suppose we are equal to the order passed by Justice Sinha, kindly comes to 109.
Yes.
এটাই তো যেটা yes
Yes, and
yes
15.
yes. According to certain suspension stroke removal such and such from the office of the such and such was not done following the norms. Some flaws in the pre-election process. Some flaws in the pre-election process. Ostracizing the suspension which was stand the prejudice. Had this person not been suspended, beloved, he was entitled in the election process. Now, this has to be adjudged in the context of a law. Now, kindly take explain to Akshu's book.
No, but if the authorities come to the conclusion suspension and removal of so and so is not in accordance with law, correct? Was not done in accordance with law. If it is not done in accordance,
Right.
that's why the suspension was illegal.
Absolutely, and I did not challenge this.
Yes, if the
I accept it.
suspension was illegal at the time on the date of election, so if would not have been suspended, so he will get an opportunity.
Yes,
to
yes, Millard,
participate in
Millard, I am extremely grateful that the answer lies in Rule 11. That is why the concept of Millard stand the prejudice. Had I not been suspended, which was held to be illegal, then what was my right? My right to elect and my right to be elected. Both are components. Now, what is the answer? Admittedly, Millard, this gentleman is a defaulter, and what is the consequence of law? Kindly seize Millard the Rule 11 and then Millard Rule 11 and then come to page 25 of my opposition. Kindly comes to Millard Rule 11. Any other landowner pays to pay in any financial year,
Yes.
any installment of his contribution towards the common expenses which may have been assessed by the concerned association shall not be entitled to vote. So my right to elect and Millard to seek election for the office of the managers of the board concerned, his arrangement areas are cleared. Page 25 of my opposition.
You are for respondent 3 and 4.
Yeah, page 25 of the opposition.
Respondent number?
Respondent number 3 and 4, 3 to 5. Election held in May 25. This is the statement of accounts not controverted. Page 25 of my opposition. I'm sorry, Millard. Page 25 of my opposition.
Yes.
Now, Millard, this is the Millard document which depicts, Millard, that this amount due and payable 1st April 2024 to 10 July 2025. This narrates, Millard, thereafter, Millard, it was increased.
Yes.
Now, Millard, this is the due.
Yes.
Now, Millard, the question is that law says, Millard, so I must tell your Lordship, Millard, at the outset that, Millard, there are the total number of vacancies as that were fallen during the time of election 48. We could fill it up to the extent 31 were filled up. Now, question one is there was election. So this sentiment was asked, my lord, had there been no situation like this, and we could not be nonchalant in such a situation, my lord, and that is our strength, which I give from, my lord, interpretation of Rule 11, my lord, which I have just placed now. Now the question here is, my lord, that it is a court of equity. A man, my lord, must tell all the facts and he must come with clean hands. Now, my lord, Rule 11, whether it is a statutory surpluses all other questions. Now, my lord, whether I am correct in submitting or whether it is a correct understanding I am before a constitutional court, my lord, your lordship knows, my lord, we have taught the concept of election injunction comes from specifically verse 37 to 42. The concept of election, my lord, first placed from the Constitution, then my lord, the Representative Act. The term election has not been defined. Now, the right elect, subject to the qualification, subjects. Right stand in election contest, that is also a question, but it relates to the concept of qualification and disqualification. Number one, that is the law, my lord, then in everything in law is with reference to context. Now, why this gentleman is not qualified? Now, my lord, the answer, if I say, my lord, that the term election has not been defined, but on this code, my lord, I place my reliance on this. Your lordship may kindly have the charity to consider paragraph 15.
15?
Of 19, 20. Thank you. 15, 16. My lord, this was at the outset, my lord, I say, my lord, whether I am correct in submitting this code of the state, that if the statute does not define the term, my lord, I can take recourse so far as the definition is concerned.
Okay, that is correct. No, only the thing is that before the earlier round of litigation, this is not the question with regard to the dues pending against the petitioner. It was not the question before this court on the earlier round of litigation or before the authority was decided. Correct. Only this court has passed an order directing the authority to consider, and if found it is illegally has been done, then the election can be set aside. So the authority has considered the matter and found that suspension is illegal. If the suspension was illegal, so he could not get an opportunity. Now, what you are raising the question, he can't participate in the election due to the pending dues against the association. If it is so, but that is not the question either before this court on the earlier or not. This is the question before the authority.
I'm grateful, my lord. Very pertinent question, my lord.
Now, at this stage, the court can say, yes, that was not the question and you can continue because
certainly not, my lord, but subject to correction, my lord. Justice Sinner's order, my lord. What does it say, my lord? Justice Sinner's order, 62. My lord, also 61, for the association against the objection of the petitioner. 61. It is not, the court was not confronted with the question, and court still not without being unconscious of the fact. Court was apprised of considering the submission court directed the entire issue should be there. Kind attention to paragraph 4, 61 of your lordship's bill.
Yes.
Start, my lord. Learned counsel for the association denies the allegation of the petitioner. Submits that the petitioner must submit his nomination for contesting the election. Hence, the court further submitted that now I stop here. Such and such. The process of election was also measures. That means, my lord, the entire scheme. First of all, the parties raised a dispute, questions, my lord, that was raised. Court was not inclined to decide the question, but court had recorded the submission and directed, my lord, the remedial measures. So, my lord, there are two aspects. If his suspension is illegal, then remedy ought to have been granted, the remedy granted in terms of law. I said the second stage, my lord, there is an impediment. Your suspension is illegal. But if that is illegal, then, my lord, what is the relationship or friendship or enmity? My lord? Concept of right and remedy. The right separated because of the, my lord, the legal position that Rule 11 stares at our face. What is the right and what is the remedy?
Because if you read the
Kind-
paragraph 8,
Again, my lord, paragraph 4.
paragraph 8, you read the
Yes, I want to. Such and such. Counterpart. Such and such. The allegation that the election process was suspicion. So what said is in the comes to that process of election has not been conducted properly. Authority said that the election process is free and fair. Authority said suspicion. Components. The logical structure of the court, my lord, if your lordship kindly takes this sentence separately and tries to reconcile all this entire sentence, then my lord, first part, you decide whether the election is free and fair. The authority said it is free and fair, but the suspension is illegal. Then my lord, the third, he said that he has the right not to be suspended. Correct? Then what is the consequence of such right, my lord? What is the dual relationship between the power, duty, privilege, and immunity? If, my lord, the question is, my lord, that your suspension, the right flows from a statute. After constitution statutes, my lord, the insurmountable difficulty when the court is conscious of the fact that the remedial measures, that means right not to be suspended, cannot be by default say that you are right to elect and right to be elected. So, my lord, that is my understanding.
Thank you. Yes, Mr. Yes.
And sorry, my lord, only one. No, my lord, my junior was my lord, exuberant. He said, say more that what is the amount. I said, no, the principle of law, my lord, because it is a court of law.
Yes.
Lordship, I may come back tomorrow with
Why?
reply properly.
My lord, she should be given an opportunity. Junior member of the bar, my lord, kindly encourage her.
This court always encourages
Yes.
you.
And that is why, my lord, that is why, my lord, we are always grateful to your lordship. Because, my lord, if a junior member of the bar, before any judge, my lord, feels free to make an argument, this is a caliber of a judge. Because sobriety, thy name is judge.
See, come ready. Kindly come to the page 61.
Lordship,
Page 61, order of this court. Correct. Page 61, last line. The allegation that the election process has not been legally followed. This is one that is in your favor followed. Then and the issue of suspension of the petition shall be decided by the authority. These are two. Correct. So the issue of suspension decided in your favor. And with regard to the election process not legally followed, it is against you. Then the court has to, then the necessary remedial measure is to be taken. So if the election process, okay, your suspension is not, but you are having the dues pending, what would be effect of it? Correct?
But tomorrow I will be absent from the court for the past half. So, my lord, if your lordship finds that, my lord,
What time you will be available?
in the second half,
First 1 p.m. 1 p.m.
1:30 minute, 2 p.m. is possible.
2 p.m. my matter is fixed.
Oh, then, my lord,
Then Wednesday? Learned counsel for the respondents has concluded their argument. Learned counsel for the petition prays for time to give reply. Give reply. According cases adjourned. Let the matter appear on 5th August.
I'm extremely grateful, my lord.
Thank you.
I'm grateful.
बुक रहने दो उसी में बात करो उसी में बांध दो बुक उसी में बांध दो यस नेक्स्ट
Item 3 I appeal. But here, I'm in custody for more than 21 years. And on the last day,
Lord, your lordship has,
News for the state.
expressed my
Yes.
mind.
So every day is appearing, but where is the report?
This is the second day.
I'm sorry, Milords, in this matter, there appears to be some conflict.
What?
Mr. Majumdar was appearing for one of the parties earlier. So I've just been informed there appears to be some conflict. We'll request somebody else to engage in this matter. Milords may have it on some other day.
That's correct. You have to bring the report, instruction.
Yes, that is the only thing, my lord, your lordship has requested.
The department has prepared the report. It is with learned. It was handed over to the learned additional Advocate General. However, as he had appeared for one of the parties earlier, so today he is not present. Let it appear tomorrow. My learned friend will take
Or you will be ready?
tomorrow. She will hand it over to the court.
Not today. Not today. Next.
Madam, for the petition.
Not aware the report SHA.
My lord, this matter relates to non-payment of interest on delayed payment, my lord.
Non-payment of interest on delayed payment.
Your Lordship,
Yes.
the Ministry of Finance for Government of West Bengal has not been a party who will be disbursing the amount. Let that be added as a
Which
party.
department it is?
My lord, it is election of Commission of India and Police Department has been made a party for providing the matter. It was main.
What was the work awarded to you?
My lord, work order was relating to providing accommodation and other assistance to CAPF officers in the ongoing in the by-elections of 2015. That I duly received the work order and I duly completed the work order. Thereafter, I submitted a bill of around 46 lakhs, out of which more than 9 lakhs was paid, and the rest part payment was not paid. Pursuant to which the petitioner approached the Honorable Court in an earlier writ petition, my lord, wherein your lordship directed to consider the case of the petitioner, and if payment is due, then the same shall be disbursed. Accordingly, the same was already disbursed. But the main due amount was only discharged, but the delayed payment for the 10 years, that was not released. For payment of the delayed payment, my lord, this application has been made. Writ petition has been. That was not considered and that no assessment was even been made.
So who will assess this? Who has released this payment?
My lord, the ASP.
SP.
ASP forwarded it to the petition.
Yes, forwarded. Who has sanctioned the amount?
My lord, ASP.
SP. Yes, madam. You are appearing.
I'm appearing for Election Commission of India.
Yes.
There is the amount will be disbursed from the finance department. SP instructed me that the petitioner made the finance department has not been made a party yet.
Which finance department?
Department of Finance, my lord. Government of West Bengal, my lord.
Government of West Bengal Finance.
Yes, my lord.
Unless and until you raise the bill to the department, if department had deducted the interest, the finance department might be a party.
Yes, my
Here, who has issued the work order? SP has issued the work order.
SP.
He has executed the work order. This court has passed an order for release. SP has passed an order for SP had directly not sanctioned the order. SP might have been. The bill was sent to the finance section and the finance section had released. Unless and until it is not your case, the SP has raised the bill along with the interest, but the finance department has not sanctioned.
Yes, ma'am. Then I shall.
And you have to take instruction whether the petition is entitled.
Yes, my lord.
How
then
the
I shall
finance
inform
department
the-
will come in
Yes, my lord.
picture?
Then I shall inform
It is your
the SP.
internal correspondence.
Yes, my lord.
Correct.
Yes, my
So
lord. I shall inform the SP, my lord, to raise the bill, my lord.
today,
With regard to the interest.
With regard to this.
when
My lord, 2 weeks, my lord.
the petitioner has filed the present writ application praying for release of the interest as the respondents have released the principal amount, but interest part has not been provided. And counsel for the respondents press for time to take instruction. According case is adjourned. Let the matter appear on 18th August.
18th August.
My lord, one request, item number 112 and 113 are similar matters. Can those
Your
matters
Lordship.
be
Same party?
same party matter?
Why is it
112?
different petitioner, but respondents are different?
112 and 113 भी कर ही देना है
112
112 and 113.
and 100.
It had appeared on Saturday as well, Your Lordship.
My lord, may I be permitted to file the affidavit of service of
Not on
Madam.
come on ठीक है एक ही ऑर्डर करो तीनों का लगा
Should I be
Your Lordship, let the finance department be implemented.
Yes, my lord.
It will expedite the entire.
अलग अलग करो सेम ऑर्डर करो
my lord, may I be permitted to add implement
একটা কাজ করুন the
finance
petitions given liberty to add the finance department of the government of West Bengal as party respondent in course of the day and to serve notice upon the finance added respondent and to file affidavit of service on the next date fix. Yes,
grateful, man.
today itself you do that.
My lord.
Next.
15th August, no?
All.
Your Lordship, it may be recorded that all are tagged together.
Yes, it will come.
Item number 5, I am appearing for the petition.
All matters be tagged together. Huh? All three matters be tagged together.
So,
Yes, who is the 4?
my lord, item number 5, I am appearing for the petition.
5.
My lord.
I am
Yes.
appearing for the respondent number 1.
My lord, the petitioner herein is aggrieved by the fact that his bank accounts have been frozen by the banking authorities arbitrarily without any formal order of the
Bank, which bank?
My lord, there are 3 banks. One is HDFC Bank,
DFC Bank,
one is
Baroda.
Bank of Baroda, and one is State Bank of India.
Who is appearing for the ITFC?
My lord, I am appearing.
My lord, I have already served.
Who is for the Baroda?
My lord, this is my affidavit of
To whom
service.
you are appearing?
Respondent number 1, Union of India.
Respondent number 1?
My lord, respondent number 1 is the Ministry of Home Affairs.
That is Union of India. You are appearing for the 2. Reserve Bank. 3 and 4?
My lord, I have served.
4, 5.
My lord, I have served.
You are not appearing for the 6. Ombudsman?
Ombudsman.
No, I have received only instruction to appear.
Ombudsman also same, Reserve Bank of India. What is the disputed amount?
My lord, the disputed amount is only rupees 3,000. My lord, I have made a
In all 3 banks?
No, my lord, if initially my Bank of Baroda account, which is my salary account, that has been frozen. And subsequently, because that account has been frozen, my other 2 accounts have also been frozen. My lord, I had made a representation that let that an lien be
But
put
the
on.
bank is not here, sir. How it can be? Delivered on 4th July. 3rd July. 3rd July. 6th July. How you can say the disputed amount is 3,000? Why? Where is the document?
My lord, I have not been given any communication. My lord, I have been verbally stated.
None appears on behalf of the respondents number 3, 4, and 5. In spite of service of notice, affidavit of service filed by the petitioner be kept with the record. For the interest of justice, the case is adjourned. The petition is directed to inform the next date of hearing to the respondent number 2, 3, and 4. And the respondent number 2, 3, and 4 are directed to file report with regard to the freezing of the account of the petitioner on the next date fix. It is made clear that on the date fix, if none appears on behalf of the respondent number 3, 4, and 5, appropriate order will be passed in the absence of the respondent 3, 4, and 5. List the matter on 12th August 2026 under the same heading. Next.
My lord, one kind indulgence, can it be fixed within top 10 matters, my lord?
10 matters. Yes, next.
Grateful to your lordship.
The same heading.
For item number 6, I beg to appear on behalf of the petitioner led by Mohammed Sabir Ahmed. My lord, this matter was taken up on 27th of July 2026. My lord, this is the invocation of 123, my lord, Army Act, my lord. On that day, your lordship pleased to direct the respondent authority to come up with the schedule on which date the proceeding will be taken up, my lord.
Yes, madam.
Lordship, I want to
Yes.
show your Lordship the schedule.
Can I get a copy of the?
Give him a copy. I've given it to Sumita. Sumita के पास है.
Yes, that's it. Okay. Yes. So you'll start from 3rd August.
Lordship, 9th of August, Your Lordship. He will report. Before that, we'll do our administrative formalities.
Yes. So 9th August he has to report.
Yes.
Then 10th it will continue.
Yes.
11th to 19th continue.
Yes.
Your witness will be present.
Yes, Your Lordship.
Then 24, 25.
Lordship, he will be provided free fooding and lodging from our side. He'll be treated as a guest at the JCO officers' mess. Your Lordship sees the second page of the schedule. 2.5, Your Lordship. Lordship kindly also sees 2.7.
Yes. So he will go on 6th and he will back on 25th of August.
Your Lordship, subject to 2.7, Your Lordship.
Subject, then he has to come.
Yes.
When you will fix the date, he has to report.
Your Lordship, 2.7, Your Lordship, once he leaves, in case there is prima facie evidence established against him, Your Lordship, then he will be attached for further disciplinary proceedings. In case the finding is on the contrary, then he'll be released.
Yes. Yes.
My lord, subject to correction by your lordship, my lord. It means that I had to report on 9th August
Yes, 6
on
p.m.
6 p.m. and
Yes.
I will be staying till 25th.
Correct.
And my lord, on such day, my lord, if the summary, if the proceedings, outcome of the proceedings goes against the my lord, petitioner, he will be taken into custody immediately. That is the my lord inner my lord implication of 2.7.
Yes.
But I only beseech to your lordship because I am ready to cooperate with the trial as my senior my lord, submitted on the last occasions, my lord. I only, my lord, beseech to your lordship, my lord, my senior is engaged in courtroom number 35. My lord, so kindly, my lord, kindly fix this matter at 2 p.m. Sure.
No.
Lordship,
Yeah,
the schedule is
that's
there,
there.
Lordship, it's
Yeah,
very
but
clear.
on the prayer of the advocates, I am fixing the
Yes,
within 10
yes,
matters within
he was
5
well
minutes.
aware.
My lord,
Taking into consideration the urgency of the matter, it is not possible.
then my lord, kindly appreciate one thing also.
If
My
you are accepting it, it's okay. If it is not accepting, I am
No, my lord, I
dismissing
am-
your application
No, my lord,
with the
I am
direction to
accepting.
the concerned police officer immediately arrest
No, my
and
lord,
produce
I
before.
am
Very well.
accepting because I have submitted that I will.
See, even in the criminal proceedings also, if the court very first day the judgment deliver what before the sentence you have to take into custody.
And my
The
lord,
same thing they are telling.
We're treating him as a
If
guest.
the 5 or 14 or 20 witnesses have been examined by them and they are I find that there is attachment, and you also not a layman, you might have been knowing that what would be the consequences after going through the evidence.
my lord,
Then how you can be
my
allowed
lord,
to go
there
out
is a
Lordship, I
provision-
just-
and who will take the responsibility
No, my lord,
for your
kindly appreciate in CRPC there is a provision. If the punishment is awarding below 3 years, my lord, I have the liberty to move a bail application on the specified
But
date.
it's an Army Act.
So that is why, my lord, I am seeking and two more, my lord, indulgence from your lord.
Yes.
One is, my lord, he may be allowed to, my lord, use the phone during the period.
Yes,
And
yes.
my lord,
No problem.
and my lord, he
He'll
may
be
be allowed
treated
to
as a
seek
guest, your
it,
lordship.
my lord, any legal assistance from any person. No problem.
Naturally, legal assistance.
That is right.
Record these 2 points, my lord.
During the recording of summary of deaths, he cannot, the counsel, he can consult his counsel outside.
Correct.
And take his assistance, but not during the proceeding inside,
That's correct.
not during our court hearings. Anytime he can consult his counsel.
Within your control.
So that he can
Within their
do it
can,
legal
the
purpose.
council can come.
Because the cross examinations, my lord, here it is a mention that cross examinations also will be, my lord, kindly see, my lord. So cross examinations may not be, my lord, may not be, my lord, acquainted with the legal facts and legal.
So he has access to the phone. He can meet him in the cantonment.
Take the advice from the advocates.
My lord,
They'll be allowed to enter the cantonment.
Still, my lord, as they have submitted that the lawyers will not be permitted during the proceedings, my lord. But until and unless the lawyers will not be permitted, my lord, only through the communications of the, my lord, phone. My lord, it is very difficult.
Lordship, may I submit? Once any witness is giving statement, he will be present in the court. When the statement is over, the
Recording.
ratio, he can take 1 day break, consult his counsel, frame his questions as much as he wants.
You're
He
not
will give him the statement.
You're not allowing the advocate to.
He can be present. He can be present there in the campus area, but
Not inside the room.
he can consult. He will
You're not-
give him the statement.
Hmm.
He can frame his questions.
He
as
can
much
take
as-
time.
as much time he wants. 1 day, 4 hours, 6 hours.
But you're not allowing the advocate to cross-examine in the.
No, advocate is not permitted.
Not permitted.
He can cross-examine. He can frame his questions.
He can take assistance. He can be outside the room.
For a simple layman, my lord. Otherwise, if he's, my lord, I am not in a position to take.
Show me the law. The advocates may permitted. Show me the law, or the advocate is bar under the Army Act. Show me the law.
This is a
Have the Army Act, then, my lord. That indulgence, I only, my lord.
Show me the law. There is a bar of the advocates to appear during cross-examination, or there is.
There is no law.
Which law you're telling that the advocates are
Army
not?
Rule 23, Your Lordship.
Which rule? Army Act 23.
rule.
Army Rule.
23.
Yes, Your Lord.
Page 71, Rule 23, procedure for taking down the summary of evidence.
Yes.
ये लिखा है ये putting question answer question कितना ही procedure है
No, that the lawyer cannot enter.
military procedure. Your Lordship, about the lawyer,
But the
there is no
bar-
written.
Then,
It is not written. So it is a military procedure.
This is unprecedented. A lawyer has never come.
No,
there is no specific part.
no, because I had appeared. I had conducted. That's why I'm telling you whether there is a rule is changed after my elevation or because I had conducted this trial.
That is a court martial, Lordship. This
court
is not a court martial.
Is it Army Act?
This is not a court martial.
This is taking down of the summary of evidence.
Summary evidence.
Correct.
That is a court martial procedure. During the court martial, the counsels they appear. Yes. Lordship, we are only at an investigation stage. It is just like
Court martial.
CRPC procedure where police investigates.
During the
And-
court
and
martial,
and
the
they-
lawyer will be
they
allowed.
Prepare the report under 173. We are similarly doing the similar procedure. After this, we will make the report.
My lord, subject to correction by your lordship, as he is saying that it is only for the investigation stage, my lord. Now, in investigation stage, in CRPC, my lord, since when the police will investigate any matter, my lord, below the 7 years, there are procedures, my lord. My lord, I understand. My lord, that is why I am ready
frame the
to
charges
cooperate
here,
with the proceeding at any length, my lord.
You will not frame.
Only-
This is unprecedented. My learned friend has been in the service for
Earlier
28
occasion
years.
when
He has
I
not
was-
seen this.
When
This
I
is
was
not the procedure, Your Lordship.
My lord, may I submit on the earlier occasion when I was taken into custody pursuant to the invocation of 123, my lord, I was not even allowed to sign in Vakalatnama. That is why my wife had to file the writ petition before this honorable court, during which the invocation of 123 was revoked, my lord. That is why I am seeking this little indulgence, my lord, from your lordship.
Your Lordship, he can consult his advocate anytime. I'm giving a statement.
Outside the room.
Any time outside the room. He wants breaks any as much time he wants breaks.
And I
During the proceeding, he can seek a break, go outside, talk to his advocate.
Seek adjournment any as
because
much
if
time.
I
There is no issue. Counsels are permitted only during court martial stage, and they have got the right of audience during the court martial stage. This is only a recording of evidence.
This is a preliminary inquiry. This is an inquiry. Why?
He's just recording the statements.
You take your client can call you, and if you wanted to give
He can be outside. The counsel can be outside the room. He can take a break.
We
He
will
can
give
say,
them a
yeah.
separate room. He wants to take a
only
break
that
for
is
consult his
indulgence,
counsel.
because it is not specifically written section 23 as they have submitted, my lord. Since I am only, my lord, seeking these little, my lord, indulgence so that he may be allowed.
Okay, in that case, I will interpret the law. You appear before the court, and this court I will hear. Then let they file the affidavit in opposition. I will settle the law whether the advocate is, and you go and appear before the authority. That can I do.
Your Lordship, in my
If you want, this court has to settle the issue with regard to during this period the advocate is not, then that is to be decided after hearing the parties. Correct. So I will not pass any interim order. I will direct you to appear before the authority on 9 in terms of the schedule, and I will decide this writ petition with regard to the whether the advocate can. Then I have to hear both the parties and consult the law. Then I have to pass an order. It's choice up to you. I cannot by making your submission, by making their submission, and this court cannot say yes, the advocate be permitted. Then the law is to be.
My lord, earlier submitted. I am
This
ready
court
to
has fixed the matter today, but the Lieutenant Counsel for the petitioner prays for time on the ground of the senior. According cases adjourned, let the petition director to appear before the authority for conducting the inquiry as per the
schedule
fixed by the authority on 9th of June, 9th of August 2023 at 5 p.m. 6 p.m.
Yes, Your Lordship, 6 p.m.
My lord.
Yes, call the
kindly reflect that too in the, my lord, right of the petition.
Let the matter appear on, what is the last date?
25th August, Your
Let
Lordship.
the matter appear on 27th of August.
My lord, I'll
Grateful.
definitely.
7 minutes, I am for the petition.
Yes.
Madam, I am appealing for the state respondent.
Witness. Manufacture of certain Ayurvedic drugs, my lord. My lord, all on a sudden, my lord, a notice of suspension has been issued by the authority, my lord, in respect of 2, my lord, drugs, my lord, which is at page 18.
You are having the license?
Yes, yes. License
Yes.
I have annexed. My lord, from the office, they have reported that some
Where is the
adulteration,
license? Where is the
adulteration of
license?
below mentioned drugs has
Where
been.
is the license, sir?
License is at my lord page. My lord, it starts from page.
14.
Yes, my lord.
So 7 item has been given to you.
7 items, and there are
Surma tablet, Basma.
total 318 items I have.
Ah.
My lord, if your lordship then my lord comes to my lord page 18 once, my lord, your lordship will find the suspension order in respect of my lord 2 drugs. That is my lord Chintamani Rasa and my lord Mihokeshwari Rasa. My lord, last but my lord 2 lines above, my lord, your lordship will find in the page 18.
Administration of the below mentioned Ayurvedic medicine and
Yes,
manufactured by the surface in several electronic media. Yes.
My lord, then my lord kindly comes to my lord the next page.
Yes.
My lord, the notice has been served upon me. Based on the hearing, my lord, this is the suspension order on 16/12/2016. I have been directed to appear at the hearing on 19th February. I appeared along with my all documents, and 19th February, my lord, and 20th of February 2026, this notice for suspension of manufacturing license has been issued. My lord,
competent technical staff had conversed regarding the forgery of the document.
my lord, the first suspension as regards to adulterers. Next, my lord, this notice, my lord, says regarding forgery of documents. Next, my lord, kindly come. My lord, I have submitted all the documents in the next page. Your lordship will find. Thereafter, my lord, kindly comes below the notice of cancellation, which is appearing at page 21, my lord. My lord, I am reading that, my lord, order of cancellation, my lord. Whereas the firm's license was suspended and Ayurvedic license and GMP certificate were confiscated and surrendered by the firm based on our earlier suspension notice dated 20th of February 2026, which I have shown your lordships. Whereas all the Ayurvedic medicines were confiscated and subsequently surrendered by the firm for statutory testing as per the existing protocol and provisions of the Drugs and Cosmetics Act 1940. Whereas the concerned Ayurvedic medicines failed in the analytical test under the provision of section 33E of the Drugs and Cosmetics Act, report as seen by the authoritative laboratory and received by this office dated such and such. Hence, based on the above, the license and GMP certificate of the concerned firm is hereby cancelled with immediate effect in the interest of public health safety. But the initial suspension was issued in respect of 2 drugs. And when the final cancellation has been passed, on the basis of authoritative laboratory test report, that has not been supplied to the petitioners, and no notice of show cause has been given before cancellation of these manufacturing drugs. And so far the Act is concerned, I do not find any provisions under which basis they have cancelled my license without initiating a criminal proceedings or anything else, There is no such proceedings, and there is a complete violation of natural justice, My entire drugs and entire farm has been cancelled, That cannot be done, Only on the basis of 2 drugs, they have taken a laboratory test report that has not supplied to me. What is the test report? Nothing has been given to me. And what standard they have failed, these 2 drugs failed, Nothing has been supplied to us, Only on the basis of this, this cannot said to be a speaking order itself also, No findings has been given, only on the basis of test report. What is the test report? I have challenged this notice before your lordships, and since my all drug license has been cancelled, I pray before your lordships to resumption of other drugs other than these 2 drugs, let it be continued,
Kindly come to the page 21.
Yes,
Page 21. All Ayurvedic medicine were confiscated, subsequently surrendered by the firm and statutory testing as per the existing protocol and the provision. Whereas the concerned Ayurvedic medicine failed the analysis test.
I am putting question to how it could be, My lord, initially they have initiated, my lord, on the basis of two.
Let they file the report. This, how the medicine,
My lord,
you
my lord,
are
The charge of adulteration.
yes, you are selling the medicine.
just, but this is
Paper and appeal, my lord.
this is not adulteration. First part they said forged documents. That is, you know, separate positions.
Right. So that's why. then
And
it has to-
second part they said the test report failed. What is the test? I have a right to know, my lord.
correct. You
I have a right to know, and
that's correct. But see, it is not. This is not a simple. This is with regard to the Ayurvedic medicine.
yes,
If today this court will stay the suspension order, cancellation order, amounts to allowing you to run your business.
my lord,
To run the business, prima facie, their contention is that you are selling the adulterated, the Ayurvedic medicine.
only in respect of
Whether
two,
this
only respect of two
Allopathic,
medicines.
allopathic medicine has been used, my lord.
Allegedly on only on the basis of two medicines, my lord. It is
Okay,
not.
let they file the affidavit in opposition. How soon you will file the affidavit in
Well,
My lord, within 2 weeks, my lord.
why you not prefer the appeal?
Well,
Well, there
it
is
is
a-
the question of violation of natural justice. When I came before this court, my lord.
Okay, I will
My lord,
decide.
they have a right to, my lord,
Okay,
give
okay.
all these documents.
When you
If
file
your
the
lordship
report-
kindly.
My lord, within 2 weeks, my lord. My lord, first of all, my lord, I would be submitting in the, my lord,
Yes.
thing is that, my lord, this is a charge, my lord, diabetology.
Hmm.
My lord, these medicines, allopathic medicines, my lord, that is
This is not allopathic medicine.
glimepiride and metformin has been used, has been found. And in the Ayurveda, they are, my lord, using this and they are making in havoc and people are taking. For that reason, cancel the license, my lord.
Only in respect of you can cancel only in respect of two drugs, my lord. They have issued
No,
a
no, this is
suspension order in
the thing
respect
has
of-
been done, my lord. It is circulated through. In there, my lord, and India has taken.
Section 25 once, my lord, the drugs and cosmetic tax, my lord. My lord,
That's correct.
It is a racket, my lord. It should be stopped, my lord.
I agreed with you, but the problem is here is the medicine. For the medicine, this court has to decide on merit. By simply on the on looking the paper, this court cannot allow you to
my lord,
run
that's
your
true, my lord.
business.
But since they have, my lord,
The public
my
health
lord, my lord, kindly consider for a once, my lord. My lord, they have sent my lord samples before the test
You
laboratory.
take all, let them file the report. If they are not follow, you take them reply. This court will decide on merit. If they are not followed, automatically it will go.
My lord, 25 says.
How this court can do at this present how?
Well, let them my lord, place a report, my lord, to that effect.
That's
my lord,
what
whether-
I'm telling. Let them file the report by
my lord,
affidavit.
kindly give them a short period. So my license has been suspended and entire staffs are working there. My lord, it has been, my lord, suspended. So that cannot be done in a longer period.
Challenging the order of cancellation of manufacturing license issued to the petitioner with regard to the Ayurvedic medicines. Full stop. Counsel for the petitioner submit that the authorities have initially issued the notice with regard to two medicines on 16th of February 2026. Subsequently, the respondents have suspended the license. Now the respondent authorities have cancelled the license without supplying the report on the basis of which the license of the petition has been cancelled. This court find that this writ petition, the net counsel appearing for the respondent raised the point of maintainability and submit the writ petition is not maintained. This court find that the written learned counsel for the petition submit that though there is a appeal provision, but the petitioner has filed the present date application on the ground of non-following the procedure of natural justice and without giving an opportunity of hearing and without supplying the report.
Well, a hearing has been given, my lord.
Petitioner, comma.
No, my lord. No notice of
Petitioner
focus. Let them
has
put the
filed
notice
the
of
present
focus
date application.
before passing of the final.
Consider the submission made by the counsel for the party. This court find that this writ application is to be disposed of only after is to be decided on only after filing of affidavit in opposition. Let affidavit in opposition be filed within 2 weeks after serving the copy to the counsel for the petitioner. Petitioner is liberty to file affidavit in reply within a week thereafter. Let the matter appear on On 27th of August 2026, under the same heading, within 10 matters, the affidavit of service filed by the petitioner be kept with the record. The maintainability point raised by the maintainability
My
point
lord,
raised by the
your lordship kindly,
is kept.
my lord, there is a provision of appeal, my lord, that has not been preferred, my lord.
That I recorded.
My lord, that may be recorded, my lord.
Recorded,
My lord,
recorded.
keep your-
I appear for Federal Bank, my lord, the contesting respondent.
Yes, who is for the petitioner?
Mr. Chakravarti, Orange Chakravarti is appearing, my lord.
So, Mr. Banerjee is leading in this matter. I will just start indicate the fact. Lordship, the offending document is a 13-2 notice pursuant to which Section 14 order was issued.
When the 32 notice was issued to you?
Lordship, 13-2 notice was issued to me on 14th of July 2025.
When the NPA was informed to you?
Your Lordship, the NPA was prior thereto, but I am covered by your...
Take breath.
May I? In the meantime, two pertinent questions Lordship had put. NPA date is 25th of June 2025 and 25th of June 2025.
NPA notice.
NPA date.
NPA date.
The account was classified a non-performing asset on 25th June 25. 13-2 is 14th July 25.
13-2?
14th July 25.
July 25.
And reply, as in bank's reply to the 13-2 in under 13-3A, that is dated
When they have given the reply?
12th September 25.
They have taken the plea of revival package?
In
the notice?
Only in the reply for the first time.
At this stage,
and I have
notice under 13.
No, then we deal with their reply, that is 26 September 2025. And in the meantime, we had also indicated they wanted closure of the account. In fact, in terms of the sanction letter, we had proposed what would be the charges if you want a closure. If you want to pre-close the account, there are certain charges that are to be paid. My lord, we indicate all that to them. My lord, they don't pay. And my lord, it continues. Thereafter, account classified NPA. Thereafter, 13-2, only in the response, they say, no, you have to give me the benefit under that framework.
Affidavit filed?
No.
Under the revival?
No, nothing. And Lordships, my lord, I am aware of your Lordships, my lord, two judgments where the distinguishing feature was that the NPA date and the 13-2 date was just the day thereafter. 24th June was NPA, 25th June was the 13-2. So there was no chance. And Lordship gave them the benefit. Here, my lord, in terms of the Supreme Court decision, which has been followed now extensively by all courts, in fact, by your Lordship also, my lord, there is no scope for Section 14 measures taken, my lord, possession taken, my lord, physical possession is with me. Yes. Section 17, my lord, no interim order granted.
My latest judgment.
Your Lordship, I am carrying that, in fact. Lordship will kindly...
Latest 2 days, 1 week before I...
Yes, sir, where Mr. Thakkar was appearing, perhaps, against...
Mr. Thakkar and Mr. Khundu had appeared.
Yes, Your Lordship,
I am then, I have to be updated about
We have considered that. Lordship will kindly appreciate one notice, which perhaps my learned senior has omitted to place. Lordship will kindly look at page number 35.
How you can come out from the Samarth? How you can come out from the Samarth judgment of the Supreme Court?
Lordship, perhaps I am covered by pronates, which was also considered by a division bench of the Madras High Court, wherein, Your Lordship, this issue really has been characterized as a jurisdictional issue. Apropos that, Your Lordship will also bear in mind kindly that although we've preferred a Section 17 application, this point of MSME was not taken there. The benefit claiming MSME, Your Lordship, the revival and rehabilitation mechanism that is really enumerated, that notice precedes my 13-2 notice, which really falls within the ambit of your Lordship's judgment, as your Lordship has perhaps held, subject to correction.
Yes, earlier I held.
Which that judgment, Your Lordship, I have Vijitsa Retail Ventures, Your Lordship would recall, I am carrying that judgment. Here, Your Lordship will see the factual matrix, how it has really unfolded. Lordship will kindly, I will not showcase all the documents, Your Lordship. Lordship will kindly, the master directions I am not showing, Your Lordship is aware of it.
I don't think there is scope of any interim order in this matter any longer.
No, there is, Your Lordship, because
Lordship, is the interim prayer that has been sought for, whether that can be, my lord?
That may be very unhappily drafted.
If it is, you are not entitled, what the interim order, what the affidavit is.
Your Lordship, I am
Question of law, whether you are entitled.
Right. Entitled or not.
You read the Pronit and the Samarth.
Samarth is the latest.
Samarth is the latest.
Yes.
Samarth has considered the Pronit.
Yes, Your Lordship.
Fix that, and that in that case, the Supreme Court has held. If you are not aware, the entrepreneurs is not aware and not taking, and the last moment you are coming.
Yes,
so
Your
you are
Lordship.
not
I am so
entitled
grateful to
that.
Your Lordship.
You are not entitled.
Apropos this, I am so
Here you are 13 notice.
Lordship, may I juxtapose the law which has fallen from Your Lordship with the fact at hand? Lordship will kindly for once take page 135. Lordship will kindly mark the date. The date, Your Lordship, is 25th of June 2025.
135.
135, wherein I have preferred a representation to the bank manager.
June 25.
June 25. Your Lordship, I have made this representation over. Subsequently, Your Lordship, the 13th notice is issued on the 14th of July 2026. Now, Your Lordship, it's a matter of law. Your Lordship, when it's apropos jurisdiction, perhaps Your Lordship has also considered so that Your Lordship always has the scope to intervene. Because Your Lordship will kindly bear in mind the jurisdiction that Your Lordship is exercising. It's under Article 226. So, Your Lordship is bereft of the explicit affairs. Perhaps
about 226, 142, 145 is
most certainly. Your Lordship, I'm covered by that. In fact, Your Lordship, Mr. Banerjee is leading me. This is of some consequence, which is why I'll request him through Your Lordship to take over. Your Lordship, I'll just indicate one judgment before Mr. Banerjee can really take over. Your Lordship's judgment in Visitsa Retail. Because this, Your Lordship,
Oh.
Lordship will kindly look at the facts over here, right from para number 1. Petitioners have filed the writ application for mandamus upon the respondent numbers 1, 2, and 3 to act in terms of the framework which Your Lordship, even I am falling under. Petitioner is a registered micro enterprise having registration so and so. Cash credit facilities availed of rupees 4.95 lakhs. Your Lordship, I have claimed, I have, Your Lordship, taken financial assistance of 6 lakhs, so I really fall within the classification of 10 crores. By a notice dated so and so, respondent number 1 has informed the petitioner that the cash credit account of the petitioner is under SMA 2 and will be turned to NPA on 25th of June 2025 due to non-service of interest, and requested the petitioner number 1 to immediately pay the overdue amount of rupees so and so and to regularize the account. On 26th June, respondent number 1, by a notice under section 13(2), calling upon the petitioners to discharge their liabilities in full by paying the entire amount of 5,12,64,000 with interest. Petitioner number 1, by a letter dated, Your Lordship, this date will be of some consequence, 13th August 2025, sent a reply to the notice dated 26th of June 2025, requesting the bank to withdraw the said notice and to follow the provisions of the framework for revival and rehabilitation of micro, small and medium industries and the judgment passed by the Honorable Supreme Court in PROCEEDINGS, which Your Lordship was really talking about. Then Your Lordship will see, on 6th September 2025, the bank again issued a notice under section 13(2) of the SARFAESI Act, calling upon the petitioners to pay an amount of so and so along with interest within 60 days. In the said notice, it was also informed by the bank that the petitioners, that the earlier notice dated so and so under section 13(2) stands withdrawn. Now, Your Lordship, the semblance that I'm really attempting to canvass is, Your Lordship, that my representation, as in this case, predates the section 13(2) notice or precedes the section 13(2) notice. So this ought to have weighed with the bank in their issuance of the section 13(2). On 28th November, Your Lordship, this is the last date that I'm really on, 2025, petitioner number 1 has made request to the zonal head of the bank for implementation of the MSME. The petitioner number 1 also made a request to the Reserve Bank of India, with the request to issue direction upon the bank for implementation of the guidelines. Now, Your Lordship, the semblance that I'm really attempting to canvass is, Your Lordship, that my representation, as in this case, predates the section 13(2) notice or precedes the section 13(2) notice. So this ought to have weighed with the bank in their issuance of the section 13(2). On 28th November, Your Lordship, this is the last date that I'm really on, 2025, petitioner number 1 has made request to the zonal head of the bank for implementation of the guidelines. The petitioner number 1 also made a request to the Reserve Bank of India, with the request to issue direction upon the bank for implementation of the guidelines. Now, Your Lordship, this is a statutory benefit that is really extended, so
So why you have not submitted your all affidavits on before the bank under the framework?
Your Lordship, because that
And
mechanism.
what is the stage now of the possession taken?
Possession has been
Then
taken
Physical possession.
without your lordship, when the matter was pending before the DRT, I have taken instructions on this count.
And you filed the application 17.
We filed the 17 application, your lordship. Lordship, this is where
It was not moved.
How?
It was not moved 17.
So this issue we were anticipating would come up, that if this alternative remedy, debt recovery tribunal, whether we can come back and trouble your lordship. Just to, on this aspect of jurisdiction, may I first?
Not jurisdiction. This court, see, you have received the notice on June 25th of June 2020.
Yes, my my MSME representation was 17th
7
of July.
17th of July.
14 July.
Where is that? 17th of July, you have given the representation.
And possession taken on 8th of January.
No, 22nd July.
Taken 17 July. And this is on 25th of June 2025. I write to the bank under. So it precedes the 13-2. My representation under the MSME circular precedes the 13-2. That is the only requirement really under the circular that I have to do now, as how Pronitz is now clarified by the Supreme Court, Justice Datta's judgment. So bank knew when they were issuing the 13. That is the test I'm on. When bank was taking steps under 13-2, the bank was aware of its obligation that I come as an MSME. That departure is probably now without jurisdiction. In aid of this, may I just rely on a division bench judgment? Your lordships have now, of course, Pronitz and how it's clarified. Okay. No, not that. I'm sorry. Madras. Please have a look at paragraph 21. Well, this judgment, your lordship will give it a cursory glance because it holds similar in tune with how Pronitz and how it's clarified, that it's otherwise a mandatory circular. There are certain rights which accrue. There are certain rights which accrue unto me under that circular. I have to invoke that circular before surface action is taken. Please have a look at paragraph 21 here.
Yes.
One before I take your lordship 21. I'm sorry, Mullah.
Yes, yes.
13 1, paragraph 13, 1-3. The bank had raised the plea that the present writ petition is hit by the principles of res judicata. At the same time, has also stated that the petitioner for the first time had raised the plea of benefits under 2015 notification. This court is of the considered opinion that when the issue was not raised in the earlier writ petition and it is raised for the first time in the present writ petition, there is no question of res judicata at all. So this I'm showing that 17 and this.
I am not on that.
17 and this are two very different.
Not on res judicata. This court is of the view, and my judgment is the latest judgment is there by following the Samarth and.
Yes, we've seen that. I think Mr. Gupta was appearing.
Yes, see, the question is that once you have been given the section 13 notice, I don't know whether you have taken the plea of the revival package.
Yes, we have.
If you have taken the revival package and subsequently they have proceeded with that, why you have not filed an affidavit and all these things in terms of the revival package? First, consider my request. But you continue with that process and subsequently now the possession has been taken. How this at the last stage the revival?
We are at a stage today.
That is the only.
Yeah, I understand that.
I am
that's
not on
something
res
that was troubling. No, why I wanted to show res judicata, and in fact, paragraph 21 also, if your lordship looks at 21 once. The next question
that there is, I'm sorry.
Yes, yes, continue.
The next question, that there is alternative remedy before TRT, is outrightly rejected, since the issue raised in the present writ petition is whether the bank can proceed under SARFAESI without formulating revival scheme under notification of 2015, which is a jurisdictional issue. Further, the issue is not under this, the issue is not under SARFAESI, but under section 9 of MSME Act,
Correct.
read with the notice.
I am totally with you. I am totally
Then I'll
with
sit
you.
down.
I am totally with you, but only you have to satisfy 13-2 notice NPA declared, 32 notice was issued to you. You have given the reply 32, taking the asking the benefit of that. Thereafter, why you have not submitted the affidavit with regard to the package? Then the bank has to submit all these things. You have to submit the affidavit.
Only because of
And
this.
whether this court has considered with regard to the Samarth. Pronit has considered whether the division bench of the Madras High Court considered the Samarth.
No, that I'll just check. No, that
Not
my
been
junior will
considered.
do. One thing,
Pronit has been considered.
Pronit has been
Pronit
considered.
considered, but not Pronit. What the Pronit Samarth has
Yes,
justified.
yes.
Then you, if your Samarth is not considered, then kindly come to my judgment.
Samarth
Your
is not
effort.
considered here.
Which you are referred to
Yes.
in the this
Yes.
Bitza.
Yes.
Kindly come to page 19, paragraph 19.
Visit, sir.
Kindly come to the page 7. Page 7 of the judgment.
My lord.
Paragraph 7. As has been noted above, the
I'll please. As has been noted above,
yes,
the petitioning enterprise does not seem to have claimed the benefit of the terms of the framework after the demand notice seem to have ever claimed.
Correct.
After the demand notice under 13.2.
Correct.
It is at the stage of compliance with an order passed by the relevant magistrate under 14 that this writ petition has been presented before this court, claiming benefits of the framework to restrain the respondent and officers from proceeding further under the SARFAESI Act and other enactment except in the manner contemplated under said notification. We find that the bona fides of the petitioning enterprise to be suspect.
This is the paragraph.
Well, this is slightly, I'm on a slightly better footing here because I have actually invoked the circular. Not this paragraph that I just placed before your lordship is where after 13.2 it was not done. After 14, I have come to court after 14. But I've invoked it before the SARFAESI Act was even looked at by the bank. That's the distinction.
Yes.
Because the 13.2 notice was actually issued on 14th of July 2025. In that judgment that your lordship was looking at, that paragraph, the court or the invocation of the circular happened after measures under 14. Here, before 13.2, because my representation is that on 25th of June 2025, which your lordship will find at page 135 clearly. And if you kindly have a look at page 135,
Yes. There is a statement in the 135. There is a reply to the 13. This is a reply to the 13.
No, this is not the reply to the 13.
Where is the reply to the 13?
The reply to 13 to the Kota, I'll just show. But that is not a part of the writ petition.
No, their response, it's there. Page 75 kindly comes, my lord. What they have not disclosed is my reply, how I deal with his reply. Page 75 kindly comes.
75? 75 to my name.
Oh, I'm sorry. It is from what? I'm sorry, my lord. That's not disclosed. That's not
No,
disclosed.
that is not there.
That is not disclosed.
So surprised at my brief, I don't know.
No, that's not disclosed. I have a copy, my lord. I have a copy. No. Relevant paragraph is paragraph 9.
At page 77.
Internal page 3, yes.
Yes.
Paginated page should be, my lord, 77. This is the only paragraph. and page 78, paragraph subpara C.
Yes, what is your reply to this?
My reply. My lord, kindly takes page 81, it starts.
কি দেখাচ্ছো?
Reply টা এখানে আছে।
Oh, এইটা।
My lord, at page 82 kindly comes first, my lord. Subpara G. My lord has page 82.
Yes.
Subpara G, my lord. The firm had thereafter approached the bank.
82.
Yes, my lord.
Of this bunch.
Of the bunch which I had, my lord. Same bunch, yes, yes. My lord, the response starts at 81. It's a 26 September mail, lordship will find. Kindly comes to page 82.
Yes.
My lord, subpara G, my lord, there is a paragraph. The firm had thereafter approached the bank with a takeover proposal from another financial institute and that the account would be closed. The bank had agreed to the same by its letter dated 12 February 2025, a copy of which is annexed and marked with letter so and so. Prepayment charges were levied in the sanction dated so and so. At the request of the firm, such charges were waived as a special case subject to the condition that takeover would be completed by 31st March 2025. This was their stand. Thereafter, my lord, they did not take steps, they did not make payment of the prepayment charges. Now, apropos the my lord, framework kindly comes to
After 13 to notice reply.
Yes.
Page 75.
Yes.
So when they have approached you, after the reply.
No, it's only in the my lord, reply
on.
It's only in the reply, and thereafter, my lord, how I deal with that particular assertion kindly comes to page 83, para 10. Allegations made in paragraph 7 of your letter under reply are denied with reference to 7.1. It is denied that classification of account as NPA is illegal or arbitrary or in violation of RBI norms. You have not taken any steps in terms of the framework for revival and rehabilitation as provided in the scheme governing MSMEs. Further, you had approached the bank for closure of the bank account. As such, any question of revival or rehabilitation does not and cannot arise. Then just skipping one more sentence, my lord, of the same paragraph, just one line I am skipping. I repeat that the question of revival and rehabilitation of an account did not arise. Talks of restructuring had also failed, which was communicated to the firm. So this was the situation. And prior to, my lord, issuance of the letter, the 13.2, there are, my lord, at least 20 such letters where we point out where did the, my lord, firm, the MSME, my lord, entity went wrong in, my lord, acting in breach of the sanction terms. Point wise, my lord, I am carrying all the documents, my lord. And kindly sees, my lord, the attempt now at this stage. If you were so concerned about not being given the right to apply under the framework, why would you wait from 12th of September 2025 and come only in, my lord, June or July 2026 with this, my lord, grievance before the writ court?
Could I just once?
But Mr. Datto, once you have received the reply with regard to the revival package and they have also given the proposal for closure and they have not closed, that was failed. So it is also your duty to place the matter before the revival committee.
My lord, one more paragraph of Samarth which is quoted by your lordship in the judgment visits kindly comes to that judgment once again, my lord. Mr. Banerjee referred to paragraph 6.
Yes.
It should be internal page 10 of that judgment. My lord, page 11, my lord, paragraph 8 of the, my lord, Samarth judgment, it's quoted.
Yes, Pranit.
It is a decision of a coordinate bench of this court holding inter alia that the notification is binding on the lending bank's creditors. Finding to the contrary by the High Court of Bombay in the judgment, an order under challenge in the appeal was thus quashed. Though, while stressing that the terms of the framework need to be followed by the lending bank secured creditors before the account of a micro, small and medium enterprise is classified as non-performing asset, this decision also lays stress on the obligation of the micro, small and medium enterprises by holding that it would be equally incumbent on the part of the MSME concerned to be be vigilant enough to follow the process laid down under the said framework and bring to the notice of the bank concerned by producing authenticated and verifiable documents, materials to show its eligibility to get the benefit of the said framework. It was cautioned that if such an enterprise allows the entire process of enforcement for enforcement of security interest under the SARFAESI Act to be over, or it having challenged such action of the bank creditor concerned in the court of law tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for thwarting the actions taken under the SARFAESI Act by raising the plea of being a MSME at a belated stage. The decision, however, left unsaid something which we have explained herein above. That's not, my lord, my concern. So, my lord, it is equally, my lord, the MSME enterprise must be equally responsible.
While my learned friend places your lordship judgment, may I just draw your lordship's attention to the judgment once more?
Well, then let Mr. Banerjee finish
Yes,
only then, my lord.
quickly, I'll take 2 more minutes. Well, please have a look at paragraph 3 of your lordship's judgment. By a notice dated 24 June 2025, the respondent number 1 has informed the petitioner that the cash credit account of the petitioner under so-and-so will be turned to NPA on 25th of June 2025 due to non-service of interest and requested petitioner immediately overdue. On 26 June 2025, respondent number 1 by notice under section 13(2) of the SARFAESI Act calling upon the petitioner to discharge. The petitioner number 1, paragraph 5, by letter dated petition number 1 by letter 13th August 2025 sent a reply to the notice dated 26 June 2025 requesting the bank to withdraw the said notice and to follow the provisions of the framework. Now, if your lordship could just turn over once, my lord, to paragraph 21 of your lordship's judgment.
Yes.
That representation that your lordship refers to, this is that representation which is quoted in paragraph 21. In reply to the aforesaid, the petitioners have stated, if your lordship finds it just makes a reference to it and says, please follow. Exactly what your lordship will find in my representation under 13(3)(a). Subsequently, the bank has issued another notice under 13(2) where the bank has withdrawn its earlier. If the borrower will not regularize the account, the system automatically shows the account of the borrower as NPA. It is the further contention of the bank that the petitioners have not made any request for any corrective action plan or restructuring the account of the petition number 1 in terms of the framework. On receipt of notice of 26 June, the petitioners, though, did not categorically request the bank for consideration of its case under the framework, but have stated that the bank has violated the notification dated 29th May 2015 and the order passed by the Honorable Supreme Court. The respondent has withdrawn but has issued fresh notice under 13(2). After the judgment of the Supreme Court in Samarth, the bank has withdrawn the notice and issued another notice under 13(2) and thereafter reply dated 17th have been taken, have not made any request for any corrective plan or restructuring. This court finds that the petitioner in his reply dated 13th August informed the bank that the bank has violated the notification dated 29th May 2015 by not considering the case of the petitioner in terms of said notification, though the bank admits the petition number 1 is an MSME. When the bank came to know about the order passed by so in Samarth, the bank has taken the stand. The petitioners have not requested the bank for restructuring. It is mandatory for the part of the bank in reply if the borrower claims benefit of the framework with reasons and affidavit, the bank is bound to look into and claim the claim of the borrower. Considering the above, the court finds that the proceeding initiated by the bank against the petitioners is at the initial stage. There is no dispute that the petitioner is not an MSME. The petitioner is directed to file its claim within 1 week and the bank is to consider. What now the bank stand specific reference I have under 13(2) objection, MSME. The bank stand, my lord, I'm very grateful to him to have given this to us. At page 83, paragraph 10, inter se me and him as a business transaction, what is failing is irrelevant so far as the notification is concerned. Because he rightly places the fact that there is no question of I have paid interest, I have not serviced interest. The facts are akin to exactly what was before your lordship in the judgment that I placed. The bank has reference to this. Bank knows I'm an MSME. That obligation, my lord, that they have, which your lordship seeks to enforce in paragraph 25.
What has happened after the 13 reply? What is after 13
Well,
reply?
we filed the 17, they've issued 14. And if I'm giving possession is taken.
You have filed the
And
17.
possession is taken. But I am told there was an possession. But I'm told there was a status quo order that was there. I haven't seen it.
Where?
DRT, there was a status quo order. The status quo order possibly lapsed, and they went and took the section 14 possession. That possession was taken on 8th of January 2026.
And when you file this petition?
Well, the status quo order not to take coercive steps. This was on 2nd of July 2026. Till 8th of July, bank was directed not to take any coercive steps against the petitioner. And they've taken possession on 8th of January 2020. Oh, sorry.
8 January 26.
No, the section 14 notice is of 8th of January 2026.
Okay. Then possession? When the constructive
Last, I'm given to understand last Wednesday the possession has been taken.
Wednesday means?
I'll just give the date. 29th possibly. 22nd July.
22nd July.
22nd July, the it was taken. And my lord, and the writ petition was affirmed on 3rd of July 2026. So while the writ was pending, in fact, your lordship would recall I had mentioned this matter also.
Yes.
While the writ was pending, this point was there. I am only seeking implementation of your lordship's judgment of paragraph 25.
Yes, Mr. Jatto.
Yes, my lord.
My lord, one more before he starts, just one. Kindly have a look at the Samad judgment, paragraph 7, that your lordship has also quoted.
I'll place 7 also, my lord.
I'll just place it once, so he can place it his way. Sorry, paragraph 7.
Yes, sir.
As has been noted above, the petitioning enterprise does not seem to have ever seen the benefit of the terms of the framework after. So I am not hit by someone. In fact, it's to my advantage that I've given that representation.
Yes, Mr. Datta.
Please.
My lord, I start with the last document which Mr. Banerjee relied upon, saying that it is not only in response to the 13.2 that I have raised this issue, there is a letter prior to that. My lord, kindly comes to that document at page 135 of the writ petition.
Yes.
Well, this document is dated at page 138. Lordship will find 25th of June 2025. What is the significance of this date? The classification of the account as NPA is on 25th June 2025.
Yes.
Well, I fail to understand how this document was served or when it was served on the bank, because Lordship will not find any, my lord, endorsement or any receipt of the bank appearing on this document. So I tried to, my lord, take instructions from the bank immediately, and I am told on instructions this I am making this submission that this letter was not served.
No, Mr. Datto, see.
Now I'll come to the reply.
Yes. Let me frame the question to
Yes,
you answer. You have issued 13.2 notice.
Yes.
In the 13.2 notice, they have given the reply and asked for the benefit of the scheme revival package. Correct. And you have given the reply of the cert, but in the meantime, he has given the proposal. But you had the knowledge that yes, he has asked for this. Why your bank has okayed the proposal which they have given that has not been considered by the bank, or they have not come forward for further action? So why the bank has not given the benefit of the, or not referred the matter to the committee or asked the.
My lord, my answer to this would be, my lord, taking refuge to paragraph 8 of Samarth. My lord, is it only, my lord, one stray sentence, my lord, in a response given to the 13-2 notice that the MSME says, I am going to avail benefit of the framework, so give me that benefit? Or is it something more that the framework requires the MSME to do? And my lord, kindly also sees the timeline. I can understand any court, my lord, receiving a petition of this nature where the courts unanimously have held these frameworks have to be followed by every bank. So I cannot shy away from that. But is it only, my lord, one sentence of the MSME that I am willing to follow the framework, come under the framework?
Because
that is good enough?
Because yes, why it is? Because as per the PRONIT, if the bank has issued, then it is a notice to the bank. Yes, the entrepreneur or enterprises is coming under the purview of the MSME. As per the PRONIT, PRONIT also recorded. If because the bank is taking the plea that we are not aware of that, might be it is MSME loan. But that's why if the bank has received the notice with regard to this is the MSME and he requesting for the revival package of 2015. So why the bank has not given, though it is a mandatory?
My lord, kindly comes back to the, my lord, reply of the, my lord, enterprise. At page 75 of the bunch, my lord, the paragraph which I was showing, my lord, what is it that they had said?
So what I propose to do subject to your correction, or you want to take what I am not going to set aside on all these things. So
Not set aside the?
I will not interfere with all these things what has been done by you.
Very well.
That will remain as it is.
Very well.
I will give the direction within a week. He submit all the requisite documents with an affidavit to you. You considered whether he will be entitled to that. If he is entitled, then the proceeding will go. If it is not entitled,
Fair enough. My lord gives me 1 day's time. I'll come back Wednesday. My lord, lordship keeps it at the top. Tomorrow. My lord, I'll come back tomorrow itself.
Because if it is.
No, I understand. I
am not going to stay on all these things. I will ask not to take any further
Very
action in the matter. He will file and you consider.
Great. Possibly both parties would be happy with that. I'll try and convince my client also.
See to that.
Very well.
Then counsel for both counsel appearing for both the parties have argued the matter at length. Police staff and counsel for the bank prays for time to take instruction. According case adjourned, let the matter appear tomorrow at the top.
Very great.
Very good.
Lordship, learned advocate Shayukranjan Ganguly is appearing for respondent number 5 and 6. Lordship, due to some personal difficulty, he could not be in court today.
My lord, I am the borrower.
You are the borrower.
I am the borrower. My lord will kindly appreciate in this matter I am challenging the impugned order passed by the ACJM Kalna, where I have been.
What is the order? Senior citizen.
My lord, my lord kindly comes to page number 25. The impugned order which I have challenged.
Yes.
How this order is impugned, my lord?
Chief Judicial Magistrate Kalna.
My lord, it starts from page 25.
Yes.
My lord, I am relying upon this notification which I have placed before your lordship of 2000 notification dated 2020, my lord.
24th February 2020.
2020.
Yes.
My lord, as per this notification, they can only proceed under the provisions of SARFAESI Act when the loan amount is 20 lakhs and above. My lord will kindly see, I have placed both the copies before your lordship. My lord will kindly see the last line.
Which shall be entitled for enforcement of the security interest in secured debts of rupees 20 lakhs and above as the financial institution for the purpose of the said act.
My lord will kindly appreciate my loan amount is.
About the 2021 notice, notification.
It is same, my lord. It corroborates the same, that there is no change.
Rupees 50 lakhs and above. The notification for the words 50 lakhs and above. Above the word 20 lakh and above shall be substituted. So now it has come 50 lakh and above. 21, 50 lakh.
My lord, my lord. My respectful submission before your lordship is that since my loan amount is less than 20 lakh,
What is the total amount?
total loan amount is
5 lakh 13,000. You have
6
taken
lakh, 6 lakh 50,000, my lord.
the opposite
Approx.
party financial assistance of tenure loan, nature of the home loan of 5 lakh 13,000 and rupees 3 lakh 2 lakh itna. Two loans 7 lakh 47,000.
7 lakh 47,000.
Ah.
My respectful, I am only on these issues. My respectful submission before my lord is, since this notification says that 20 lakhs and above, can we, when it is 20 lakhs and above, then only we can proceed under the provisions of Surface Act. My second submission before your lordship is, show me the notification.
So how this court is having the jurisdiction? Surface matter? What your challenge?
My lord, I am challenging this impugned order because this impugned order,
The magistrate.
magistrate, my lord, how they have proceeded under that, that is why I am before my lord.
Under the Surface Act, how this court can have it determination? This order is under the Surface Act.
My lord.
So whether the magistrate.
Your
how
Lord,
this-
may I intervene, your lordship? Am I
lord.
audible? I am for the petitioner. We are approaching this court because there has been an excess of jurisdiction. There is no jurisdiction to proceed against Surface by
Correct,
the authority.
correct, but this court is not dealing with the Surface matters.
This is, we are not raising any substantive right under Surface which is being violated. We are saying that the authority has no jurisdiction to proceed against under Surface for our loan because we are below 20 lakhs. In your lordship, I want to, to draw your attention to, there is a division bench judgment of this Calcutta High Court, very recent of April 26, in the case of Ghulam Sarwar versus PROCEEDINGS and Capital. Exactly the same facts were agitated here, and the bench had in detail, they had deliberated on every aspect of the maintainability as well as for the loan amount. And if you, I will attract your attention to the serial 33, it's the second last page of the judgment, which makes things very clear.
Hello? Yes.
By your Lord's permission, if I read out.
Yes, no problem. So, from whom you are
Thus we agree with the conclusion arrived at by the learned
Respondent 5 and 6.
Who is the respondent 5? Branch manager.
Aadhaar Housing.
Aadhaar Housing Finance.
Is it HFC?
Lordship,
HFC?
It is HFC.
Or the NBFC?
It is an NBFC engaged in the business of housing finance. There is a clear circular from the RBI with 5th January 2022.
Finance.
You are
Lordship.
appearing for whom?
I am for the state, my lord.
I'm for the state.
You are appearing for?
I'm appearing for Aadhaar Housing Finance, Lordship. Mr. Ganguly is the counsel. He is not in court today because of some personal difficulty, Your Lordship. I'm kindly praying for not today.
My lord, let interim protection may be granted, my lord, because they are going to take the process.
Lordship, kindly fix it tomorrow, Lordship.
Tomorrow.
My lord, can kindly fix it day after tomorrow. I have some personal inconvenience. My lord, kindly grant interim protection, my lord, so that they do not take the physical process.
Number 5 and 6, place for a day's adjournment. Accordingly, case is adjourned. Let the matter appear day after to come with it. 5th of August 2020.
My lord, let interim protection be granted because they are.
Come on, day after tomorrow within.
My lord,
100
they will, I wishes, my lord, they may take, they have taken,
not
they
to
will.
take anything.
My lord, let it be grateful, grateful.
Then Your Lordship, I am appearing for the Union of India.
Grateful.
Yes.
I am appearing for the petitioner. The petitioner is a citizen of India. After his completion of the graduation, he went to abroad for his employment.
These are the
In the year 2016, he applied for his passport, and the passport has expired in the year 2025.
When he went to abroad.
When he was abroad, his passport got
expired.
When he was in abroad itself.
Yes, itself.
Okay, then
Then Lordship, from there, from Indian Embassy, he obtained emergency certificate, and using that he came back to India. And then he applied for renewal of the passport. Till date, the passport has not been renewed.
you are the Bangladeshi national. You are the Bangladeshi national.
Yes, Your Lordship. Lordship sees the second paragraph
Yes, yes.
of the
You are the
brief.
Bangladeshi national.
Yes,
Have you got the
Lordship.
report? Show the report.
Lordship, regarding his citizenship, we have his all educational certificates,
Correct.
birth
Has he declared the Indian citizenship? Or is an Indian? How it can be?
Lordship, he has a birth certificate which is issued by the government of West Bengal. And the passport itself also issued by the India also.
I think your client has not given a proper instruction to you. Something is surprising. You read the report.
Acha, we sought documents, he's not provided those documents.
I have the application with me.
No, that's correct. You see the paragraph 2 of the report.
Reliable represent information raising question about the Indian citizenship. The office gave him whether there is any kind of discrepancy. Also, I do not have instruction regarding that.
Under observation, Your Lordship kindly sees paragraph 2.
Yes. You do one thing. You file the. You take exception.
I'll file it in the form of an affidavit.
File form an affidavit disclosing the document what he is having.
Very
Then he file the report.
Next Friday, Lordship, I'll
Let
file
the file report by way of an affidavit.
Okay.
How soon?
Lordship, 7 days.
Union Council appearing for the Union of India Passport Authority.
Your Lordship, Union of India and Passport Authority.
The respondent authority appearing for the respondent authority, file the reports. File the report. This court, after going through the report, this court find that the authority has to file the same by way of an affidavit by disclosing the documents. Accordingly, affidavit in report be filed by way of an affidavit within a period of 1 week after serving the copy to London Council for the petitioner. The petitioner is liberty to take exception to the report if any, within a week thereafter. List the matter on 18th August. Come on 18th August.
Grateful, Lordship.
Affidavit.
Deeply obliged.
Next.
My lord, I appear for state, my lord. I am led by Mr. Senior Advocate Mr. Shobik Nandi in this matter, my lord.
Who?
Shobik Nandi.
Ah.
Senior Advocate, my lord, he could not appear before due to his personal difficulties. Your lordship be kind enough to fix the matter on Wednesday, my lord.
All matter Wednesday, Thursday, then what the court will do today? Tender notice.
Tender notice, my lord. The tender was initially issued. 6 participants were declared to be the valid tenderers. I was one of them. And by such declaration, my lord, I accrued the right to be considered on the basis of my technical bid. At this stage, without assigning any reason, the tender was cancelled and a fresh tender notice was issued by clubbing the works and enhancing the tender value, earnest value, everything.
Which was given to you. Affidavit service filed by the petitioner be kept with the record and counsel for the petitioner prays for time. According cases adjourned, let the matter appear on 6th August 2020 under the same heading. Yes, next.
Work order may not be issued in the meantime.
Come on 6. Come on 6. Come on 6. Within 10 minutes, score it, na? Within 10 minutes.
Review of India, my lord.
Yes.
12, my lord, I appear for the petition in this matter. My lord, lordship had
Well, look, before my learned friend starts, I was given instruction, my lord, that the affidavit, I was instructed to file the affidavit on behalf of the respondent number 1. But due to some unavoidable circumstances, my lord, the affidavit is due to be filed by the, it was not affirmed, my lord. 1-2 days and it will
Principal amount released.
yes, my lord, that has been complied with.
That has been completed.
Yes.
So,
A very short question, my lord. Lordship can briefly
file
extend the
affidavit.
time. Yes, my lord. I'm only
how soon
praying
you
for
file the affidavit?
abridging the time.
7 days.
And then counsel for the respondent prays for time to file affidavit in prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within a week after serving the counsel for the petitioner. The petitioner is liberty to file reply, if any, within a week thereafter. Please the matter on 19th August.
Grateful, my lord.
Next.
August?
My lord, this was a matter with regard to willful defaulter. Mr. Moinangas argued with Lordship Chambers. On 19 June 26, the Lordship was pleased to pass an order directing them to file affidavit. My lord, affidavit was not filed within time, my lord. On last Thursday, my lord, they had served us with a copy of the affidavit, my lord. On 29 July, they are served. They are supposed to serve us on 10th July, my lord. My lord, I need some time to file a voluminous affidavit.
May I be
They have served us on
Yes, affidavit filed.
may I be permitted to file in court, my lord?
29 July, they have served.
Have you received?
I've received on 29 July. 7 days time, my lord. I'll file my reply. And my lord, in the meantime, my lord, the order was there, my lord, with regard to my lord, the interim order, my lord, according to this paragraph, we extended for 1. My lord, considering the above, the court filed,
The
my lord, see the
respondents have filed affidavit in opposition after serving the copy to the land counsel for the petitioner. Counsel for the petitioner prays for extension of time to file affidavit in reply. Let affidavit in reply be filed within
10 days, my lord.
within 2 weeks from date. After serving the copy to the land counsel for the respondent. This is the matter.
My lord, interim order, my lord, paragraph 6, my lord.
Is the
It
matter
will not take effect with regard
on
to the interim notice that is second May.
on 20th August 2026 under the same heading. The interim order is extended till 21st of August 2026 or until further order. Next.
My lord, I'm appearing on behalf of the petitioner in item number 14, my lord. It's a very small matter. May I be allowed to appear virtually? My lord, I'm in Delhi. My lord, it's a very small matter. My father and mother was the recorded owner of a leasehold property. They were the original lessee. Both of them have passed away, my lord. We are two brothers, the petitioner and the respondent number 5. All applications has been made to the land manager, but for some reason or other, he is not mutating the property. He has only issued one notice to us, which is at, my lord, at page 72, dated 2nd April 2024. Kindly have a look at page number 72. He only wanted certified copy of will and original certificate of probate, my lord. Everything we have submitted, we have produced the original, but still today or tomorrow it is not yet done, my lord. My brother is respondent number 5. He had a severe heart failure, so he couldn't come and be the joint petitioner. He is in the online, Mr. Shubir Bose, and my lord, let it be mutated in both the son's name of the original lessees. There are no other legal heirs and successors. We have submitted all documents.
Huh?
Like a detailed report, my lord.
Ah.
Some time, my lord.
Why your authority is asking the certified copy of the will and say once the document, the land is already mutated in
Yes,
the name of the mother,
my
father.
lord. That's why, my
So
lord.
they are the legal heirs.
Yes, my lord.
So why the old will and old license certificate?
Yes, my lord. For this,
Why?
they want to file a detailed.
Who want to file?
A land manager, my lord.
What the land manager will do? Land manager to go above the law. Then he has to see who was the earlier owner and whether the petitioners are the legal heir or not.
Yes.
And whether they are entitled to get the land mutated in their name. Then how soon he will file the reply?
In 1 week, my lord.
1 week.
Yes, my lord.
Land counsel for the state press for time to file report by a week after serving the copy to the land counsel for the petitioner. The counsel for the petitioner is liberty to with the report, if any, within a week. This is the matter on 21st of August.
March.
Next.
Much obliged, my lord.
May it please your lordship, my lord, may I permitted to file the affidavit of service? My lord, petitioner applied for the
EWS certificate.
certificate, my lord.
Yes.
And my lord, in spite of all the document is filed with the authority concerned. But my lord, the certificate was not issued to her. Your lordship kindly come.
Where is your application for EWS?
Application was online, my lord.
Where is your application? When you filed?
Yes, my lord. Application.
Page 12. What is your annual income you shown in the application?
Yes, my lord. Annual income, your lordship kindly come to the income tax certificates, my lord.
No, in
Your
the
lordship
application you
kindly
know.
come to page 23. The year in the year 21-22, annual income was 1,48,900, and according to the certificate of 23-24, income was 2,95,470. And lastly, July 24, the income was 4,47,170, my lord. It's a less than 8 lakhs, my lord. And she's entitled. And not only that, my lord, after the service of the writ petition, the joint secretary, my lord, directed the authority concerned to issue the certificate accordance with law. But till date, my lord, the certificate was not issued.
You have not got the report. Other party got the report, you have not got the report.
No, my lord. Representation দিয়েছিলাম authority.
Yes, why? Where is the representation? Where is the application?
Representation টা কোথায় দিয়েছেন?
My lord, let them consider, my lord.
Application টা যেটা অনলাইনে দেওয়া হলো।
Page 12.
Your lordship kindly come to page 13.
The grievance of the petitioner in the present date application that the petitioner has made an application to the concerned authorities for grant of EWS certificate. In spite of submission of the application till date, the authorities have not provided the certificate to the petitioner. Also, for the petition submitted, the petition has disclosed all the documents, including the income tax certificate, wherein it reveals that in the year 21, in the financial assessment year 21-22, the income was 1,48,900, for the financial year 23-24, the income was 2,95,470. And 24-25, the income was 4,47,170. In spite of the submitting the document, the authorities have not considered the request of the petitioner for grant of income EWS certificate, though the petitioner is coming and citizen. In counsel for the petitioner submitted after filing of the writ application, the petitioner has received a communication from Joint Secretary Backward Classes Welfare Department, Government of West Bengal, wherein the said authority has directed the Additional District Magistrate Purba Medinipur as well as the Subdivisional Officer Tamluk to examine the request of the petitioner and to take appropriate action in accordance with law. In spite of the direction issued by the higher authority to the Additional District Magistrate as well as the Subdivisional Officer, they have not considered the application filed by the petitioner till date. At the non-counsel for the petitioner, this court find that The petitioner has filed an application for grant of EWS certificate. The petitioner also disclosed the document to prove her income. But in spite of the same and in the meantime, the Joint Secretary, backward classes of Welfare Department of Government of West Bengal also directed the authority to examine the request of the petitioner to take appropriate steps in accordance with law. Considering the above, who is the authority?
SDO.
Who is issuing authority? DM or SDO?
Additional District Magistrate
The-
Purbo Midnapur,
The
and my lord,
the respondent number
Sub-Divisional Officer Tomlu.
The respondent number 2 and 3 are directed to consider the application submitted by the petitioner for grant of EWS certificate and to pass appropriate pass a reason and speaking order after giving an opportunity of hearing to the petitioner within a period of 2 weeks from the date of receipt of this order. It is made clear that if the authorities found that the petitioner is entitled to get the EWS certificate, the certificate be issued to the petitioner within a week thereafter. Affidavit cup is disposed of.
Here, item number 16, my lord. The amended application has been served to us.
What application?
Well,
What has happened is that we had carried out the amendment of the writ petition, Lordship had allowed that by consent. So they were to give their opposition.
Opposition, my lord, we need some time as the writ is voluminous.
How
Because
much-
we need
How much time?
3 weeks at least to the officer. We have communicated to the department.
There's an interim order here.
We are for the Union of India 1 to 3.
Against the bank and
You are appearing with Union of India.
You are 1 to 3 respondent.
London Council appearing for the respondent number 1, 2, and 3. Prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. Reply, if any, there to be filed within
3 weeks, but we are the public secretary.
within 3 weeks thereafter. Thereafter, let the matter appear on 23rd September 2026.
The
interim order is extended till 25th of September 2026 or until further order, whichever is held.
Good.
I'm appearing for the petitioner, my lord.
I appear for the Reserve Bank of
My
India.
lord, item number 17, my lord, I am appearing for respondent number 2, my lord. My lord, I am praying unconditional apology, my lord. The report which I have prepared, which could not be affirmed, my lord. I only need a 2 days accommodation, my lord. I'm praying for 2 days accommodation.
9th July order was passed today.
My lord, it was, my lord, it was, there are so many other cases, my lord. The report earlier was filed with the wrong instruction, my lord. That report I have not served, my lord. Only 2 days time, my lord. It will be affirmed today, a fresh report, and it will be.
Same matter, my lord, because the
No. They have to disclose what is the amount, what is the disputed amount.
52,000 on.
Leonard,
There is a specific allegation, my lord. Only that part I have to deal with.
respondent number 2 and 3. Praise for who is for the 3? You are appearing for both.
No, my lord. I am for the 2, my lord. 3 for Canara Bank, my lord.
Appearing for the 3. Let council appearing for the respondent number 3 and 2. Praise for extension of time to file application of report. Let the report be filed. Let the report be filed by 6th of August 2026 after serving the counsel for the petitioner. The petitioner's liberty to take exception to the report, if any, by 10th of August 2026, list the matter on 11th of August 2026.
That is the
Affidavit service be kept with the record. Next.
Lordship, the Southeast.
My lord, in item number 18, I pay to appear on behalf of the petitioner. Am I audible, lordship? My lord.
Yes, item number 18, you are appearing?
Well, I'm appearing for the petitioner, my lord.
Yes.
I am appearing for
My
the
lord.
1, 2, 3.
My lord, here in this case, the petitioner is aggrieved by the acts and actions of the banks who are acting on the LEA notices issued by different agencies. The fact is that, my lord, I have a trading account. I do trade in cryptocurrencies and I do P2P, peer-to-peer trade. And that is done in a way that is compliant with the laws and the rules in effect. I have exchanged all the documents. I have exchanged my credentials as also have taken the credential of the person who is purchasing the cryptocurrency from me. I have all the records. I have submitted all the records to the police. The fact is that one person, the private respondent herein, has filed a case against me, implicating me rather, case against another person implicating me, wherein my bank account has got affected.
Yes, you are appearing for?
1, 2, and 3.
Yes, what is the instruction?
My lord, I don't have any instruction.
Huh?
I don't
So
have.
why you are
any-
appearing? If you have no instruction, why you are appearing?
No, my lord, I am praying for filing of opposition, affidavit in opposition, because 1, 2, 3, I wish to file my opposition, my lord.
My lord, notably,
counsel
the
for
two banks, the respondent number 6 and 7, both are
opposition.
nationalized banks amenable to writ jurisdiction, but they have chosen not to appear.
Week thereafter, list the matter on 2nd September 2026. Next.
I'm grateful.
I am for my lord the WBSC DCL respondent. Last petition also my lord.
What is your prayer?
My lord, the difficulty is, my lord, they have, my lord, supplied.
Now, what is your prayer in the writ petition?
They have not supplied the full copy of the petition. My lord, if your lordship kindly come to page 9.
Okay, you are for the respondent.
I'm for the
And how this court is having the determination?
It's a, my lord, they are praying, my lord, that for disclosure of, my lord, that technical bid evaluation summary.
But nobody is appearing. As none appears on behalf of the petitioner, no accommodation is sought for. Let the matter appear in the combined monthly list of September 2026. Yeah, and then counsel for the respondent submitted on the earlier okay. No, but I recorded none appears, no? Nobody is here. None appears. No.
I'm for WBSC DCL.
Then counsel appearing for the WPSC DCL. SCDCL?
Yes, SCDCL.
SPC. Submit that on the last occasion he has appeared in the matter, but his name is not recorded. In the order dated so. The name of so will be recorded as appearing on behalf of the WBSC DCL. Yes, next.
Number 20 minutes to file this petition. And they have to file the original bid document. I know.
Huh?
Lord, then Mr. Loknath Chatterjee is appearing in this matter, my lord, as junior standing counsel of the state, my lord. They are to file the original bid document, my lord.
Yes.
Lord, kindly make it tomorrow, my lord, because I have a matter at 2 p.m.
Not today.
And my lord, let this matter be retained its position.
Next.
My lord, this will appear under the same heading.
None appears on behalf of the petitioner, no accommodation is sought for. Let the matter appear in the commandment list November 2026. Yes, who is for the petitioner?
My lord, I am for the petitioner, my lord. I am, my lord, I am a Sikha Sahak of my junior madrasa, my lord. I got a registration certificate regarding this matter, and I approved all. On reliance, I inform that another madrasa by the same name in a key distance will be established. On the basis, I made a RTI district magistrate answered me my three queries, but informed me to collect the competent authority. But competent authority of that, I made a director of madrasa education before the my advocate's letter was demand justice, but no answer was given. For this, I am praying. Kindly give the answer. What is the distance and
Why you're not prepared an appeal? How the writ petition is maintainable?
my only prayer is kindly give direction to collect the instruction. Director of madrasa education, my lord. This is my one.
Court can give direction. You applied under the RTI.
Yes, my lord.
SIPO has passed an order
Yes.
directing you to collect the document from the concerned authority. If the concerned authority is not allowing you to providing the document, you go and file an appeal before the authority, or you go for the execution before the SIPO. Why the how the writ what the writ court will do here?
My lord, only direction to collect or consider the representation.
That is the order.
My lord.
Where is the order of SIPO?
My lord, page annexure P3, page number 15, my lord.
Page number 15.
Yes, my lord. To be collected from the
Copy of
competent
the first
authority.
visiting copy so to be collected from the competent authority. Recognition letter of the establishment of the institution to be collected. Yes, plot number so to be collected. Then
I go before the authority.
where is your RTA application?
My lord, page number. Yes, my lord. Page number 20. Page number 20. People.
RTA application. Where is your RTA application?
My lord, RTI application. My lord, page 16, my lord. No, my lord, 17. 17, my lord. 17, my lord. P4. A typed copy is page number 18, my lord. Since it was not readable for this, a typed copy.
70 is not the format.
Yes, that is not the RTI.
Yes, my lord.
This is not the RTI. This is a district officer monitoring. This is something else. Where is your RTI application?
Section 6 এ যেটা করেছেন সেটা
And who is the competent authority?
My lord, director of the minority.
That's why you ask for some document. Unless and until your question is not here, so how this court can ascertain which is the competent authority?
My lord, competent authority, my lord, Doma, district, Doma, district officer of madrasa education, my lord.
Petitioner have to file the section 6, my lord, of the RTI Act. After that, he will get the answer, my lord. Section 6 file না করলে আপনি কি করে পাবেন না?
দেখুন না আমাকে
এটা section 6 এর ফরম্যাটই না।
আমি যেটা দিয়েছিলাম তার
Grievance of the petitioner in the present writ application that the petitioner has prepared a writ application before the concerned authority for grant of for supply of certain information. The district officer minority affairs Bhimphu has disposed of the application filed by the petitioner on 3rd of February 2026 by directing the petitioner to collect the information from the competent authority. The petitioner has approached the competent authority, but till date, the competent authority has not provided the document in spite of the order called by the district officer minority affairs before. In view of the above, the writ petition disposed of by directing the competent authority. Who is the competent authority? The respondent number?
My lord, respondent number 4.
Respondent number 4 has passed an order. How the respondent number 4? He is telling the competent authority, director madrasa might be. He is asking for the madrasa document.
Madrasa document.
And director
I annex
respondent
it,
number
my
2.
lord.
2 to consider the 2 to
Document.
supply the document to the petition in terms of the direction
Yes,
of the
Madam.
district officer minority affairs
Ma-
Birbhum dated 3rd April 2026 within a period of 4 weeks from the date of receipt of this order.
Respondent number 2, my lord.
For your lordship, for 21, which has gone on late. Lordship is be taken up once today, my lord, you have sent it to the monthly list. It's very urgent. I had mentioned it also.
Sir, other than your matter and 2 matters, I have called now 23 matters, only 3 matters I have heard. All matters have been adjourned. And you see the morning what all advocates are having urgent. If I am fixing the matter in urgent, but nobody is there, what can be done?
I will be here at 2 o'clock, my lord, item 21.
2 o'clock my already fixed matter
Very,
is there.
Lordship, just make it not today then, man.
Not today, Corridor. See, that's why I am not allowing the put up the mentioning. If I allow the mentioning, I put in, nobody is coming. But morning hours, 10:30, all the thousands of advocates having the urgent. Can you see where is the urgent mentioning? This much.
Sir, আমি এটা কিছু
July. Which matter? Which matter? How it can be done now? How it can be recorded? It has been uploaded. Then
My lord, my lord, may I have your lordship's leave to mention a very urgent matter? I came in the morning. Mr. Jishnu Chaudhary will be leading me in this matter. It's a matter where an order has been passed by this honorable court and a linkage auction for coal that will be starting from the 5th of August. We filed a CAN application. It is due to appear tomorrow, your lordship. If some priority could be attached, subject to your lordship's convenience.
What?
There's a CAN application we filed. There's a subsisting order of this honorable court of 30th November 2023 to allow the writ petitioner to participate. The writ petition is pending. Now we filed a CAN application because the respondent authority is giving us a vague response and would ultimately not permit us to participate and will deposit, essentially forfeit the earnest money which is deposited with the bid.
I am for the matter Coal India Limited.
Lord, if tomorrow any day and tomorrow any time it could be taken up, subject to your lordship's convenience.
Yes, next, call the list. That can, sir, sire matter, all these things, all the day it cannot be listed. Yes, call the.
This is my application.
Matter number?
I am a registered lessee, my lord, of the property in question. There are several.
I made an application for addition of public and on the last Friday, the copy of the opposition. Therefore, my lord, I should give the reply.
My lord, I am.
2 or 3 days time is required to.
It's an affidavit in opposition, my lord, in connection with the application for addition of party. My lord, I am ready, my lord, not to press the opposition. If your lordship says, my lord, I'll argue only on the application. I am ready to argue it because I can show before your lordship that straight away that the writ petition is different, they are different. I'll tell your lordship what the main controversy is. There is a building, brother. 1 second, brother. I am addressing his lordship on the merits of your application as well as mine, so that this needn't be done piecemeal. I am the petitioner. I say that I am a registered lessee in respect of the premises in question. There are certain occupants in the premises. There are certain buildings in the premises. I have obtained a registered lease after the expiration of the term of lease of the previous lessee. That's my learned friend's client. After getting the registered lease, I have made representations to the West Bengal Fire Safety Authority saying that though there is activity and commercial activity going on from various buildings and structures there, such building and structures are unauthorized, and even otherwise, no fire safety certificate within the meaning of section 12 of the West Bengal Fire and Services Act, Emergency Services Act, has been obtained from the fire authorities. No steps have been taken by the fire authorities despite my representations till date, and hence, my lord, my writ petition, according to the West Bengal Fire Services Act, no premises in any area where this act is in force shall be used for the purpose of storing or processing at any material point of time any hazardous substance unless the owner or occupier thereof shall have previously been granted a license by the collector. This is an absolute bar. I have presented, my lord, the representations to the authorities. They have not acted, and therefore, my lord, this writ petition. Even if the authorities have acted on paper, which they might come and show your lordship, on ground the activities are continuing, and according to me, I have a right to intermeddle in the activities. Objection has come from a non-party who is applying before your lordship to get intervene in the writ. Who is the non-party? Admittedly, from his application, if your lordship kindly sees just scan one just once, I will not prolong this much further. Admittedly, from his application, he is a previous registered lessee. His lease has expired, and today there has not been any renewal granted to him, nor any extension granted to him. In such a situation, he says that my attempt to get orders in this writ petition is without any locus, because
he is the lessee. To which my reciprocal submissions are threefold and very short. Number one, under section 111A of the Transfer Property Act, when his lease has expired with efflux of time, from the next moment he does not have any further right. He only has the right of one thing. If he is in physical possession, which he is not, because there are certain occupiers who have built buildings who are in possession. If he himself were in physical possession, the only thing he can say is, until a decree of eviction is passed against me, I should not be evicted without due process of law. That's his only right. He can't create any further tenancy. He can't keep on enjoying any rents from ex-tenants which he had under him. All that is gone. Today, in my writ petition, where I am admittedly the subsequent registered lessee, there can be no question of my learned friend stepping into the array of parties in the writ petition, because no legal right of my learned friend can be said to be infringed. I am not asking for his dispossession. He is not in physical possession of the leasehold. Second, application for addition of party.
How you are in occupation of?
I am not in occupation. I am not in occupation. No. Let's be very clear. I am not in occupation, and the Transfer Property Act permits me. One of the obligations of the lessee under section 108 of the Transfer Property Act, lessor, is to give the lessee physical possession immediately after execution of the registered deed of lease. Correct. Which means that in India, it is possible that a lease be registered in favor of me if my learned friend was the ex-lessee and still in wrongful possession.
If the lease deed is registered in your favor, you are not in occupation of the property. So what prayer you are asking before this court?
The prayer I am asking before your lordship is this, twofold. One, there are buildings and structures on the property which are unauthorized. They do not have any prior sanction plan of the municipal authorities. They are illegal.
Who are they?
These are, my lord, the occupants who are there. I have mentioned, my lord, their names.
They are the party here?
Yes, I made them parties. Kindly see, my lord, paragraph.
No, they are the party?
Yes, 12. Respondent number 12 to respondent number 19. Kindly see, my lord, paragraph, pages 4 and 5 of the writ.
12 to 19.
They are the parties. They are the persons who house various structures and buildings in the premises. And there is a fire department report, my lord. Kindly see, my lord, page 92 just once. All occupiers were made parties. All occupiers were seen. Now, my lord, it's at 92, 31st of January 2025. There's a report to the divisional fire officer by the officer in charge, Kamarhati Fire Station. This is intercept between the fire authorities. As directed, an inspection has occurred on 19th of December at about 11:30 in the presence of authorized persons. 8 numbers of establishment at the above address. Remarks. Kindly see. License found not valid. License found not valid. Applied for RFSL. Updated license found. Next is area mentioned. Applied for RFSL. License not found. License not found.
What is the prayer?
The prayer is the activities of which offend.
Who is appearing for the private respondents? You are appearing. Yes.
The activities which offend the Fire and Safety Act, the authorities have to do 2 things. Number one, ensure that those activities are brought to a standstill immediately. Fire cannot await any further documentation coming up after 6 months or 8 months. Number one. Number two, my humble submission is therefore, my lord, the fire authorities be directed to take immediate steps to stop the activities. Secondly, and close on their heels, the fire authorities may make an inspection and also take appropriate criminal steps and prosecution against the persons who are running this show without getting the licenses. Well, these are my humble submissions.
Yes.
Please come to page 194 just once before Mr. Vishwarup Bhattacharya takes over. His setup person isn't doing too well today. 194, my lord, annexure P5. Please come also, my lord, to the notice under section 218 of the Municipal Act. Kindly see, my lord, the occupiers' names are there. Aditya Purohit onwards at the top left-hand side. Aditya Purohit, Priyaranjan, so-and-so, last is Gopal Bagri. All of these are private respondents. Whereas the councillors are satisfied that you have constructed the few numbers of buildings and structures violating the Bengal Municipal Rules 2007 at the above premises without obtaining sanction plan from our end. You have acted in contravention of section 204 of the West Bengal Municipal Act 93, which is an offence punishable under 218 of the Act. You are therefore directed to submit your explanation in writing within 48 hours. Now, my lord, kindly see page 195. Another letter has gone, my lord. This is the earlier letter was 25th of May 2026. This is also 25th of May 2026. Once again, my lord, it is underscored. Kindly come to, my lord, similar letter, only, my lord, the last but one paragraph. You have acted in contravention of provisions of section 204 of the West Bengal Municipal Act 1993 and thereby committed an offence punishable under section 220 of the said act. You are therefore requested under provisions of the act of sections of the WBM Act to stop construction, if any, of your construction forthwith, failing which action shall be taken. Now, my lord knows, my lord, section 204 of the West Bengal Municipal Act is prohibition of construction without any sanction. Is equivalent to section 400 of the Kolkata Municipal Corporation Act, and notices have gone out to each of these occupants saying that they have made unauthorized buildings and they are carrying on their activities there.
Yes.
So today, prima facie, before your lordships, two facts are there. Number one, that each and every building of the occupiers is unauthorized. Municipality has held the same to be so. Second, that each and every occupier is carrying on activity which falls within the mischief of the West Bengal Fire and Emergency Services Act without having any valid license in their favor.
Yes.
Now, my lord, my humble submission, if your lordship kindly takes, my lord, my writ petition just once. I have made a number of representations. May I take your lordship, my lord, to the prayers? Our representation is at page 197 of your lordship's brief. It basically summarizes, my lord, what I have submitted before your lordship. I have brought on record, my lord, the findings, my lord, of the municipal authorities as well. It's a lawyer's representation of Mr. Ashish Dotto, which my lord will find at page 197 of my lord's brief. It has been sent, my lord, to the fire authorities on 15th of June 2026. Today we are in the first week of August, so more than 1 month's time has expired. Now, my lord, my prayers, please come, my lord, to the prayers that I have. I have sought, my lord, basically for action to be taken by the fire authorities to stop the illegal commercial activities. That's my prayer A, mandamus. And I have also sought for directions upon the fire authorities to seal those buildings so that the activities cannot be carried out, because it's a question of life and death. Fire is not a thing to be played around with. C, Millard, I have also prayed for lodgement of criminal prosecution under the Fire Services Act for those persons who are continuing with the act of unauthorized work from these illegal constructions.
Yes.
And my interim prayers are of the nature of K. K, my lord, if your lordship sees, page 24, J and K, if your lordship wants to go in for interim consideration. Otherwise, lord.
Yes. Who is for the municipal authority?
Regarding sealing, just one second, sir. My lord, 37A just once of the Fire Act, sealing. I have sought sealing. Question is, am I entitled to seek sealing, or are they entitled to seal? This is 37 capital A of the West Bengal Fire and Emergency Services Act. And the word used is shall. So if any activity is being done without a license, dehodes the provisions of the act, then the director concerned has an obligation to shut it down, to seal it up, so that it does not imperil the lives and properties of persons who are in and around the premises. This is a fire hazard waiting, my lord. It's an inferno waiting to be implemented. Please take appropriate steps, my lord. My humble submission, please pass appropriate orders on them, my lord, to stop the activity straight away. 191. We had, my lord, submitted, my lord, a representation, my lord, and from the fire safety authorities, there's also a page 91. The divisional fire officers has written to the Director General building, where it is stated as follows, page 91. I'll just end with this. Page 91, divisional fire officer writes to the Director General, who's the head. Submission of inspection report at 38 BT Road, No.24, Parganas. In view of the complaints raised, respected sir, in response to the memo under reference, either undersigned or directed to occur an inspection and submit the report. Accordingly, officer in charge Kamarhati has inspected the site. Now, my lord, third paragraph. The said premises is abutting 30-meter BT Road in the said area. There are 8 numbers of buildings, 2 numbers G+1 storied, 5 numbers single storied, and 1 number shed based found, which are made up of brick walling and RCC roofing, and also brick walling and tin roofing. The said building is being used and running by different kinds of small scale business entities by storing hazardous materials like garments, wooden blocks, plyboards, cartons, etc., without proper and valid fire safety R oblique FSC oblique FSL, neither certificate nor license. Accordingly, the owner of the said business entities have been served notice under section 35 for violating section 11C and 12 of the WBFS Act 1950 with up-to-date amendment submitted for his kind information. So action in terms of paperwork has happened, but at ground zero, nothing has moved. Each of these 8 buildings, as I am submitting today, are carrying out hazardous activities of storing materials. It's a finding of the fire officers here. This finding, my lord, cannot be contradicted because anyone who goes to the spot will see the same. If the constructions are all unauthorized,
You
and
are appearing for the
they are required to be
authority-
stopped.
Municipal authority? Yes, what is your instruction? Huh? Huh. Hmm.
May I get one?
Yes, I will hear all of you, no problem. Yes, which was fire service? Yes.
Instruction given for yesterday, madam.
What is your instruction?
Instructions are that, my lord. One Mr. This is Krishna Kumar Memani. They had applied, however, for this. I have access.
No, with regard to the paragraph.
I have asked them.
Sir,
Give them
with
the
regard to the page 91 and 92, what is your submission? 91 and 92? It is your letter?
Yes.
Yes. What is your submission on this?
Sir, on record, whatever this is my letter.
So what
Personal file. This
so
is
what information instruction you got?
from the one Mr. Krishna Kumar Memani, my lord, he had applied online. We have asked them to give the sanction plan. So that has not yet been given. Well, this was on. The applicant is here on 3rd July. We send them. The applicant is hereby requested to submit sanction plan drawing to this office as early as possible.
That is with regard to the one. And what about the other 7? Page 92, there are 8 persons.
There are total 8 persons.
Yes.
So, with regard to what?
One with regard to whom? Krishna Damani is Krishna Engineering.
No.
Ah.
Krishna Mamani is not here.
Then
He has applied for addition of party.
that is with regard to you come with the 91 and 92, give the answer.
91 and 92. Check. But sir, only with Krishna Mamani who has sought for application for addition.
Krishna Damani is not.
Appear in 91, 92.
You have issued the notice to 8 persons. With your allegation that the license was not valid, they are not having the fire license. So what you have done after this? This is January 2025.
Thereafter we took a
What steps? Whether this factory has been closed?
No.
Then what has happened?
But after that we have done a inspection. Kindly come on the inspection report which is 31st of January 5. The occupancy is an industrial occupancy. There exist 8 numbers of single-story manufactured and state occupancy. At the time of inspection, it was found that the occupancy and that premises do not have appropriate adequate fire prevention measures and remains non-compliant with the safety regulations. Such type of occupancy comes under the purview of section 11 or section 12 of the West Bengal Fire Services Act 1950 is up to date and hence notices under section 35 of the West Bengal Services Act 1950 was issued on 25th of January 2025 and again on 18th of May 26 to the proprietor owners of all these 7 persons directing the compliance of the fire safety rules. After receiving the aforesaid notices, the defendant office that they have applied for fire and applied for fire safety and fire license and renewal of fire license by the 2026.
Terms of what?
An application for fire safety recommendation has been issued online portal, but that is not written this. So this is what I've got this.
Yes. Yes.
And you know, the date is 27 February.
Yes.
What it says, last paragraph, last sentence, according to the owner of the business, serve notices, task to date, and then. And thereafter, we have these documents, first of all, these documents find place in the reputation. Kindly ardently proceed with the petitioner and important information. A roundabout attempt to get rid of user a surreptitious. Because regarding this license part, it is for Mr. Das's client, the government state to take care of. But they have taken care of them. After this state surreptity, they have served on you this notice. 80. It is a part of the application and 110 of the application. But it is the only document that we have received.
110.
110 of the can of my can. I'm told ordinarily I'm not looking to the can because I'm not.
Yes.
110 doesn't change it at all.
Same
Same
thing.
thing. 110, the same thing.
So please see the reference is the page. So page 72 is 292.
Mr. Bhattacharya, whatever it may be, as on date, there is no fire license. You have, show me. That's what I'm asking. If you got the fire license, then matter ends. If you're not having the fire license, then I have to see. Sure. Yes, you're not having, then I am passing order here, Stop the business. Because from the submission of the respondent authorities, I find that they have closed their eyes. The fire authority have closed their eyes. After filing of the writ petition, now June they have issued the notice.
I'm indicating it to you. And all the other entities, have applied for renewal. And the fire authorities have for
So this is of steel fabric,
steel fabric is
automobile parts, plastic, no. License there is fabric.
Steel fabric has a license. Balaji creation has a license.
Balaji creation. Yes.
And the remaining, we are covered by 18 weeks.
No. This was issued on 9th June. So it is valid up till 27 January 17 June 2027. Okay. And just a minute. That is with regard to the steel fabric. And Balaji is having the license of 24, 27. So how the notice was issued on January 25?
Difficulty.
The authorities have perhaps persuaded by Mr. Banerjee's client.
এই সব শুধু ওই প্রেজুডিসের সাবমিশন এই জিষ্ণু থেকে শিখে
So that the
হ্যাঁ
board of the property, he does not have pressure. And
You don't worry, the court will not disturb the possession. Only the court will see whether the building can be demolished or whether the you challenge this. If the true cause of action, one court can taken into the matter. That's why. Now, if you are taking the plea with regard to the determination that you challenge, I will pass an order. If the true cause of action, the group 9 can take the matter. The court can take the matter.
There are orders. He was about to. He was about.
No, that's why for correction, I may commit. Okay.
He was about to challenge almost.
Always.
No, that's all right. That's all right. If legally available, always, no difficulty. Unlike him, my lord, I don't make submissions on prejudice.
Please. Yes.
কি হলো কর না মামলাটা কর না ডান্দিক বাদিক না করে তাও মাল্টিপল হলে গ্রুপ 9 এ মেইনটেনেবল হাইকোর্টের জাজমেন্ট আছে
Please,
I'm
you
sorry,
take your seat.
your extension issue is not stopping of my business. Closing, they have to pay, invite your lordship to PSG, calling an inspection. Not so far as the illegal construction part, we have some answer somewhere, this is the existence since 1983, 84 of all these structures, and this is none other than Kamarhati municipality. This is none other than Kamarhati municipality. The same municipality will not be cases, maybe not for.
Okay. With regard to the building, if it is non-sanctioned plan, then let the municipal authority come with all the documents. We'll see to that. With regard to this fire safety, that is very serious. That is very serious in nature.
Two of these entities.
Two of its entities
Have all applied. There are fire authorities.
Okay, apply let the.
Once again, please keep it 110. They have asked not to allow anyone to stay there during the night, and apart from the night guard.
Why night? Why you without the fire license? Why you how?
We have to count. We have paid the money. We have done everything.
Okay. If you have done, why the license has not been provided to you? That's why. That's why before you opening your mouth, I told that I will not take any benefit. I will not get any instruction from the authority. Authority has closed their eyes. What the instruction? What the instruction means? The learned advocate appearing for the authority is stated before this court. Maybe.
The intervention of the writ petition.
I don't know. That is.
Are sitting tight over this entire issue. This issue is continuing not now. Please, when we are obliged to take license, but first of all, what does people say? There are activities. It is not that there is no endeavor to adhere to law. There is a clear cut endeavor and strict vigilance. We have applied for, we have paid the fee, we have done every possible thing, so as to adhere to whatever is obligatory on us. The fire authority, after receipt of this application, please see my chief page document that I have handed over. There is a letter by all of us, which says that we have adhered to your requirement. Please issue the license in our favor. Two of them have already been issued licenses. And all of us have licenses. It's not that this is the first time this application is being made. It's been renewed.
So that's what I'm telling. If you show the renew, there is no question. If you're not having that, but you're shown. And the second part is that the document which is the page 92 and the document which you have produced with regard to the license. Page 92 says the steel fabricated having the automobile parts manufacturing, and the document, the license which you have produced with regard to that author, this steel fabricators, that is with regard to the steel fabricators. Steel fabricator, that is the plastic powder and garnish and plastic products.
That is the product of the.
No,
It's a storage
no.
license.
And this is page 92.
Where is the-
You deals
correct.
with the automobile parts and manufacturing.
Customer, take it, your lordship, record my submission, 92, 72, 85, 91. Have never ever been served on me, apart from page 110, that is 18 page. Nothing has been.
No,
served.
this is not served to you. This is by the fire officer to the division officer.
Document from one authority to another.
Correct.
And the restriction of the special privilege over these books. We don't have.
Correct.
We don't have. You know, kindly.
No, Mr. Bhattacharya, you are telling that steel fabricator having the license he might be having 2-3 units of the business, but the license which you have not produced before the authority with regard to the automobile parts manufacturing, which license you are relying upon,
I need to come back.
relying upon. Relying upon.
Submission, that they are manufacturing this or that.
Correct.
I need permit to come back tomorrow, place it under the documentation, or any time convenient, the court will answer you. Tomorrow, day after, whenever it suits your lordship.
And that is as a warehouse and workshop for restoring the process. And
That's a storage license.
storage license.
Storage license.
This is storage license.
This is not a fire safety certificate at all.
manufacturing license.
That's a storage license.
What is on the document is on the document. He is trying to present the repetition in a very nice way,
No,
so that he gets rid of me.
I am
so that, my business
this court has to go by the document. The document which is appearing at page 92, eight firms, steel fabricator, you are telling that steel fabricator is having the license, but that is with regard to the storing. Yes. Yes. Hmm.
I come and answer your lordship. Each and every.
And that is also the Balaji creation. Balaji creation also is manufacturing the garments manufacturing, but this is with regard to the warehouse storing. Storing license. Okay. Unit might be one.
I'm so confidently. But the license is given for the warehouse.
Yes. Warehouse.
The warehouse, not for the business.
Running the factory is different thing. Having the workshop is different thing. Having the warehouse is a different thing, sir. Yes. What is your locus? That you go to the civil code. That you go to the civil code. That you go to the civil code. Declaration of title, permanent injunction. Pending. Okay, no problem.
It's for default application for restoration.
Yeah.
That's his.
The grievance of the petitioner in the present application that the officer in charge, Kamarhati Fire Station, by a communication dated 31st of January 2025, informed the divisional fire officer that the 8 firms, namely Steel Fabrics, Tejas Enterprises, Singh Fabrics, Balaji Creation, Magnum Prints, Joy Ma Kali Timber Company, and Krishna Engineering Works were not having the license. We are not having the license. Full stop. To run their business. Not having the fire license. Full stop. The counsel for the petitioner further draw the attention of this court has submitted that. Yes, where is the municipal notice? There is no notice of the municipality. the counsel for the petitioner further submit that the Kamarhati municipality had also issued the notice to the owners or occupiers of the premises under section 202 of the Bengal Municipal Act on the allegation that the building construction is not having the sanction plan. The full stop. Counsel for the petitioner further submitted that the petitioner also made a representation to the authorities for taking appropriate steps for running the business without the fire license and the construction of the building without the sanction plan, but the authorities have not considered the same. Mr. Bhattacharya, learned advocate appearing for the respondent number 5 to 12. 12 to 19 has handed over the two licenses of steel fabrics as well as Balaji Creation and submit that these two firms have got the license from the Department of Fire and Energy. This court perused the said licenses produced by Mr. Bhattacharya and found that that is not with regard to the business, that is not with regard to the business of the said firm. That is with regard to warehouse of the workshop and for restoring the process, not with regard to the business dealing mentioned in the notice dated 31st of January 2025. The learned counsel appearing for the municipal authority submit that the municipal authorities have issued the notice to the owner or occupier of the building with regard to the illegal construction of the building over the property, but due to the resignation of the chairman, the hearing could not be completed and the proceeding is pending. Land council appearing for the fire authorities press for time to take appropriate instructions and file the report. Consider the submission made by the council for the respective parties. The fire authorities are directed to submit the report with regard to the present status of the business of the private respondents number 12 to 19, whether they have obtained the license after the issuance of notice dated 31st of January 2025.
On 12th of May 2026.
Which one?
We have complied with 12th of May.
Correct. I am in terms of notice, and the municipal authorities also directed to submit the report how soon the proceeding will be completed. Let the report be filed within a week after serving copy to the land council for the petitioner. The petitioner's liberty to take exception to the report, if any, within a week thereafter. List the matter on 21st of August 24th of August 2026. Under the same heading. Under the head so specifically na under the heading urgent motion.
May I take back those documents? I'll produce photos.
Urgent motion.
Only one prayer. Question of interim relief we kept open. Question of interim relief we kept open.
Yes, this court has not considered the interim relief at this stage.
The same is kept open. Otherwise,
at this stage, not considered.
Milord,
you have taught me something other.
Milord, I have been allowed to add parking.
Your application is there. I will see to that. I have not decided your application.
Yes. May I take back those licenses?
Yes.
Somebody is going to hand it over to us. Let's stop 5-10 minutes.
Let's call the next.
License copy আমরা পাবো না এফিডেভিট করে দেবে তো Milord, may I have
come on then. Let the report come, you will get all these things.
My lord will take cognizance of the report না ঠিক আছে
And why is Mr. Banerjee so over?
Give the copy I recorded.
Copy in the record.
10 minutes.
Yes, next.
Grateful to Lord.
24, my lord, I am led by Mr. Prasad Mukherjee, my lord.
Lordship, I beg to appear for the petition. I am being led by Mr. Ramokar.
Court, my lord, will file, my lord.
Yes, you received the report.
Yes, my lord.
You received the report.
My lord, we have received, my lord. My lord, the thing is, an exception is to be preferred by us. I believe the direction was there. Now the exception was duly affirmed on 29th, but the original copy, the learned advocate on record.
Record and order.
Here today.
The Land Council for the petitioner, respondent has filed report after serving the copy to the Land Council for the petitioner. Council for the petitioner prays for time to file exception to the report. Let the exception be filed within 2 weeks. List the matter on 27th of August. Next.
Sir, I did 25, but I am for the petition one. I am late by Mr. Doctor.
My lord, I am appearing for the department.
Yes, madam. What is your instruction?
My lord, my instructions are that as yet the authorities have not decided to take any action against my learned friend. My lord, there is some procedural things are going on. It will take some time. So let my learned friend wait for some time. Your lordship can continue with the interim order.
But my problem is that an interim order is may serve my purpose for the time being, but we have so many about 50 pumps are lying ready, but that is not being taken.
But I have told them, my lord, because my lord,
I've invested money.
My lord, there is some communication is required to be done. For this reason, my lord, it is not being lifted. Let my learned friend wait for some time, my lord, it will be done.
But my lord, the considerations are elsewhere.
I told you.
I mean, after all, it's a commercial venture. I invested money. I want return of for my investment. I mean, this is, my lord, but there are other matters, my lord, waiting for your lordship's consideration.
And
Same thing with only this party.
Not be apprehensive of. In fact, it is a premature. We have not taken any action.
Mr. Datta, you are getting some clue from the other.
No, I have got the clue.
That goes very well, my lord. Out of court, we have spoken, my lord.
No, she has been very kind enough to, my lord, disclose her.
Learned Council for the respondents on the instruction submitted that the respondents have not taken any final decision and they will not take any coercive action against the petitioner for the timing. Accordingly, grace for time. As it is the contention of the respondent that they will not take any coercive action against the petition, the case is adjourned. Let the matter. How soon you will file affidavit, file report?
4 weeks.
The
respondents are directed to file report within 4 weeks after serving.
But let my learned friend use our good offices to.
But I'll try to. I have told him I'll try to.
Maybe 2 weeks
Within
or
3
3
weeks.
weeks. 3 weeks.
Within 3 weeks. Affidavit कर दो, report मत करो. Affidavit within 3 weeks. Reply if any there to be filed within 1 week. 1 week. List the matter on 8th September.
8th September. Because there is another matter between the same parties, Millard, almost Millard, same action. Your lordship was pleased to, Millard.
The respondents are directed not to take coercive action for till the next date of hearing. Yes.
281.
Under the urgency, same head.
180. But in there is another matter between the same parties where my allegations are same in respect of another product. But I was paying it on the returnable date. Millard, in the other matter, where I have got an interim order in my favor, which is continuing. May that matter be, Millard, be placed one after the other with this matter?
Yes.
When the date is.
But that is in today's list as item
218.
218.
So it can be called on.
Achha,
Both the matter can be tagged together.
Yes.
In your
My lord,
you are having the interim order.
Will not take together. It will be one after other.
One after the other.
It is submitted by the Land Council for the parties that item appearing at 218 of the today's list being WPA 13581 of 2026. We also is between the same party and prays for fixing the same matter along with this writ petition. Let the WPA number 13581 of 2026 be placed analogously along with the presented application on 8th September 2026.
Only if you but in the, she wants one after the other. That can be done.
Analogously, I told.
No, she wants
one after another.
The only thing was in the other matter, the interim order is still 27th of August. This may be extended, Millard.
Then you mention that. I will extend it. 27 you mention, I will do. Keep note of it.
But the problem is where my lord has been pleased to fix it on 8th.
8th August, you mention, I will extend.
Or your lordship can
Today.
extend it.
Extend?
Yes, yes, no.
The interim order in WPA number 13581. 13581 of 2026 is extended till 8th of September 2026 or until further order, whichever is served.
But could these matters be a bit higher up in the list, my lord? I'm so
Okay,
sorry.
so, September.
My lord, let my London wait. It will inure to his benefit.
So not necessary of hearing.
Very well.
Yes.
Not necessary of hearing.
A good old friend of mine giving good suggestions. I'm grateful. my lord.
Yes, next.
Wait.
I am waiting for the respondent number 2 and 3.
The gist of the case is this, to make a mountain of a molehill. It was very short matter.
I will present respondent numbers 2 and 3, my lord, in this matter.
But
That's not one, my lord, union of India matters.
but a poor litigant, a poor cultivator, his land has been
How
encroached.
the litigant can be poor?
But poor litigant, his only source of income, that is the cultivation land, that has been encroached by the HPC without providing single compensation. This is my case, my lord.
Who is appearing for the HPC?
Well, I represent Hindustan Petroleum Corporation, my lord. But my submission is the writ petition is not maintainable, my lord.
Why?
But under the Petroleum and Minerals Act 1962, my lord, but if they are aggrieved, my lord, under Section 10, my lord, they have to approach before the learned district judge, before the local district, my lord.
Oh, my lord, if I am aggrieved by the decision, but they are not giving single bill.
My lord, I have taken instructions to that effect, my lord. We have passed the compensation. We have also tried to communicate the quantum of compensation to the petitioner, my lord, but they have refused to accept it, my lord. My learned junior is there, my lord. He can hand over the copy of the quantum of compensation that has been awarded, which has returned back with an endorsement refused. But now, at this juncture, my lord.
But Section 10 says.
No, you passed an order for you refused to accept.
So 19th of April, my lord, we tried to obtain, my lord. Well,
Take instruction.
Yes, my lord. Then
you have a copy, access copy. Extra copy you are having.
But I don't have that instruction, my lord.
Take. 2,94,070 rupees. 2,09,470 rupees.
But my lord, situation is
this.
this.
The check was also made ready to be handed over, which they refused to accept, my lord.
Yes.
My lord, the check was also made ready to be handed over to the petitioner, which they refused to accept, my lord. But that is indicative in that letter.
But I have to take instruction, my lord.
Take instruction.
Yes.
Check is also ready. Yes. Come and take the check. Now that then your client will not be poor. And council appearing for the HPC. Submit that. The HPC already passed an order awarding the compensation dated 19th of April 2025, but the petitioner has refused to accept the same. The copy of the order dated 19th April 2025 is handed over to Land Council for the petitioner. Land Council for the petitioner prays for time to take instruction. According case is adjourned. Let the matter appear on. When you will come?
1 week.
Let the matter appear on 13th August 2020.
Grateful.
But maybe little higher up on the list, be very short matter, my lord, won't take much of lordship's time, my lord. I leave it to your lordship, my lord. I'm obliged.
I am appealing for the petitioner, but I am late by Mr. Joydeep Kosh, senior advocate, my lord. He is engaged in addressing courtroom number 3, my lord. And I am praying for.
What is the matter?
Matter is, my lord, I am praying for implementation of street vendors protection and protection.
Implementation of?
I am praying for implementation of Street Vendors Protection and Livelihood Act. My shop has been ingress and egress of my shop has been encroached by the hawkers. The hawkers. Yes. That is my.
So against whom you are asked for the? Again, who are the authority to take?
KMC is the implementing authority.
How this code?
Residuary, since, my lord, the Street Vendors Protection and Livelihood Act does not comes under the KMC, my lord.
But you are asking for the municipal authority, direction
Yes,
about the
yes, my lord.
municipal authority.
Yes, my lord.
Then,
Since the act, the code number 3 has determination of KMC related municipality. This is not a municipal act, my lord.
Other matters-
Maybe, my lord.
Other matters related to the same act is also pending before that.
pending before the authority. It is, you are asking for direction, maybe you are the street hawker,
My lord,
but you are asking
since
for
it is
the
not a-
implementation by the KMC. If the implementation of the KMC, how this court can do that?
He is not the street hawker. He is the one.
Yes, I am a owner. I am a owner of a shop.
Owner of the
Yes,
shop.
I am a owner of a shop. Yes.
So you are asking the municipal authority to take appropriate steps.
Yes, my lord. It is the duty of the municipality, my lord. But it is not on the KMC Act, my lord. My lord, kindly appreciate.
So under which act you want to want that eviction? Under which act?
The Street Vendors Protection and Livelihood Act.
Livelihood Act, whether the municipal authority has given the right.
Yes, my lord.
Show which law. Show me which law. Which section? Which section? Eviction of the street vendors. Which section you are? Municipal authorities have the right to evict you.
It is the local authority who has right, my lord. The local authority has been described, my lord, in under 2C of the act, my lord.
Under
2C of the act has been defined, my lord, local authority.
Correct.
It has been defined local authority has the right to evict, right to regulate, my lord.
Correct.
And local authority has been defined in
Municipal corporation or the municipal
corporation.
So go to the municipal that court. How this court?
So since this act doesn't come under Kolkata Municipal Corporation Act, my lord, any municipal act, my lord, that's why I have filed before this honorable court, my lord.
Where is that? Appellate side rules? Appellate side nahi. हाँ मोटो
तीन नंबर को नहीं
लगी से दिखेगा गोल से
I'm trying to
साइड है और साइड appellate side.
Hearing under codices functioning to
No,
municipality.
this is yeah. But I'm led by Mr. Kaur in this matter, my lord. He is on his legs right now.
How? Which one?
My lord,
How this court?
my lord, there are, my lord, beyond, my lord, the municipal laws, my lord, some other issues are also involved. My lord, that is why, my lord, it has been, my lord, filed here.
No, you are asking prayer upon the municipal authority to remove the street hawkers from the in front of the shop.
Yes.
Correct. In front of your shop. So if the municipal authorities are done, how this court?
Well, there are multiple facets involved in this matter. My lord, the 2014 Act, as well as, my lord, the 2018 rules. My lord, the liabilities are not just municipal liabilities. My lord, there are other issues involved. Because, my lord, it also creates a threat to, my lord, the life of the persons, my lord, using the footpath. My lord, there is a, my lord, this has been, my lord, something which has been decided, my lord. My lord, may I, my lord, make one prayer, my lord, whatever order, my lord, passes, my lord, without Mr. Kaur, my lord, kindly gives a day's time, my lord, or, my lord, a short passover. এখন তো আর নিয়ে লাভ নেই। My lord, keeps it not today, my lord, kindly.
Not today.
And, my lord, because, my lord, Mr. Kaur is, my lord, otherwise I would not have made this prayer, my lord. My lord, can it retain the position? Grateful to you.
Not today. Next.
But before your lordship takes up, you will
not today.
Have this copy that page number. হ্যাঁ দুটো
Yes, my lord, I beg to appear, my lord, on behalf of the writ petitioner, my lord. Last occasion, there was an order passed by your lordship. My lord, if your lordship kindly sees, there was a direction, my lord, upon the state respondents, my lord, to furnish the report. My lord, if your lordship kindly sees the order passed by your lordship.
That this is the affidavit of service. Respond.
Yes, my junior is there, my lord. She prepared the affidavit of service. Now, my lord, we have served.
Yes. And for the pollution control board. I am for the central pollution.
Who has issued the impugn order?
The district magistrate.
District?
Magistrate.
Magistrate, yes, madam. District magistrate.
So it is sub-divisional.
Subdivision officer.
SDO. Now you cannot say not receive. Kindly see the affidavit of service, and there is a specific order to serve to the office of the government feeder. Your feeder has received. Received.
Very well, my lord, I will appear.
Yes. So file report.
So they are, my lord, also enjoying the interim order. So kindly give us.
Yes, my lord.
Learned counsel for the state press for time to file report. Let report be filed within 2 weeks. Within 2 weeks after serving the copy to London counsel for the petitioner, the petitioner's liberty to take exception to the report if any within a week thereafter. Full stop. This is the matter on 26 August 2026.
Yes, my lord. The interim order, my lord, be extended, my lord.
Order is extended till the next date of hearing or until further order. Which
Grateful.
I'm grateful, my lord. I'm grateful.
Item 29.
Close. Original site.
Lordship, only one indulgence, item 30, Lordship, there was a direction to file the affidavit.
29 close করে দিল।
কি close করে?
নেবে না just
Lordship,
And at number 30 minutes.
affidavit in opposition was served late. We are also running late to file the affidavit in reply. I'm praying for some time to
How soon you file the reply?
Lordship,
আজকে দেব না কালকে
You got a no, 30.
grateful.
Next date.
No, item was 29. I'm for the 29. I'm for the petitioner.
For the petitioner.
Lordship, 29, I'm
He has received the affidavit in opposition, but he placed for 2 weeks time to file reply. Let reply filed within 2 weeks. This is the matter on 27th of August 2020.
Well, in 29, I'm for the petitioner. There was a prior direction for filing a report by the responding authorities.
Yes.
My lord, I am
29.
item number 29.
Come tomorrow.
My lord, item number.
Wait, I'll come to you.
Come tomorrow. Whichever not taken today, it will come tomorrow.
With a lordship leave, may I be permitted to mention an organized matter?
May I have the leave of lordship to mention this? My lord, may I have the leave of lordship to mention this original side matter, my lord?
Yes.
Item 149, that is appearing today's list, my lord. That appeared matter on Saturday, first hours, item 4, my lord. That could not be taken out by your lordship, my lord. I am only praying a subject lordship pleasure. That may be taken up on any day, my lord. That may be taken up on any day, my lord. That was appearing on Saturday, item number 4. That could not be could not be taken up by lordship, my lord.
Ah.
Therefore, I am praying.
It could not be taken up by him because the court was playing here.
No,
cricket.
no, my lord, since that could not be called, my lord. I am praying at least on any day, lordship will take the matter, my lord.
It is in the list, it will come.
My lord, item 49, 149, my lord, that could.
That's why if you persons allow this court to hear the matter, automatically the matter will come on serially. But you persons are not allowing this court every day mentioning my matter me top, my matter me top. By that way, the top matter will go down.
My lord, I only submit this is a contempt matter, my lord, and contempt rule was issued on.
Contempt application में तो है ना? Then contempt application number 1 matter is there. So what can be done?
That is why
contempt application cannot be as an item number 1, sir.
No, I am not. I just accept some recommendation be given. That I am praying, my lord.
What?
At least that may be fixed on any day.
Let us see. Let us see.
I be permitted to mention item number 147 of your lordship's daily list today for tagging the matter along with the other connected matters. Your lordship, this is with regard to challenging the revocation of the incentive scheme. Your lordship had directed the connected matters with respect to this on 8 September.
Taken, we'll see to that. Yes.
Your lordship, may we come to your lordship. I am the member of the Legislative Assembly, your lordship. The writ petition was filed on 28 July 2026, your lordship. The matter is returnable on 5th August, your lordship. The session of the Legislative Assembly will be starting on 17th, your lordship. I'm only praying for abrogation, your lordship.
You're telling the 5th August it will be listed. So what further?
The urgency is that the matter will, the assembly will be starting from 17th.
What is the prayer? What is the prayer in the writ application?
My only prayer is that I'm not being, the assembly is, the speaker, honorable speaker is not letting me to permit in the assembly, your lordship.
What the court will do? It is returnable on 5th.
5th, your lordship.
Okay, see if the 5th it is listed, it's listed, not listed, you mention, we'll see to that.
Your lordship, I'm grateful.
Also, take later also.
Item number 1, your lordship, in this matter, the suit was decreed and a special referee was appointed by your lordship for ascertainment of mean profit. Let the time to file the report by the special referee be extended, your lordship.
Report filed?
No, your lordship is.
Who is the special officer?
Mr. Banerjee, Shuddhashatya Banerjee is for the special referee. But he was not unwell for a long, he was not well for a long time.
So the matter is listed today has to be mentioned for filing report by the referee or the special officer?
Lordship, special referee.
By the special referee, but the learned counsel for the plaintiff submitted that the special referee is for time to file a report according case adjourned. Let the matter appear on 2nd September 2026 for filing report.
Lordship, I think by that time also it will not be
Why?
completed because the defendant and respondent rather has not filed his statement of defense.
29 September 29 September.
29 September.
Yes, call the list.
I had almost finished my submissions that day, just 5 minutes. I showed to your lordship, my lord, how this writ petition was not maintainable. Besides taking the point of it being a private bank, a case in respect thereof was also cited by my learned junior. But the main points which we made was, here is a writ petitioner who knew everything, but has not been able to do a single thing within the time prescribed. My lord, he did not file his expression of interest in time. He could not file the documents required within time. He could not file even the hard copies of the documents in time. And yet, my lord, he requests your lordship, my lord, to pass an order in his favor. A very important point in my very humble and respectful submission, which I had taken before my lord was, my lord, so far as the Swiss method is concerned, your lordship was told on the last day, there is session 1 and session 2, or stage 1 and stage 2. Stage 1 is over. A person has been declared to be the highest bidder. He will participate in stage 2. My learned friend, my lord, has filed a supplementary affidavit pointing out that how during the pendency of this writ petition, we are proceeding with the preparations and carrying out of the procedure under stage 2. That is not the subject matter of this application. And in any event, today, a valuable right has accrued in favor of the person who's the highest bidder in stage 1. That person has not been made a party. No notice has been given to that person. And today, if an order is passed by your lordship, and I say this with deepest respect, it will be putting to naught, my lord, the entire processes which have taken place and placing a whole lot of people, about 10 in number, who have participated in stage A, done each and every action in time within the prescribed format, and then will be just thrown out because, my lord, a person who has not been vigilant enough, my lord, did not take his steps in time, and now approaches your lordship to set the whole clock back. Okay. That, my lord, is not permissible or acceptable in law. Just 2 more cases I want to cite. I won't cite, I promise your lordship, my lord, the entire cases, just 2 or 3 sentences. 1984-4 Supreme Court cases, 1984-4 Supreme Court cases, page 251. Prabodh Verma, State of Uttar Pradesh. I will not place the entire judgment. Straight away come to paragraph 28. These are principles which are well known to your lordship, but my lord, since litigants come to reiterate something which is not possible, my lord, we have no other option, my lord, but to place the relevant thing. Paragraph 28. The real question before us, therefore, is the correctness of the decision of the High Court in the Sung case. Before we address ourselves to this question, we would like to point out that the writ petition filed by the Sung suffered from 2 serious, though not incurable defects. The first defect was that of non-joinder of necessary parties. The only respondents to the Sung's petition were the state of Uttar Pradesh and its concerned officers. Those who were vitally concerned, namely the reserve pool teachers, in this case, my lord, people who have participated in grade A, were not made parties. And even by joining some of them in a representative capacity, considering that their number was too large for all of them to be joined individually as respondents, the matter therefore came to be decided in their absence. Well, the next line in my humble submission is very important. A High Court ought not to decide a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, or at least by some of them being before it as respondents in a representative capacity if their number is too large. And therefore, the Allahabad High Court ought not to have proceeded to hear and dispose of the writ petition without insisting upon the reserve pool teachers being made respondents to that writ petition, or at least some of them. I need not place the rest. My lord, I have been repeatedly making this point before your lordship with great humility. People have participated within time, within the framework of law, so far as stage 1 of the Swiss procedure was concerned. Today, to suddenly come forward, taking advantage of your own wrong and saying that the results should be overturned and that I am guilty of certain laches which I am not, in my very humble and respectful submission, my lord, cannot be permitted. Kindly see just 1 more paragraph, my lord. It repeats the same thing, but to summarize our conclusions, paragraph 50. A High Court ought not to hear and dispose of a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, or at least some of them being before it as respondents in a representative capacity, if their number is too large to join them as respondents individually. And if the petitioners refuse to so join them, the High Court ought to dismiss the petition for non-joinder of necessary parties. Kindly come to 5.5. Though a High Court ought not to dismiss a writ petition on a mere technicality or because a proper relief has not been asked for, it should not, therefore, condone every kind of laxity, particularly where the petitioner is represented by an advocate. Well, there has been, my lord, laches on his part. He says, give me names, give me this detail, that detail. And my lord was pleased to observe that day, but why did you give those details? Does this not amount to condonation of the delay on their part? With respect, no. I did not want to shut them out. I'm giving them every opportunity to participate. But if in spite of that, they delay, and in spite of that, my lord, they do not participate. Your lordship remembers the case which was cited by my learned junior on the last occasion. Yeah. A person who has not participated, my lord, in the tender process.
Not.
ought not to be heard at all. My lord, the next case, which 2018, 8 Supreme Court cases, 243, National Highways Authority. Kindly come to paragraph 20. While considering the relief claimed by the respondent claimant, the same should have been tested in the touchstone of the principle governing the lender process, the tender process, especially when the validity of the tender document has not been put in issue or challenged before any competent forum. Here, my lord, the validity has not been challenged. Going by the terms and conditions in the tender documents, as already alluded to in paragraph 10 above, there is no title of doubt that the right of the claimant to match the bid of L1 or to exercise ROFR would come into play only if the respondent was to participate in the tender process pursuant to the notice inviting tenders from the interested parties. The objective of tender process is not only to adhere to a transparent mechanism, but to encourage competition and give equal opportunity to all tenders with the end result of getting a fair offer or value for money. The plain wording of the eligibility clause is in the tender documents, and the incidental stipulations make it explicit that the respondent was required to participate in the tender process by submitting its sealed bid, technical and financial. The fact that a deeming clause has been provided in the tender document that if the respondent was to participate in the bidding process, it shall be deemed to fulfill all the requirements of tender clauses so-and-so, being the existing concessionaire of the project, does not exempt the respondent from participating in the tender process. Rather, the tenor of the terms of the documents made it obligatory for the respondent to participate in the tender process to be considered as a responsive bidder, along with others. Having failed to participate in the tender process, and more so despite the express term in the tender documents, validity whereof has not been challenged, the respondent cannot be heard to contend that it had acquired any right whatsoever. Only the entities who participated in the tender process pursuant to tender notice can be allowed to make grievances about the non-fulfillment or breach of any of the terms and conditions of the tender documents. The respondent who chose to stay away from the tender process cannot be heard to whittle down in any manner the rights of the eligible bidders, my lord, something which I've been laying stress on, who had participated in the tender process on the basis of the written and express terms and conditions. At the culmination of the tender process, if the respondent had not participated in law, the offer submitted by the eligible bidders is required to be considered on the basis of the stated terms and conditions. Thus, if the claim of the respondent was to be strictly adjudged on the basis of the terms and conditions specified in the subject tender document, the respondent has no case whatsoever. He must at least, my lord, do things in time. And when I have been cooperating with him at every stage, I cannot unilaterally extend the time, especially for him. And in my deepest and most humble submissions, my lord, this honorable court never comes to the aid of such recalcitrant.
Yes.
My lord, the next case, this was cited on the last day, Federal Bank versus Sagar Thomas and others.
Yeah, that is
paragraph 33. I'm not placing that all over again. Paragraph. My lord, kindly take 2008 volume 9 Supreme Court cases 299. Kindly come to paragraph 11. 299. It may be well noted that the auction sale was done after adequate publicity in well-known newspapers. Hence, if anyone wanted to make a bid in the auction, he would have participated in the said auction and made his bid. Moreover, even after the auction, the sale was confirmed by the High Court only on 30th July 2003, and any objection to the sale could have been filed prior to that date. However, in our opinion, entertaining objections after the sale is confirmed should not ordinarily be allowed, except on very limited grounds like fraud. Here there is no allegation of fraud. Otherwise, no auction sale will ever be complete. It is not in dispute that the auction was an open auction after wide publicity in well-known newspapers. Hence, there was nothing to prevent so-and-so to have participated in the auction, but they did not do so. There is no allegation of fraud either in this case. Hence, in our opinion, there was no justification to set aside the confirmation of sale.
Yes.
My lord, I need not place the rest of the paragraphs. These are the basic principles which I'm trying to point out. Oh, sorry. My lord, paragraph 28, my learned junior points out. It's marked, but I forgot.
Yes.
It is held that every confirmed sale can be set aside. The result would be that no auction sale will ever be complete, because always somebody can come after the auction or its confirmation offering a higher amount. It could have been a different matter if the auction had been held without adequate publicity in well-known newspapers, having wide circulation. But where the auction sale was done after wide publicity, then setting aside the sale after its confirmation will create huge problems. When an auction sale is advertised in well-known newspapers having wide circulation, all eligible persons can come and bid for the same, and they are themselves to be blamed if they do not come forward to bid at the time of the auction. They cannot ordinarily later on be allowed, after the bidding or confirmation is over, to offer or finalize a higher price. Of course, the situation may be different if an auction sale is rupees 10 crores. In this situation, it is possible to infer that there was some fraud. Well, here there is no such allegation. But the basic idea is, when you know, paragraph 6 onwards are placed in the petition, when you know what is happening, where it is happening, how it is supposed to happen, you do not pull your socks up. Thereafter, you make requests to us one after the other. Give me this, give me that. And I do that. And still you do not put in even your soft copies within time, your hard copies within time. Nothing is done within time. And now the easiest way for him is perhaps to approach this honorable court.
Okay.
I respectfully submit, my lord, this should not be permitted. My lord, one last case before I conclude. 2005, volume 6, Supreme Court cases, 657. Paragraph Well, the discussion is elaborate. If my lord so desires, my lord will go through it, but I just place the conclusion, paragraph 32. Applying these principles, it can very well be said that a writ of mandamus can be issued against a private body which is not a state within the meaning of Article 12 of the Constitution, and such body is amenable to the jurisdiction under Article 26 of the Constitution, and the High Court under Article 26 of the Constitution can exercise judicial review of the action challenged by a party. But there must be a public law element, and it cannot be exercised to enforce purely private contracts entered into between the parties. And my lord, there are other cases on this. Today, my lord, it is not as if any public action is being challenged before your lordship.
Yes.
He says, I want to take part in Swiss stage A, Swiss method stage B. I have not done it within time. In the meantime, my lords, stage 1 is complete. Today, it cannot be said that the clock can be turned back because so many rights have accrued in so many people's favors. And I dare say, my lord, with the deepest of respect, your lordship will kindly not allow that, because it will put to an end the sanctity of contract and the sanctity of relationship, my lord, that exists by and between the bank and its borrowers. My lord, those are my respectful submissions.
But I first deal with the point of accrual of right and non-joinder of necessary parties. Lord, if your lordships kindly take page 96 once, volume 1. No, volume 2, sorry. Lord, this is the bid document. First page is 95. Your lordships kindly come to page 96.
Yes.
There is a heading called disclaimer. Has your lordship found that? Kindly, my lord, come to the second paragraph. The purpose of this bid document, has your lordship got? The purpose of this bid document is to seek suitable bids from and to provide certain information to UI participants as defined hereinafter for participating in the base bid process for the purposes of identification of the base bidder. It is clarified that the base bidder will be required to participate in the subsequent auction process as defined hereinafter, and the base bid process itself does not create any right whatsoever in favor of base bidder UI participants to acquire the loan assets. The bank has the right to modify or cancel or withdraw or suspend, this is second sentence, the other sentence, temporarily, permanently the base bid process with or without assigning any reason, without any liability at any stage, including after receipt of the selection bids.
Yes.
As defined hereafter, or finalize of the base bid, as the case may be. The bank also reserves the right to not proceed with or modify or cancel or withdraw or suspend temporarily, permanently the auction process with or without assigning any reason or without any liability whatsoever. So, my lord, first thing is the disclaimer document, which is part of the bid document, clearly says that the base bidder does not acquire any right. This is number one. So, if not the base bidder has not acquired any right, Lord, there is no question of any
Making a party.
making him a party. Number two. Number three is that we do not know who is the base bidder. Even Lord, in any of these documents, the correspondence, etc., the name of the base bidder has not been disclosed. So, Lord, how do we know who is the base bidder? Even if we were compelled, Lord, under law to make him a party, Lord, we would require the name of the base bidder, which we don't have. So, Lord, my first submission is that, Lord, there is no requirement of anybody being added as a party other than the parties that we have already, Lord, included, because, Lord, there is no accrued right in favor of the base bidder in terms of the documents, bid document itself. Now, Lord, kindly come to page 97. The second last paragraph. The information contained in this bid document, the timeline suggested for the process or any other information which may be provided to UI participants during the base bid process is subject to change without prior notice. The bank may, in its absolute discretion, but without being under any obligation to do so, update, amend or supplement the information contained herein, including the envisaged base bid process mentioned here. So, Lord, timeline is not, Lord, a fixed timeline. It is flexible timeline. Now, with this, Lord, my submission is there has been no accrual of right. Therefore, Lord, question of adding anybody would not arise. Now, Lord, I come to the issue of that it was our own default by reason whereof the timeline prolonged. And, Lord, the documents which we were supposed to upload, we did not upload. Now, Lord, your lordships have seen page 102, which is the timeline. Your lordship has already seen this. I have shown it. My learned friend has also shown it. Now, your lordships may kindly come to page 105. Clause 4. It says submission of UI, NDA and other supporting documents. Has your lordship found that? Any eligible bidder interested in participating in the base bid process must submit the UI in the format attached as Annexure 1 hereto, along with the below mentioned documents, information by the UI due date. Any document information, the formats of which are provided in this bid document, must be submitted in that format only, unless otherwise approved by the bank at its sole discretion. Now, what are the documents, Lord, which I have to submit? One is board resolution and power of attorney in the format. This I have submitted. Then authorization letter in the format which I have submitted. Details of documents to be provided in UI as detailed in Annexure 7 hereto, that has been provided. D says any additional document information sought by the bank must be furnished by the UI participant. So, Lord, this is an obligation that after scrutiny, if the bank wants further document, that I have to submit. But the fixed documents are A, B and C. And E says a NDA in a format as provided in Annexure 2 here. So, my lord,
What is the NDA?
Non-disclosure agreement, because my lord, confidentiality.
Yes, etc.
Now, my lord, all the documents that are required under A, B, C, and E are given. D is the power of the bank to ask for further documents which are not provided in either A, B, C, or E. Now, my lord, your lordships may kindly come to page 149. 149.
Yes.
Lord, this is, Lord, submission of the bid by us on 24th June 2026 at 5:19. Now, Lord, if your lordships kindly see page 102. 102, Lord, does not specify any timeline for this 24th June. Your lordships will kindly see the table. The only timeline that is given in this table is in 8. Your lordships will find it says Thursday by 6 p.m.
Correct.
Apart from this, there are no timelines given. But Lord, when they advertised, they said that you have to submit it by 5 p.m. In the advertisement, it is there, 5 p.m. Now, Lord, this is 5:19 when these documents are submitted. Right? Now, Lord, kindly come to page 175. Kindly, Lord, see the bank's reaction to the submission. This is on 29 June. Lord, we submitted on
24.
24. On 29th, after 5 days, the bank says, please note that UI board resolution of NDA were received post deadline provided in the bid document, that is 24th June 2026. In light of the same, we regret to inform you that we shall not be moving ahead with your submission. So, a rejection. Then, Lord, we reply at page 176. Kindly see, Lord, our reply. We would like to respectfully clarify that the required documents, namely UI, board resolution, and NDA, were submitted via email on 24th June 2026, which was within the stipulated deadline mentioned in the bid document. The hard copies of these documents were delivered subsequently, and the delay pertains only to their physical receipt. Since the soft copies were submitted within the prescribed timeline, we kindly request you to consider our submission as compliant with the bid documents. Then he said, we would be grateful if you could review our submissions accordingly and reconsider your decision. Now, Lord, kindly come to page 177. Lord, the bank says at the top, request you to share email dated 24th June 2026. The bank might have misplaced it. So they said, please share this email. Now, Lord, that letter which is at the bottom was just a reminder which was sent at 3:46, and this reply came at 3:48. Your lordships will find that at the top, Lord, the timing is mentioned.
Yes.
After the date, the timing is mentioned. At 3:48, this reply came, supply the attachment. Now, Lord, please come to page 179. As requested, we send the attachment. As requested in the trailing email, please find attached a copy of the email dated 24th June 2026 along with a screenshot of the email to support our submission in soft copies. In light of the above, it is requested that our bid application be considered as that of an eligible bidder. This we do on the 30th June. This is on the very next day. 29th at 3:48, they say we send it on the next day. Now, Lord, your lordships may kindly come to page 181. This is, Lord, the 1st July letter. The bank, Lord, accepts our bid. They say, noted in the attached UI, the bank account details are not specified. Request you to rectify the same at the earliest. Lord, they wanted to know whether, Lord, we have any account with them. Yes, bank. Now, Lord, your lordships will find the answer. This is, Lord, 1st July at 10:29. This is 181. Please see 182. 1st July at 11:39. Within an hour, it says, with reference to your observation, we like to clarify that our company does not have any direct or indirect relationship with Yes Bank Limited. Accordingly, the relevant declaration in UOI may be read as, we confirm that we are not directly or indirectly related to Yes Bank Limited. This happens on 1st July. Then, Lord, 1st July, the reply goes at 11:39. At 5 o'clock in the evening, we get a letter from the Yes Bank. Says, please find the attached herewith the updated UOI as requested and consider. No, sorry. This we sent. Consider our application as eligible. After we furnish this.
What is the time of this mail?
This your lordship, page 183. 1705. 505. This is not our mail. After we send that, we said that please accept our request, our application as eligible. Then, Lord, kindly see page 184. The next query comes. This is on 2nd July. Lord, on the first day, we were only supposed to give the declaration.
Yes.
Now, once we gave the declaration, then came the next query. Request you to share the audited financials for 23, 24, 25. Lord, this is on 2nd July at 1:21. Then, Lord, 185. Your lordships will find 2nd July at 4:20. May not be a very good time to reply. But Lord, the financials are forwarded. The financials are forwarded.
That to forward the finance.
Audited financials are forwarded. Now, Lord, please come to page 186. Then comes the query, source of fund. These queries are coming in driblets. They did not come together. And this does not, Lord, pertain to the documents which were supposed to submit, which was, Lord, submission of Mr. Bose, that we did not submit our documents. These are relating to the queries that the bank was raising, and they raised the queries one after the other. I can understand, Lord, all these queries raised together, that they did not do. They broke it up in driblets. They kept coming. Maybe, Lord, it was striking them one by one. So, Lord, 2nd July at 4:25, they come, request you to provide your source of funds. This source of funds query is answered on the very same day, page 187. Your lordships will find. Here, Lord, your lordships will kindly see. It says that it's a non-banking finance company. In the first paragraph, your lordships will find that it is a non-banking finance company. And then, Lord, Vardhan Securities, RBI, etc., eligible to submit the bid. It is also part of AlgoQuant Group. Brief profile of AlgoQuant Group. Then the brief profile is given. The proposed acquisition is supported by the AlgoQuant Group along with its promoters, so and so. Now, Lord, after this, on 2nd of July, Lord, what happened was on 3rd July, they had sent us a mail that you provide name of 2 personnel who will have the access to the VDR. Now, Lord, this is at page 188. Now, 188, 189, 190, 191, they are all, Lord, for the purpose of giving access to the VDR. And Lord, what happened was initially we sent 3 names. They said, no, you have to give 2 names, choose out of them, and one was dropped. Ultimately, this happened on 3rd July at 6:20. Subsequently, Lord, on 4th July, a reminder was given that please give us at page 192 IM. 191 is the final, Lord, names which were provided for giving access. For 192 is a reminder. Ultimately, they said that it will be available shortly at page 193, and ultimately, Lord, access was given on 6th of July 2026. Now, Lord,
what is the 192?
192 is
July is the last date of it is your query.
My is saying that reminder.
Okay.
that please give VDR access. And that was on 4th July, 5:09, and 4th July at 6:09, page 193, they said that we will give it shortly.
What is the time of 4th, 193?
193 is page 609, 18.09 at the top, your lordships will find. Sorry, my lord, if the print.
Yes.
Now, lord, this is the factual scenario is.
Discuss our call, access will be available shortly. Yes.
Now, my lord, kindly take the supplementary affidavit once and come to page 6. Lord, kindly come to page 6 of the supplementary. I'm sorry. So sorry.
Yes, yes.
Page 6 of the supplementary affidavit, which is on 25th of July.
Yes.
They say, you have kindly 1, 2, 3, third paragraph, 25th July at 12 o'clock midnight, past 12 o'clock midnight, 0043 AM, says, kindly see the third paragraph. Despite the aforesaid delay in submission, bank at its sole discretion decided to permit Vardhan to participate in the base bid process, subject to compliance with the prescribed documentary requirements to the satisfaction of the bank. Now, my lord, as on 25th July, all the satisfaction were met. Now, my lord, the issue therefore is twofold. Lord, on question of default, my submission is there was no default on the part of the writ petition.
Yes.
Because, Lord, whatever document we were supposed to submit, we had submitted it, and we had submitted it on the 24th of June.
Yes.
And there was no difficulty because they had initially they must have lost that mail. Then, Lord, we forwarded them the mail saying that we have sent the mail. They asked for the copy of the mail. We forwarded them. Based on that, they raised their further queries. Now, my lord, these further queries went up to 2nd of July. Now, this further query that they raised was not our default. It was, Lord, the query that bank wanted to satisfy themselves. Lord, I am not putting any allegation against them, but I am saying that this was not my default. Because Mr. Bose's argument is that it got delayed due to their own default. It was not on my default. Now, my lord, once all the documents were given on 2nd July, we had access on the 6th of July. Now, my lord, if your lordship sees the timetable once again, 7th July was the date fixed for completion of due diligence, 102, page 102. 7th July was the date fixed for due diligence, completion of due diligence, and Lord, 10th July was the date for the purpose of submission of the selection bid for the base price. Now, Lord, what happened is that on 6th July, we got access to the data room. Now, Lord, once we got access to the data room, Lord, we looked into the data. Then on 10th, Lord, we raised certain queries, the 10th of July. Your lordships will find that at page 196. Sorry. 196, kindly come to. Lord, 196 on 10th July, the further data was uploaded in the data room. Has your lordship, is your lordship looking at page 196?
Yes.
Now, page 196, your lordships will find that on 10th of July, the bank note uploaded further data. Uploaded further data. Now, Lord, once these further data was uploaded, Lord, we raised certain queries, which is at page 197.
196, this is a uploaded document.
Yes, bank's document. This is bank's document. This is further data was uploaded. They had, Lord, updated the data on 10th of July.
Yes.
Now, Lord, after this, on 10th July itself, we raised certain queries. Now, this query was all pertaining to their loan, the assets, the recovery process, number of litigations pending. Your lordships will find a list of queries which were raised on 10th of July. Kindly see D, litigation and regulatory matters, settlement and borrowers discussion. Each heading, these queries were raised. Till date, this query has not been replied.
No, so as per page 102.
Yes.
102, this compliance of due diligence is to be completed by 7th of July.
7th of July.
Correct.
Now, 6th July, we
given you access to VDR. Correct.
Now, if your lordship sees the original.
And on that day, you have made a representation. You made on 9th of July, you have requested for
extension time. Yes.
Correct. Because it would not be complete.
Yes. But after that prayer, on 10th July, they updated the data further. And on updation of the data, we made this request on the 10th July to also furnish these particulars. Now, 10th July was the last date for submission of the bid. We could not have submitted the bid because our due diligence was not complete. If your lordship looks at the original timeline, from 25th June to 7th July,
correct,
it was 12-13 days. That was the normal time that they had allowed. But if we had got the access on 6th of July and we had complained that we want further time, I could have understood. But the point in issue is that we never got the access before 6th of July. And between 6th and 10th, we had just 4 days to complete the due diligence and also to submit the bid. And due diligence was not complete because we raised those queries that never came back. So this is the scenario in which we could not submit our bid on 10th of July. Now, our contention is that the timeline which was given from 25th June to 10th July ought to have been extended because that power remained with the bank. I have placed the disclaimer chapter where bank reserves every right. And when the bank finds that the offer is just 1 lakh more than the reserve price, that I have already argued 245 crores, the base offerer has given only 1 lakh more than that.
Yes.
Bank should have extended the time, should have accepted and bank has power, that power should have been exercised. I am saying that this is arbitrary, violation of Article 14, because they are not giving the same level playing field to all the persons who are coming. This is complete violation of Article 14. Level playing field was not extended. And I am I am also taking the point that there was an interim order restraining the bank from conducting the sale between 8th of July 2026 till 23rd July 2026. So, as on 10th July 2026, bank could have easily extended that time. The bank was prohibited from going ahead with the sale. Bank could have easily done it. So, my main plank of attack is, we didn't get the proper level playing field for the putting in the offer. Judgment deal করতে হবে সরি ছটফট করছিস
So what time you got the access?
I got the access on 6th of July. I'll just give your lordship the date. Time. No, no, the time. 197, I think. No, sorry.
197 is your query.
No. The time, exact time.
Because 4th they have stated you will receive shortly.
Yes.
Page 193.
Correct. 194.
194 received access on
This is where we acknowledge that we got access on 6th of July.
6th of July.
And they say that Saturday, Sunday was non-working day, 4th and 5th.
Correct.
Therefore, no, their case is that we got at 1 p.m. 195. Kindly see page 195. It was at 1 p.m. Your lordships will find that 1, 2, 3, 4th paragraph. 6 July, we got the access at 1 p.m.
6 July 1. So 6 July 1 p.m. you got, but you have not made any representation for 6 to 9.
6 to 9th, Lord, we did not make any representation. Your lordship is right.
Because page 94 is the first request on 9th July.
The prayer for extension, I'll let you kindly.
That is the 9th July.
9th of July, yes.
9th July.
9th July, we asked for extension. Because 10th July was the last date for submission.
Correct.
Last date for submission of the offer was 10th July. So, Lord, 9th July, we said, please extend the time because of these factors, we have not been able to complete the due diligence.
And 10th July, they had uploaded the document.
10th July, fresh information was uploaded. That's on 10th of July at 12 a.m. Midnight.
12 a.m.
12 a.m.
By that time, your submission of the bid is over.
Submission bid was over. Submission bid time for bid was over. 102.
Friday, midnight. 12 a.m. means night.
Night. 12 a.m. means night. That means it is actually early morning.
1200 hours.
No, it was 10th July 2026 at 12 a.m.
12
That
a.m.
means it must be at around early morning.
That's why.
Early morning. Early morning.
Yes.
And Lord, your lordship has seen Lord 106. Lord, they have the power to extend. It's not, and the injunction was operating. Nobody would have Lord raised any voice because the injunction was operating. Now, Lord, the last point is with regard to maintainability.
Where is the reserve the right? 106.
10, yes. 105. 105 is submission of documents. 106 extension. And Lord, even for due diligence, kindly Lord see clause 5, page 106. UI participants, on submitting the signed and duly stamped NDA and other documents as stipulated clause 4 point above and who satisfy the eligibility criteria specified in this bid document and are in compliance with the other provisions of the bid document may be provided with data room access by the bank as per the timeline specified in clause 3 of the document until July 7, 2026 or such other extended date as may be decided by the bank. So, Lord, every sphere bank had authority to extend the time. And this was a flexible timeline, not a rigid timeline.
Yes.
Now,
what is the maintainability?
Yes, on the maintainability. Stress cell is not guided by a statutory provision because Reserve Bank circulars are now declared by the Supreme Court to be read as a statute. Now, if your lordship looks at the guideline ones, that is page 32. Clause 65, page 53.
Page
63. Page 53. Sorry, page 53, clause 65.
Yes.
The lordship has marked it. The statutory guideline or the Reserve Bank guideline, which is a public policy,
yes,
clearly says that adequate time has to be given for due diligence to the prospective acquirers. Now, the test of reasonableness is that whether this has been followed. Now, my lord, my complaint is that when the stress cell is guided by a Reserve Bank guideline, it is, my lord, a public policy. Therefore, my lord, one has to adhere to the public policy by adequately giving the timeline to the acquirer for the purpose of satisfying itself, because it is taking a stress loan, taking over a stress loan. The stress loan is basically the loan which has not been repaid. Bank doesn't want transferring it. Bank doesn't want to take the risk of recovery. So bank is letting it go.
Giving to the third party.
Correct. Now, my lord, whoever third party is going to bid, lord, he has to satisfy himself before he bids that, lord, what is the chance of recovery? The secured assets, unsecured assets, lord, pending litigations, the guarantee given by the directors. There are multifarious aspects which has to be looked into. So, my lord, due diligence is a very, very vital aspect of the matter. And Lord, I had also, Lord, submitted in my opening submission that, Lord, in so far as the base bidder is concerned, the advantage is that the base bidder gets a chance to match. Whereas, Lord, I, as a counter offerer, I will not get a chance to higher my bid once the base bidder meets my price. So, Lord, this is one shortfall for which, Lord, the bank should have given me adequate opportunity to become a base bidder. I lose a substantial right in terms of the scheme. The scheme, Lord, prescribed for this kind of a tender process, and it has a restricted right in so far as the counter offerers are concerned. So, Lord, the first submission is that, Lord, if it is guided by a statutory scheme, and Lord, bank therefore has a public duty to function and discharge in holding the stress sale, and this duty is guided by a statutory framework or a guideline of the Reserve Bank of India. Now, my lord, if your lordship in this context kindly takes the Federal Bank judgment that my learned friend has cited, Lord, I heavily rely on this judgment. Kindly come to paragraph 18 first. Paragraph 18.
Yes.
From the decisions referred to above, the position that emerges is that a writ petition under 226 of the Constitution of India may be maintainable against state government, an authority, statutory body, instrumentality, company which is financed and owned by the state, a private body run substantially on state funding. Then 7, a private body discharging public duty or positive obligation of public nature. And 7, a person or a body under liability to discharge any function under any statute to compel it to perform such statutory function. Now, Lord, today the stress cell, they can't hold contrary to the guidelines, Lord, which is given by the Reserve Bank of India. This is, Lord, the framework under which, Lord, they have to hold the stress cell. Now, Lord, please come to paragraph 33. Yes, Lord. For the discussion held above, in our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligation or such obligations of public nature, casting positive obligation upon it. We don't find such conditions are fulfilled in respect of a private company carrying on a commercial activity or banking. Merely regulatory provisions to ensure that activity carried on by private banks works within a discipline do not confer any such status upon the company nor put any such obligation upon it, which may be enforced through issue of writ of mandamus under Article 226 of the Constitution. Present is a case of disciplinary action being taken against its employee by the appellant bank. The respondent's service with the bank stands terminated. The action of the bank was challenged by the respondent by filing writ petition. The respondent is not trying to enforce any statutory duty on the part of the bank. This is the distinguishing feature. It was a master-servant relationship which was terminated. Therefore, no statutory statutory duty was being enforced against the bank. But Lord, in our case, it is totally different. Lord, in this respect, if your lordships kindly take page 33 once, page 33. Lord, apart from the fact that, kindly see the introduction, apart from the fact that it is issued under section 21 and 35A on the Banking Regulation Act, your lordships will find it clearly says the Reserve Bank being satisfied that it is necessary and expedient in the public interest so to do, hereby issues these directions hereinafter specified. So, my lord, this is a public interest in mind, a public scheme which has been constituted. And bank, lord, will have to follow this guideline when, lord, they are undertaking stress sale. They cannot, lord, deviate from this. And I say that, lord, when they don't give adequate time for the purpose of due diligence, it is in violation of the scheme, which can't be done. Now, Lord, just the other judgments which have been cited, first 84.4 is third-party interest. Here I have shown, Lord, there is no third-party interest. The bank themselves disclaim that there is any third-party interest because they say that no interest is going to be, the interest of the base bidder is not going to be affected. No right accruing to him, right? Now, my lord, the other judgments, one of which is 2018, volume 8, SCC, 243. My learned friend read below paragraph 20.
Yes.
Your lordship's lord kindly sees. This is on the question of failure to participate. Lord, I have not failed to participate. I have participated. My bid was accepted. My entry was accepted. But Lord, I was not allowed to complete the process. I didn't have the adequate time to complete the process. So this is not a case, Lord, where I did not intend to participate. I intended to participate. I asked for extension of time. 6th, I was giving access. 10th was the last date of deposit of my offer. 9th, I said that please extend the time. And this is not an unreasonable request because, Lord, the bid document authorized the bank to do it. And Lord, there was an injunction operating. They could not have completed the bid, Lord, on the 10th or, Lord, according to the schedule. Up to the 23rd of July, they couldn't have. So, Lord, they could have easily extended the time. And this was not done, Lord. It was tailor-made. They were, Lord, trying to, Lord, support the other person who has become the base bidder, whose name is not disclosed. So, Lord, this judgment has no manner of application insofar as we are concerned. The other judgment, Lord, is 2005, volume 6, SCC 657. 2008, 9, the date.
2005, volume 6.
657, that's the last judgment. That's the last judgment cited. What was the paragraph?
They mean 32. They are relied upon 32. State. That is the meaning of state.
But I don't think I should deal with it. I leave it at that. And
that is another is 2008 volume 9.
2008 volume 9. That is, Lord, paragraph 11 and 28. Lord, please come to paragraph 4 first. The facts of the case are Hindustan Nitro Products was put under liquidation and an official liquidator was appointed for it. The assets of the company were proposed to be auctioned and hence the court asked the official liquidator to obtain a valuation report. The official liquidator, after obtaining the valuation report, submitted it to the court. The valuation of these assets, according to the official liquidator, was 2.55 crores. The property was then put up for auction on 25th March 2003 after advertising. It is in various well-known newspapers having wide circulation, including Economic Times, which is well-known newspaper having wide circulation in the business community. Several bids were received and were opened in the court. The highest bid was of that the appellant, Valji, Khimji and Company amounting to 3.51 crores with the consent of the learned advocates representing the secured creditor. This bid was accepted and sale was confirmed. Lord, this really, Lord, takes the judgment totally out of context so far as our facts are concerned. In our case, Lord, there is no question of any finality so far as the sale is concerned.
Yes. Anything further?
Lord, I don't think, Lord, there is any further I can add. Lord, my contention is that, Lord, I should be given a chance to be to participate and become a base bidder. And Lord, there is no impediment that in doing that because of the, Lord, terms and conditions of it. And Lord, I am also seeking a direction upon the Yes Bank to, Lord, give answer to the queries, Lord, which are still lying with them. Kindly have a look at my prayers in the writ petition. Starts at page 27. Lord, I'd asked for H, but here, Lord, your lordships may kindly prayer D, prayer A, G.
Pass and cancel and declare the void invitation. Declare void the invitation expression of.
No, Lord, C, if your lordship takes pair C, the privatory order, no further steps to be taken. And Lord, the second stage notice came, Lord, while the writ petition was pending before your lordship. Therefore, Lord, we have included that in the supplementary affidavit, paragraph 14, if your lordships kindly take it. Auction notice is dated 30th July 2026, paragraph 14, and auction notice is, Lord, document is annexed.
When is the auction? When is the auction?
The auction is, Lord, on the 4th of tomorrow for the purpose of submission of expression of interest, 5 p.m.
Tomorrow 5 p.m. Where is that?
My Lord, kindly.
Yes, got it. Page 8. Just a second.
Brief reply, my lord, to
What reply?
Can't be a reply.
My lord, lot has been said, my lord.
Only you give the answer.
Yes, my lord.
To kindly come to page 196.
My lord.
So you are uploaded the document on 10th.
I'll answer, my lord. What this document is. My lord, several queries were being raised even after the deadline of 6th of July.
Correct.
This is not a, my lord, uploading of a document, my lord. This is not uploading of fresh terms or fresh documents. The queries which were being sent by the intending participants, those queries were being responded to. That is a response to the query, because the virtual data room, my lord, what happens? All the relevant documents, it's like a vault which contains all the relevant documents necessary for participating in the bid. The documents are there. All the intending bidders, based on those documents, were generating queries, like my learned friend did after at around 4:46. That is after the bid process had ended, which is why it was not responded to, could not be responded to. Because at 12, the bid process came to an end. The query from my learned friend's clients came, if my lord sees the very next page, the time, it is around 4:46.
Which one?
At page 197, if my lord takes.
What is the time?
Page 1997.
197, what is the time?
4:42.
On the right hand side at 16:42.
1642.
This is, my lord, after the bid has been opened.
Correct.
And my lord, page 196, this is prior to the bid being opened. Certain queries
That's
were
why,
being, yes,
that's why
my
I'm
lord.
telling. Yep. Now then, if it is your answer, then you come to the page 102.
My lord.
Page 102, as per your document, the total is to be completed by 6 because 7th is the completion date of diligence.
My lord.
7th is to be completed. So
My lord.
after the 7th, you cannot give any document, you give not anything. So
No,
how you then
it is, my lord, not giving of documents. Documents I cannot.
whatever it may be. So 7th is the last date.
My lord, like we had entertained them and all their questions, we had entertained all the participants because I cannot be giving them a special treatment and denying a similar treatment to the other participants.
I am not on that.
My lord,
if your schedule, the court will go by your schedule.
My lord.
Correct. So your submission of query is the 6th of July 2026.
My lord.
But in the case of the petitioner, the 6th of July, you have given the access to the petitioner to the VDR.
My lord.
That is not denied. That is
not denied. I give the reasons why so.
Yes, you have given the reason. So that will court will consider. And the completion is on 7th of June.
There is completion of due diligence.
Have given the date of time of completion on 7th of July. So after 7th of July, there is no, you cannot give any document, you cannot give any reply. So 7th is totally completed. Whatever they have given the diligence, what you have inspected, that is over.
My lord.
Then the 10th is the opening. They have to submit their EOI.
My lord.
Correct. So if you have given on 10th of this 197, so how you can justify this?
My lord, the night before that they have not, they have only annexed, my lord, page 196 that there is something uploaded. What has not been annexed is what had been uploaded.
I have it with
A day before, a query was made because, my lord, we have been entertaining queries all throughout till the submission of the bid.
Correct.
It was not like, my lord, they will be shunned out. Nobody was intended to be shunned out.
Correct.
Till the date of submitting of the bid, that is 10th of July, till the submission of the bid, we have responded to all questions that were put to us. Like we have responded to their email of 9th July. Likewise, my lord, different queries were being made in the virtual data room. So that, my lord, none of the participants are put off or because they require some clarity to put in their bid so that we do not shun them out.
Correct.
For transparency, my lord, we entertained every query
Correct.
till we had opened the bid.
When the bid was open?
12. Page 102, my lord, will see the time is 12. If my learned friend's client, 102, my lord, will see, my lord was indicating.
No, when your bid was open?
My lord, the timeline is given there on 102.
Given.
On 10th 12.
10th July 2020.
10th July 12. The injunction order which my lord learned friends have referred to, I'll take my lord to that injunction order what is there. My lord learned friend submitted that the injunction restrained the bank.
So that's why when the EOI was open.
10th, exactly at the time.
Which time?
12 p.m.
12 p.m.
My lord.
12 p.m. The EOI was open.
It was open and the query which is being generated by the respondent is generated at 4.
Open on 12th of July at 12 p.m.
On 10th July. 10th July 12 p.m.
12 p.m. So how you can upload the document at 12 a.m.?
96. It is my lord. It becomes 12 a.m. at midnight. It will become 12 a.m.
Correct.
Till 11:59. It was 11th of 9.
So that's why again I have thrice I ask you what time you have opened the EOI.
EOI, not the EOI, my lord. The EOI was on 24th of June. 10th of June, 12 p.m.
Only come to 105. Submission of the selection bid of EMD and EOI participant. 10th July.
Yes, at 12 p.m. We have opened the bid at 12 p.m.
12 p.m.
My lord. That is in the afternoon.
12 p.m.
My lord.
Then when the selection was made.
That is when the selection was made. 12 p.m.
12 p.m.
My lord.
So if the selection is made, why this document has been uploaded at 12 a.m. in the night?
12
p.m. means in the afternoon.
Yes.
As my knowledge is.
12 a.m.
As 12 a.m. is the night, midnight.
Right,
After the
right,
midnight.
right. It is the midnight of 9th of July till 11:59 p.m., my lord.
How it can be, sir? It is a computer generated.
Yes, my lord, till 11.
It is not handwritten. It is a computer generated.
Lord.
Computer generated says 12 a.m. means the 12th of the 10th of night.
No, no, my lord, 10th night, 12 at 12 a.m. it is 11 July. Till 11:59, it is 10th of July. 11:59 p.m. is 11th of July, 10th of July. At 12 midnight, at the strike of midnight, it is AM, my lord. 12 midnight is not referred to as PM, it is referred to as AM. So it is the night of midnight of 9th of July.
Okay, night, okay, 9th midnight or early morning of the 10th July you uploaded.
Yes, my lord,
Correct.
because the night before.
Correct.
My lord.
And you open the bid on 12th.
Yes, at 12,
At
exactly the scheduled time.
Exactly. It is possible for the bidder to go through the document.
It's not no, it's a, my lord, it's, my lord, a bidder specific. It is an independent query made by one of the intending participants.
But my learned friend should check the VDL. This is all documents which have been uploaded. Size of the documents are 28 MB, 677 MB. Kind of
one bidder, one of the intending bidder raises a query. Based on his query, my lord, there were 10, 11 interested participants. They have all been submitting their queries from time to time, and the bank has been responding to all the queries from time to time, even after the 6th of July. The intent being all the participants should have all that they require to answer, to participate. The last, it is, my lord, different participants raising independent queries. It is not a collective query.
But if your lordship kindly permits.
So an independent, my lord.
See, either you go by your timeline fixed under the tender notice,
My lord.
or if you are extended, you have to communicate this. The court has to see with regard to because if you are strict on the timeline, then you have to follow the timeline. If you're not if you are telling that you have given the benefit to all and extended the time for verification with document, so why if it is so?
My lord.
Correct. If it is so, so as per your timeline, page 102,
my lord,
the last document is to be submitted by 25th of June. Bank may provide access to the data on 25th of June.
Yes.
Correct. So you have to provide data on 25th of June.
May provide. The language is may provide.
Correct. 25th of June. And
My lord.
last submission of the query is the 6th of July.
My lord.
And completion of due diligence, that is on your part.
No, on their part as well.
Okay, as well. So 7th of July. So 25th of June till 6th of July, what is the time period?
My lord, about 10 days.
10 days. So, but admittedly, the petitioner has got access to the VDR on 6th of July. So, if you are telling that the opportunity is given to all equally,
My
if
lord.
the petitioner has got the access on 6th of July 2026, correct, at 12 noon, no?
1 noon. 1 noon.
1 p.m. So, if 12 on 6, so he will get only 1 day.
1 day's time.
Correct. 1 day. And you making a submission that page 196 is provided to all. So either you have to follow with regard to your guidelines if you are extending the time. So what is the problem for extending the time, giving the reply to the petitioner to the queries 1 day or 2 days?
My lord, the queries, my lord, allow me 2 minutes. That original timeline, the timeline which is prescribed is 24th June, submissions have to be made. 5 p.m., my lord will find that requirement at page 94, that the submissions were to be made within 5 p.m.
Correct.
They send their hard copies on 26th of June.
Where from you got?
Page 94, if my lord is pleased to take up page 94. This is my publication, and my publication forms part of my tender bid document. If my lord is pleased to take up page 94, P5,
Yes.
my lord will see in the middle, the first paragraph after the table, 3 lines from the
5
bottom,
p.m. 5 p.m. and 20.
and before 5 p.m.
Correct.
So that was the deadline which was given. The email admittedly came at 5:19. Hard
That you
copies
condone.
admittedly came at 26th of
That
June.
you condone in terms
On
of that.
29th, we rejected their submission. They made a subsequent request, kindly allow me to participate. The first round of email, my lord will see, and I will show my lord, because one of their submission is, I am not required to give my financials. They have showed, my lord, some of the clauses, and I'll show one more clause which required them to give the financials on their own. The first submission they make is, I am asked that my form is not correct the form and give it to me. My lord, giving it in an incomplete form is not attributable.
Don't repeat.
Correct.
That Mr. Bose.
If my lord come clause F,
This court is only on the ground on putting the question to you. You satisfied this court. This last date of submission queries is 7th of July 2026.
My lord.
And submission of the bid on 10th of July 2026.
My lord.
You, the petitioner, has been given access on 6th of July 2026. Subsequently, the petitioner has made a several correspondence. You have replied to that. You have not strictly cancelled the request of the petitioner. You have given the all reply to the petitioner. Petitioner be allowed to participate. No problem at all. So if it has come on 7th, it is completed with regard to the completion of all due diligence. So why you have uploaded on 10th of July?
What we have uploaded is response to a query made by one of the bidders.
So query has completed by 7th. So why you have again you have uploaded on 10th? If it is uploaded on 10th on all persons, the all persons have got 10 days further. Why this petition will not get further 2 days?
No, 10 days further, my lord.
Because 25th of June to 25th of June to 6th of July, all persons who got the time.
Yes.
But this petition has given access on 6th of July. That is not the case, but I am telling you. And 7th of July is the last date. And 7th is last date. Why you have uploaded the further document on 10th of July?
Because some clarifications were required by the participants.
That's why.
Relaxation.
So if we are giving the clarification to this other party, so why these persons one day you are not given the reply?
They are not, madam. They sought for the clarification after the bid is opened.
Hearing concluded.
My lord, just one thing, if I may show clause F, my lord, the financials, which had been, my lord, just one page. One page, my lord, they had shown some clauses. This clause was not shown. Page 124, clause F. Because they have contended the delay was occasioned because we were asking for documents which they were not required to provide.
Yes, 124.
Clause F, if my lord sees. If I may place it, along with our EOI, this is their undertaking which they are giving. We have also enclosed information documents as required in the EOI invitation to demonstrate that the financial capacity and relevant requirement matters as set out in the EOI invitation, such and such. So they were, my lord, required.
That's why their query has not been completed. How the EOI they did not get the chance to submit the EOI.
The first stage, my lord, is they have to give their financial capacity.
When?
This is, my lord, a part of the.
Tell me when.
My lord, this is submitted with the expression of interest at the time of expression of interest.
Interest will
24th of June.
20.
This has to be given on the 20th, and they have given it on the 24th of June at 5:19.
Correct.
Without these documents.
Correct. But you have condoned that. You have not stated because of this you are cancelling it.
No, we allowed them time to bring those documents on record.
And now you can raise this question.
No, I'm not saying that, my lord. I'm just responding to their submission where they had submitted that bank kept on asking for certain informations
Correct.
which they were initially under the terms of the EOI not required to disclose.
Correct.
Therefore, the bank was seeking additional information. As a counter to that, my lord, I am submitting that this requirement of giving financial capacity, that they had the financial capacity to undertake a transaction of 245 crores upfront, they had it. Because the
That is secondary issue. Your rejection is not with regard to the financial capacity.
No, we have not rejected. They have not submitted the bid.
That's why.
My lord, we have not rejected anything.
That's why that stage has not come. The stage is that they have not completed the VDR verification. That's why they have given the query to you, not given the answer, and you have selected one of the person as the L1.
But a query, my lord, will only see the time query after opening of bid.
Again and again, I am putting the one question. You are again the bouncing to me.
The documents, as I have already.
That's why the court is specifically putting the question to you. You, as per your tender notice, 7th July is the total date of completion of making the queries. Queries. If the 7th is totally making the queries, so what prompted the bank to disclose further document on 10th of July?
My lord, from my instructions are from 6th till the 10th. Every day,
so if
every query has been responded to.
Okay, then if you are allowing the persons from 6th to 10th,
Right.
why the 2 days has not been given to the
My lord,
petitioner? The petitioner
they are not
is
asking
being
for-
given the access only 6th of
My lord,
July.
they were not asking for response to a query. They were asking for extension of time to alter the bidding date. Query, my lord, would stand on a separate footing.
Okay.
My lord,
And
one sentence, kindly. Thereafter, no more. He will not speak anymore. I will not speak anymore. But let us suppose, for the sake of argument, my lord, what has fallen from my lord is right. They were not given the time. Our answer to that is, we responded to their queries so that they could participate if they wanted to.
Correct.
They chose not to participate in the manner it should have been done, within the time it should have been done, within the day it should have been done. 9th was the day, my lord, when they could have acted. They did not, they waited for another day. And then, my lord, the basic submission, very respectfully, which I made before your lordship, let us suppose the bank was totally in the wrong by giving them those information. If we had not given those information, the question would have been, you have shut us out. You have not given recourse to natural justice. But what about those people who have participated in accordance with the law, a decision taken, and today you will set the clock back without notice to them? They may have so many things to tell your lordship. Your lordship never passes any order which is without notice to the other side. So today, especially in writ petitions of this kind, when valuable rights have accrued in favor of other people, forget this, the highest bidder, all the other 10 bidders who participated. How is this petition, my lord, maintainable in the absence of them? So today, even if my lord is pleased to set the clock back and say that whatever the bank done is wrong, what will be achieved in the process?
No,
my lord, this
with regard to the process, because you have also not disclosed. You have also not disclosed he is the bidder. And where is the list you have not disclosed? You are arguing 2 days.
We haven't
Bank
filed
has
any
argued 2 days, you are not disclosed. The petitioner cannot say, yes, you cannot blame the petitioner, first thing. Second thing, with regard to accrued of interest does not arise because your conditions also there, your conditions says,
Disclaimer.
93.
96. That is the reason, right? They are agitating.
My lord, the Swiss method, my lord, there is no accrual of rights. In the first stage, there will be no accrual of
96,
rights.
the disclaimer. Can you see the disclaimer? I think bank has not shown to you.
My lord, I'm sorry I had to go away because another matter was going on.
Your Lordship, may I just point out that time was fixed for me at 3:45. I beg your pardon, Your Lordship, for interrupting this way.
You are so junior, seniors are in front of you.
The purpose of this bid document is to seek suitable bids from and to provide certain information to the expression of interest. Participants for participating in the base bid process for the purposes of identification of the base bidder. It is clarified that the base bidder will be required to participate in the subsequent auction process, and the base bid process itself does not create any right whatsoever in favor of the base bidder, participants to acquire the loan asset. The bank has the right to modify or cancel or withdraw or suspend temporarily the base bid process with or without assigning any reason and without any liability. The bank has not done anything till now.
Yes.
It is
The judge is on, no right will be acquired by the base bidder. Now
no
that
right will be acquired with the base bid. I believe
Yes.
that is what is troubling.
Yes.
precisely, that is the precise
Well,
violation
that
of
is
right they are
the-
agitating.
That is the violation that they are talking about. That is what they.
No,
that
if
is what
it
they
is,
say.
if in the disclaimer, if you are telling that the base builder has not acquired the right, so now you cannot, how you can argue that yes,
And why have they come to court?
right
My
has
lord, I
accrued.
asked this question to myself.
They have come to the, they have not challenged the subsequent event. They have
can't
challenged
do that.
that he have not given the proper time giving the answer so that he can go for the further course of action.
My lord, he had everything at his disposal in the beginning. For some internal reason, which I do not know and I don't want to know, my lord, he could not respond in time. He writes to me and says that, give me this information, give me that information. I made the mistake, if I may use that word, my lord, of giving him that.
Naturally.
But does it take away, my lord, the rights of the bidders who are already in line? And today, if my lord is pleased to allow his application, the entire process will be put to naught without giving a hearing to anybody concerned. And there is no infraction on the part of the bank, just because the bank was.
That is the mistake done by the bank. Time and again giving the opportunity to the once you stated in the mail that they are not going to entertain the request of the petitioner, then again you condone. That's why yesterday I also put a question.
Yes, you put it.
Once the bank has condone all the things, can you raise that plea at this stage?
My lord, let us assume, my lord, that the bank has condoned it. But does it give him the power or, my lord, the leeway to do something which is not right? And will your lordship, my lord, be party to that?
Let me consider that.
That is
that
the
question.
The question is, will my lord be a party to it? That is the most important question.
My lord
Will
can
my
never
lord
be a party to
it?
anything.
Because after all, my lord is going to decide.
That's why, Tony, let me decide. Let me
Yes,
decide.
of course, your lordship will decide.
And tomorrow,
Today, my lord, he cannot turn back and say, just because the bank gave him all the information and he couldn't supply all the information within time, my lord, he gets an automatic right, my lord, for an order in terms of his petition. That is the base order being.
Thank you. Thank you. Kal ke order, huh?
Would my lord like a written note?
Tomorrow is the last. When tomorrow is the 5 p.m. You say you will not open. Then you can give tomorrow. Then I will deliver the judgment after 2 days. If you continue with the schedule, then tomorrow I will deliver the judgment at 3 p.m.
I don't think a written note is required. My lord, I don't think my lord has heard us extensively. We are very grateful to.
No, if you wanted to give the note,
no.
Because tomorrow is the 5 p.m. is the time is fixed.
They can give their expression of intent in the meantime.
In the meantime, if they give their expression,
Of course, abide by the outcome of the bid.
Second
stage.
Well, kindly also keep in mind that they are not stopped from participating in the second stage.
That I taken note of. That I taken note.
So that is always open to them. So at this stage, my lord, to go back when the second stage is under process, some people will be stuck where they were at level 0 and other people will reach grade 2. That can't be done, my lord, in my very humble.
If the level playing field is not equally extended, bound to happen.
It has not. It has not.
Okay.
He's the only person who asked for the extension. He got what he wanted. Still, he could not.
And the only person who.
Well, I leave it to my lord.
Okay, let me consider.
For your lordship.
Your lordship, I had assignment at 3:45. Your lordship fixed my matter at 3:45. Your lordship, this was a writ petition filed by me, and your lordship had on the last occasion instructed Prasar Bharati and MSTC to come back with instruction. Your lordship.
Yes.
And they were supposed to return today, Your Lordship, with instructions from the clients as to what.
He might be on Air India, Akashwani. You are Prasar Bharati?
Yes, I have asked the representative to be there. My instructions are, I have to submit that after the bid, after the inspection, the fire broke out. And after the fire broke out, I have not communicated by letter. But I'm told that verbally I have informed. What my lord now is that there's a entire list of what is remaining in go down 2. And also they have their auction list. So my lord, we are willing if they can come for a joint inspection and
After a lapse of 3 years, Your Lordship.
make a list of what is there and what they can pick up. Accordingly, we can adjust.
Good option. Go for the inspection.
Your Lordship, may I just place this? I have made a bidding and I am out 70 lakhs and above.
Correct.
To the tune of 70 lakhs and above. They gave me an inspection and they are now claiming that they have verbally informed me, Your Lordship. What is the proof of that?
What she is
They take
telling?
money from me after, Your Lordship, you know, the amount that they are saying that I can claim, that they'll refund is to the tune of 20,000.
What she is telling that she had the instruction that both the party make joint inspection if and what the materials you have lifted, what the materials was there in terms of the list at the time of auction, it will considered. But if it is not there, they will.
Your Lordship, the godown had caught fire, Your Lordship. They did not allow. And Your Lordship, the report that they have filed before Your Lordship, Your Lordship can kindly take a look at the report that they have filed without my knowledge also, without my information. I had no idea that they had filed this
Madam,
report,
you
Your
are
Lordship.
again going to the British time, then it is very difficult. She is telling that new inspection will be carried out. Inspection will be carried out. What are the materials lying in the godown at present? Secondly, what are the materials you already shifted that will be?
Your Lordship, these are all. Your Lordship, these are godowns with scraps. These are scrap materials, Your Lordship, that had caught fire.
So list will be there.
Yes,
There will be a list.
Auction list is there.
Auction list will be there. For identification of the materials, the material list would be there.
Your Lordship makes this part heard, Your Lordship, because Your Lordship's determination will change and this will again go before some other court. This will go before some other court and then I'll have to start this matter all over again before another. Your Lordship makes it part heard. Makes it part heard, Your Lordship. This is prejudice to my rights. On the last occasion, they were supposed to come back and give a report to Your Lordship as to what is the instruction.
Madam, like you, if all the advocates will telling like this, parted, then my determination will. If my determination will change also, I will remain in group 9.
Your Lordship has heard this matter at length, Your Lordship, threadbare. Your Lordship had heard it, Your Lordship.
Okay, let it be matter. Remain in the list. Let come. I will hear thee. No problem. I will hear. Yes.
Gives a short date, Your Lordship. Kindly fixes a short date.
My lord will pass a short order.
To do inspection, inspection has to be person who is appointed by the court.
Your Lordship, come and take the inspection along with the
matter is specially fixed to get.
To be appointed. No, I want a court officer to be appointed.
At
To be in the
45
presence of the
PM,
court
but
officer.
due to paucity of time, the matter could not be taken up everything. Learned counsel for the respondent.
Your Lordship appoints a court officer for the sake of inspection, Your Lordship, in the presence.
The respondents are ready to carry inspection in presence of the petitioner and to make inventory by telling the list of the materials which was lying in the said godown prior to the fire incident and on the basis of which the petitioner has participated in the tender. Consider the submission made by the counsel for the respondent. Let the matter appear.
Your Lordship.
Let the matter appear on 12th August. Under the heading
12th August.
urgent.
Yes, Your Lordship. Agreeable.
Joint inspection given.
Come on, that they will decide.
No problem, Your Lordship.
This is the first SIR, Madam Milord, of an advocate of this court which your Lordship was pleased to take up on the 17th of April, Milord, suggesting the tribunal to expedite the hearing. Milord, the tribunal, unfortunately, Milord, despite your Lordship's direction of 17th, has not been able to persuaded to take it up. Now, my lord, the gentleman concerned, my lord, he is likely to go for, my lord, Hajj visit. Now, my lord, I was only busy. The matter has been mentioned. Your lordship has been kind enough to keep it, my lord, on the 26th of March 2027. Now, my lord, what I was humbly
March 27.
Yes. That is the instruction I am saying. Now, my lord, I was only humbly beseeching your lordship. It will not take beyond 3 minutes, my lord, by the clock. My lord, any day at 1 p.m., 1:15, whenever it suits your lordship, my lord, may it kindly be placed in the list for 3-4 minutes.
When he is going to on Hajj?
My lord, the tickets cannot be purchased, my lord, without the.
No, that will be a schedule. No?
Well, there's a 10th of August.
How the court pass also, how we will get
My lord,
that?
yes, my lord, the relevant permissions and everything, my lord, will be expedited. My lord, if it can be, my lord, any day, I just, my lord, he's an advocate. It's not a professional thing.
But my appellate side.
My lord, appellate side, my lord, someone is here. My lord.
Come tomorrow. Come tomorrow morning. No, no.
My lord, I'm handing it over to them. My lord, if they can.
Give
My lord, any day convenient.
Yes.
My lord, your lordship will keep it, my lord, any day.
Item number 4 was fixed at 3 p.m. My lord, your lordship fixes it at any
You
time.
do one thing. I will make an application.
My lord, I'm
I
sorry.
will make an application. This court may be given the what?
My lord, I was just telling my learned senior that this court should become part-heard determination. Because all the part-heard.
What is happening? বন্ধ করে সব কিছু বন্ধ করে
এই বন্ধ নেই।
last day, my lord, this closed.
No, the live streaming.
And in Bengali, they are just saying.